Fresh matter. Put it.
May I seek liberty to mention, my lord. One matter, my lord, habeas corpus matter, my lord, that girl, victim girl, my lord. We trace that girl, my lord. We are bringing at 2:30, my lord.
Ah.
No, my lord. Serial number 10. It will be listed on Monday, Lord. So, senior argument.
Orders.
Argument ready. There is 25 date. 25th on date. Serial number 10.
Who is on the Mr. Ravi?
Ravi, on behalf of Ravi B. Patel.
Mr. Sangan Basu Patil. Please wait.
Please.
Yes.
Serial number 25, my lord. Kindly week's time, my lord. I already informed, my lord.
Only if the other side is here, you can.
The other side is there.
Otherwise, you can mention.
Either 27th it is.
20.
27th.
Serial number 25.
25, my lord.
My lord, 48, my lord. Next week.
At the request of learned counsel for the appellant, release this matter.
27th, Lord. 27th.
On 27th of November.
There is interim order.
Interim order granted earlier stands extended till the next date of it. Yes.
48, my lord. Next week.
Who is on the other side?
I'm appearing for respondent, my lord.
48. Please. You are for Mr. Mantesh Patel.
Please, I'm appearing for respondent. Please, please, my lord.
You have no objection.
No, my lord.
Serial number 48. At the request of learned counsel, Shri
SV Deshmukh.
S.V. Deshmukh.
Yes, ma'am.
Release this matter
Next to any date, my lord.
on 28th of November.
Please.
Your Lordship,
Yes.
serial number 18. I'm proxy counsel at 18. Proxy counsel requested to list in the next week.
Unless the other side is here, say no
Government is-
objection.
government
not
is-
adjourn.
Government is there.
Which one?
18.
18.
ಬೇರೆ ಇದಾರಮ್ಮ ಬೇರೆಯವರೆಲ್ಲ ಇದ್ದಾರೆ. Let us see. Yes.
Non-compliance of office objections for first time, CL number 1, Rupasagar Patil.
2 weeks. For the appellant for compliance of office objections.
CL number 2, Veerangoda Mali Patil.
Fourth time ಬರ್ತದಿಲ್ರಿ.
Before this,
Finally 2 weeks.
CL number 3, AGA.
Praise, my lord. 2 weeks time, my lord, finally. 3, 4 and 6.
Weeks. 3,
4 and 6, man.
6.
Please.
CL number 5, Sangan
Week's time granted, my lord. Week's time granted.
Finally a week's time. Yes.
CL number 7, VK Nayak. For fourth time,
2 weeks for complaints of office objections.
orders. CL number 8, Sivanand Patil. Non-filing
Yes.
of petition.
10 days, my lords, finally. Paper book is ought to be filed. 10 days finally, my lords.
Finally 2 weeks are granted at the request of learned counsel for the appellant for furnishing paper book.
CL number 9, Sanjeev Kumar C. Patil.
Order. Matter is of the year 2020. Steps have not been taken for service of notice in respect of respond number 3. Note respond number 3 are private party.
General Secretary, AEC. Three, four. 1, 2, 3.
ಚೆಕ್ ಮಾಡ್ಬಿಡಿ ಯಾರು ನೋಡಿ ಇಲ್ಲಿ ನಂಬರ್ ತಪ್ಪಾಗಿದ್ರು ಅಲ್ಲಿ ನೋಟಿಸ್ ಲಾಸ್ಟ್ ಯಾರು ಕಳ್ಸಿರೋದು ಈ ಸಜ್ಜನ ಸರ್ವಾಗಿದೆಯಾ ಅದೇನಾ ಉಪೇಂದ್ರ So finally, 2 weeks time is granted to the appellant to take steps for service of notice on respond number 3, failing which the appeal will be dismissed as against respond number 3.
CL number 10, Sangan Baswa B Patil.
10, my lord, on behalf of Ravi B Patil, kindly be Monday, lords. Kindly Monday on behalf of Ravi B Patil.
At the request of learned counsel for the respondent. Matter
25th,
on 25th of November.
please. Much.
CL number 11, Veerangoda Mani Patil.
Appearing for the appellant. In the connected matter, the office objection have been overruled and the interim order has been granted.
ಕೊಡಿ. So similar orders as in 202721 of 2020. Same orders. ಇದು learned government advocate takes notice for respond number 2. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on the learned government advocate.
CL number 2, Mahantesh Patil. CL number 12,
But in this matter, my lord, we comply the direction of the learned single judge. Lord, kind sir, I filed the affidavit, my lord, on 2/7/2024. Annexure R3 is the endorsement is issued, my lord. Lord, order passed by the learned single judge, my lord, page number 18. But 17 is the relevant parameter. There is a direction to file the fresh representation, my lord. He is not given the representation fresh. Then, my lord, he filed the, my lord, contempt before the Salon Court, my lord, annexure D. That is, my lord, page number 25.
You utilized the property of the petitioner.
Not utilized, my lord. That's why, my lord, endorsement is annexure R7, that is R3, my lord.
ಏನಂತ?
Page number 6, my lord.
Yes.
Third para, my lord. I read. ಸದರಿ ರಸ್ತೆಯ ಪ್ರಸ್ತುತ ಗ್ರಾಮೀಣ ರಸ್ತೆಯಿಂದ ಸರ್ಕಾರ ಆದೇಶದನ್ವಯ ಜಿಲ್ಲಾ ಮುಖ್ಯ ರಸ್ತೆಗೆ ಮೇಲ್ದರ್ಜೆಗೇರಿಸಿ ಪ್ರಸ್ತುತ ಇರುವ ರಸ್ತೆಯಾದ ಯಾಪಲ್ ದಿನ್ನಿ ಡೊಂಗ ರಾಂಪುರ್ ರಸ್ತೆ ಮಾರ್ಗ 10 ಕಿಲೋಮೀಟರ್ ರಸ್ತೆಯನ್ನು ಸುಧಾರಣಾ ಅಭಿವೃದ್ಧಿ ಕಾಮಗಾರಿಯನ್ನು ಕೈಗೊಳ್ಳಲಾಗಿದ್ದು ಸರಿಯಷ್ಟೇ. ನಿಗದಿಪಡಿಸಿದ ಅಗಲಗಿಂತ ಕಡಿಮೆ ಅಗಲ ಅಂದರೆ 7.5 ಮೀಟರ್ ಅಗಲಕ್ಕೆ ಜನಪ್ರತಿನಿಧಿಗಳ ಸಾರ್ವಜನಿಕರ ಮತ್ತು ವಾಹನಗಳ ಸುಗಮ ಸಂಚಾರಕ್ಕಾಗಿ ಸುಧಾರಣಾ ಕಾಮಗಾರಿ ಕೈಗೊಳ್ಳಲಾಗಿದೆ. ಆದರೆ ಯಾವುದೇ ರೀತಿಯ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿರುವುದಿಲ್ಲ. ಗ್ರಾಮೀಣ ರಸ್ತೆ ಒಟ್ಟು ಅಗಲ 12 ಮೀಟರ್ ಮತ್ತು ಜಿಲ್ಲಾ ಮುಖ್ಯ ರಸ್ತೆ ಒಟ್ಟು 25 ಮೀಟರ್ ನಿರ್ದಿಷ್ಟಪಡಿಸಿದೆ. ಆದರೆ ಯಾವುದೇ ಪರಿಹಾರ ಮತ್ತು ನಷ್ಟವನ್ನು ಭರಿಸಲು ಸರ್ಕಾರದಿಂದ ಯಾವುದೇ ಅವಕಾಶಗಳನ್ನು ಕಲ್ಪಿಸದೇ ಇರುವ ಪ್ರಯುಕ್ತ ತಾವು ಉಲ್ಲೇಖಿತ 3ರಲ್ಲಿ ಪರಿಹಾರ ಧನ ಮತ್ತು ನಷ್ಟ ಭರಿಸಲು ಕೋರಿರುವುದು ಸಮಂಜಸವಿಲ್ಲ ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. You not utilized additional malad.
You are not saying you are not utilized.
But that is
You have said that it is been expanded.
that is not expanded in the sense, my lord, whatever, yes, our, village road, my lord,
Ah.
there will be the 12 feet, my lord, but after encroaching, it will be reduced to the 6 feet.
Huh?
After encroaching the neighbor lands owners, my lord, that will come to the 6 feet. Thereafter, my lord, when we will form the road, my lord, our road, my lord, utilized.
You can proceed, you can demolish the compound and do whatever you want.
Not compound, my lord, not compound here. Only, my lord, our road, my lord, we utilize, that's all. Whatever 12 feet are there, my lord, that road we developed, that's all.
We are not going to accept this.
But that is the endorsement, my lord.
Yes, yes.
The honorable court, my lord, kindly see, even when he filed the content petition, my lord, before this honorable court, my lord, but annexure kindly see, my lord, that is annexure D. Annexure D, my lord.
Yes.
He filed the contempt earlier, my lord.
Hmm.
This honorable court, my lord, kindly see. He withdrawn that one.
Huh?
He withdrawn that contempt, my lord. Page number 25, learner counsel for the complainant seeks leave to withdraw the contempt petition with liberty to submit a fresh representation to the authorities pursuant to the order dated so and so. Accordingly, contempt petition is disposed of with liberty to. Then, my lord, kindly see next page, my lord. He given the representation on 22/8/2023.
Yes,
Fresh representation.
yes.
But this was, my lord, considered by the, my lord, annexure R3. But here, my lord,
There are two contempts
yes,
that
my
you
lord,
have done.
yes, my lord.
One is violation of the decree passed by the civil court. There is a decree passed against you, restraining you permanently from doing anything. You have violated that order.
But I will read that order of the learned single judgment.
Yes, please read. Please read paragraph number 3.
Para number 3, my lord, please. It is the case of the petitioner that aforesaid land belonging to the petitioner have been utilized by the respondent for purpose of framing a public road. At the stage of laying the road, the petitioner had filed the OS number so and so seeking a decree permanent injunction. And competent civil court has allowed the suit and granted a decree of permanent injunction restraining the respondents and their men from laying the road in the hands of the petitioner. It is the case of the petitioner that in the utter disobedience of the decree passed in OS number so and so, the respondent have utilized the property of the petitioner for the purpose of forming the public road, and appeal filed by the respondents against the decree passed in so and so are also dismissed, and thereby the decree in OS number has attained finality. Yes, ma'am. That's true, my lord. Then, my lord, then it is further case of the
Do it,
petitioner.
sir.
But that
When there is a decree operating against you, how
that
did you proceed?
but that information I will get, my lord. What is they filed the any appeal and stay?
Madidiri, that is also dismissed.
Allah, if it is so, my lord, he has to file the, my lord.
What have you said in your endorsement regarding that?
That one, my lord. Annexure R.
Nothing is there. So a decree of a civil court does not bind you.
No, not. It is binding, my lord, definitely. But I will also private next week, my lord. I will get the instruction from the officer.
Perfect. Learned government has filed an affidavit of the executive engineer, PWD, Raichur division, along with the copy of an endorsement dated 1/7/2024, at annexure R3. Full stop. Next para. We have gone through the endorsement. Full stop. We find that the learned single judge, comma, in the order dated 7th of June 2022, in WP number 200697 of 2022, has noticed the contentions of the petitioner that when the respondents tried to utilize a portion of the property belonging to the petitioner for widening of the road, comma, the petitioner had filed a suit in OS number 256 of 1999, seeking a decree of permanent injunction. Full stop. The suit was allowed and a decree was passed in favor of the petitioner, comma, restraining the respondents from interfering with the peaceful possession of the suit scheduled property. Full stop. It was further noticed that an appeal preferred by the respondents against the judgment and decree was also dismissed. Full stop. Therefore, the decree passed by the civil court had attained finality. Full stop. With these observations, the learned single judge had directed the respondents to consider the representation seeking necessary relief from the respondents for acquisition, payment of compensation and damages in respect of the land utilized by the respondents, without following due process of law. Full stop. That being the case, we are not satisfied with the endorsement given by the executive engineer, who has stated that there existed a panchayat road earlier which measured 7.5 meters in width. Full stop. Therefore, at the request of the general public and as per the directions of the people's representatives, the road was widened to 12 meters. Stop. It is also clear from the endorsement that the respondents admit that the road has been widened and the lands belonging to all the owners of the property adjoining the road have been utilized without payment of compensation. Full stop. Next para. But ನೀವು ಒಂದು ತಪ್ಪು ಮಾಡಿದಿರ ಕಣ್. You have not made the state a party in the writ petition. You have sought directions only to the deputy commissioner and the executive engineer. They don't have power to acquire. It is only the state which has got the power. What is the use of giving representation to the executive engineer? What will he do?
What's the authority for the land which is already utilized?
Sir,
is
we have
by the
understood
department.
everything. Your contention is that it is not acquired. No due process of law is followed and they have utilized the land. You now want the land to be acquired and compensation to be paid. Who is the competent authority?
Well, state is the
Then-
competent authority. What's the
You will have to approach the state only. Neither the deputy commissioner has got that power nor the executive engineer. What can he do? You please tell me. Can he decide compensation to be paid?
what's the proceedings which now under the new act?
We will do one thing. We will give liberty to give a fresh representation to the state government.
State means again I have to give the deputy commissioner notes and the
No, sir, state means not deputy commissioner.
revenue secretary.
No, you have wrongly understood the concept. Deputy
The
commissioner is not the state.
is the only executive authority.
Aste,
ಹೌದು.
the eminent power
Is with the
is only with the state to acquire lands, to issue notification. Thereafter, the executive's action will come into force.
11(1) of the new act, not 2013. 11(1) of the wherein that provision provides for issuance of notification
ಯಾರಿಗೆ?
for the acquisition.
ಯಾರು ಮಾಡೋದು notification?
ಅದರಲ್ಲಿ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಅಂತ ಇರ್ಬೇಕು.
How can it be?
Just I may be not clarified. I am not sure,
ಕೊಡ್ರಿ.
but in some of the cases.
Even para 5,
Eminent domain power lies only with the state, so
Yeah,
it
I
cannot
know.
be deputy commissioner.
or even para 5 of the learned single judge order, my lord, there is a direction to approach to the state only. Kindly, sir, my lord, that the suit can
Para?
to be dismissed. Para 5 of the order, my lord. It is further case of the petitioner that on OS number 2 so and so filed by claiming damages from the respondent and the state suit dismissed on the ground that the petitioner has an alternative remedy against the government to seek
Correct.
compensation.
ಅಲ್ಲಿ ಹೇಳಿದ್ರು ಕೂಡ you have ಏನ್ ಮಾಡೋದು? ಏನ್ ಕಷ್ಟ ಆಗುತ್ತೆ ನಿಮ್ಗೆ ಸ್ಟೇಟ್ಗೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡಕ್ಕೆ?
ಇಲ್ಲ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ ಅದೇನ್
ಮತ್ತೆ?
ಸಮಸ್ಯೆ. But the overall the
All these blunders you have committed.
ಅಲ್ಲ overall the issue would not again remain that
Yes.
since there was
But
an
directions can only be given to the competent authority. What is the use of giving directions to the executive engineer or the deputy commissioner who don't have the power?
the what's once I made a representation to the state, then the
You
other
have to pursue
authorities
that
will
only.
follow.
You'll have to pursue that only. Next para. However,
Last time once this court marks has directed the state to provide any notifications. What they are contending in the endorsement they have given once, last date of hearing.
ಅದ್ ಬಿಡ್ರಿ, we are finding fault. That's all right. This endorsement cannot be accepted. But the question is,
Technically, we are not,
see, courts can issue directions only to a competent authority. If directions are issued to incompetent authority and it doesn't have the power to do it, what can we do? However, we find that the representations are given to the deputy commissioner and the executive engineer of Raichur. Full stop. The learned single judge has noticed in paragraph number 5 of the order that in a second suit filed by the petitioner in OS number 28 of 2011, claiming damages from the respondents, comma, the suit was dismissed on the ground that the petitioner has an alternative remedy against the government to seek compensation and damages. Full stop. Despite such observation, comma, representations are given only to the deputy commissioner and the executive engineer, who do not have the power to consider such representation seeking acquisition of land and for payment of compensation. Stop. Such power of eminent domain to acquire lands by issuing notifications lies only with the state government. Full stop. Next para. In that view of the matter, we closed the contempt petition while granting liberty to the petitioner to give a proper representation to the state government for acquisition of the lands and for payment of compensation and damages. Full stop. Ordered accordingly.
But I will take notice for respond to 1 and 2, my lord.
Ah.
This was not ordered, my lord. I will take notice.
Yes.
CL number 13, Deepak V. Barad.
Yes.
CL number 13, 1-3.
In this matter, my lord, I filed the memo for withdrawal for this reason, my lord.
13, sir, 1.
Sorry, I'm very,
13.
very.
A week's time is granted to the appellant. 2 weeks for furnishing the correct address and to take steps for service of notice on the respondent.
CL number 14, government advocate for withdrawal of appeal.
Here for the appellant, my lord, I filed the memo for withdrawal for this reason, my lord. As per the GO, my lord, we filed the 2 appeals, my lord. By mistake, my lord, this subsequent appeal, my lord, I'm going to withdraw the subsequent appeal. Already filed
Withdrawing
that,
this one.
yes, already filed, my lord, MFA number 201946 of 2023 against the government order, that in persons of the government order.
Learned
But-
government advocate has filed a memo. Dated 6/11/2024, seeking leave of this court to withdraw the appeal on the ground that an appeal has already been filed in LAC number 154 of 2020. And by oversight, this appeal was filed. Stop. Next para. Consequently, the appeal stands dismissed as withdrawn.
Please.
Number 10, Lepa Eru.
Lord, government advocate has to file the report of having served the notice on respondent number 4. Last time, Lord, that 4th respondent has come to me only. Before previous. bench.
Innೊಂದು ಕೇಸಲ್ಲಿ they have got that girl.
Yes,
Yes, I informed to.
30 list.
It will be listed at 2:30. That matter.
I'll check up. I'll check up.
Check up already. ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ that girl has been traced. She'll be
Rachel
brought to the
Miner
court now
Grateful, my
at
lord.
2:30.
I'm grateful.
Please be present at 2:30 ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ.
ನಾನು ಇರ್ತೀನಿ.
Yes. Yes, ಇದ್ರದ್ದೇನು?
In this, my lord, 4th respondent notices were ordered to be served through government advocate. Now government advocate has to file a report for having served on the 4th respondent. In fact, the 4th respondent has come to me before the previous bench. I referred to Mr. Gopal Krishna Yadav. He must have taken the signature.
In service matter.
ಹೌದು, ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್.
You had appeared for the fourth respondent also.
No, no.
Huh?
By mistake, that fourth respondent has come to me to the High Court only. I requested her to meet Mr. Gopal Krishna Yadav before previous bench. Perhaps he must have taken the signature on the report. That is what my submission.
ಏನ್ರಿ ಬಂದಿದ್ರೇನ್ರಿ?
ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು
ಇಲ್ಲ, ಇವ್ರು ಇರ್ಲಿಲ್ಲ ಅವಾಗ. ಗೋಪಾಲ್ ಕೃಷ್ಣ 2 days. My lord may have it after 2 days. ಗೋಪಾಲ್ ಕೃಷ್ಣ
ಹೆಂಗೆ? How do you have that contact number ಅವ್ರದ್ದು?
ಸರ್ಕಾರದ ವಕೀಲರು ಅವ್ರಿಗೆ ಥ್ರೂ ಗವರ್ಮೆಂಟ್ ಇಟ್ ವಾಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಬಿ ಸರ್ವ್ಡ್.
ಗೊತ್ತಾಯ್ತು.
I have served and filed a report. Having served through my lord.
ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್
My
ಫೋನ್
colleague,
ನಂಬರ್ ಇದೆ ಅಂತ ಕೇಳ್ತಾರೆ ಸಾಹೇಬ್. ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫೋನ್ ನಂಬರ್ ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾರೆ.
ಇದರಲ್ಲೇ ಇದೆ, ರೆಕಾರ್ಡ್ ನಲ್ಲೇ ಇದೆ. Her number is there in the my lord records itself. I have produced before the court.
ನೋಡ್ರಿ ಹಂಗಾರ ಫೋನ್ ಮಾಡಿ
ಕೊಡಿ sir.
ಕರ್ಸ್ರಿ.
ಫೋನ್ ನಂಬರ್ ಕೊಡಿ.
ಕೊಡಿ ಅವ್ರಿಗೆ ಫೋನ್ ನಂಬರ್
ಕೊಡ್ತೀನಿ.
The request of learned government advocate release this matter on 27th of November. ಕೊಡಿ ನಂಬರ್ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
CL number 16, Bapu Goda Siddappa.
I am here for the appellant Mr. Siddhi. Week's accommodation for taking the steps in respect of respondent number 2 Mr. I have also filed the application for TI application. The respondents have alienating the Mr. property in the during the pendency of the suit. I have getting the interior benefit of interim order. The copy of the also order has been produced ROR in the mentioned Mr. Siddhi. It is suit for partition separate position. It is plaintiff's appeal. The suit has been dismissed.
Respond number 2.
Yes, ma'am. I take the steps within 2 days, Mr.
Huh?
Within 2 days, I
No, no.
take the steps.
For the appellant submits that you will take steps for service of notice on respond number 2 in a couple of days.
Yes. I sought for the TI, Mr. Siddhi, not alienating the. I filed the application for IN number 2/2000.
Partition suit.
Yes, my suit for partition separate position. Suit has been dismissed, Mr. Siddhi. I am the plaintiff before the trial court that during the pendency of the suit, the TI has been granted till the disposal of the suit, Mr. Siddhi.
Relationship is not disputed.
Not disputed, Mr.
Relationship
not-
is not disputed. Then
But the properties are it is not a joint properties. That reason the court has
self-acquired property.
self-acquired property. The court has been declared. Ma'am. It is ancestral property because on the ground that the father has Mr. the I'll produce the 2 copies Mr. the sale deeds. That is in the respect Mr. the page number 69.
How many suitable properties are there?
And there are the 3
So it is suit is decreed in respect of
suit is dismissed. Mr. The plaintiff's appeal is dismissed.
all the 3.
Yes, Mr.
All the 3 items.
Items. One house property is also there. But I'm not claiming any house property.
It has been disposed of to third parties.
Yes, Mr. They are already there. 4 and 5 is the third person with the Mr. alienating the property. Even though Mr. during the pendency of the appeal is alienating the property to the some other person. Mr. That reason I filed the application for TI. Mr.
You are appearing for whom?
I am appearing for defendant.
The present owners?
Present owner is Sanganabasov B. Patil. Mr.
I am not appearing.
4 and 5.
Niva?
Yes, Mr.
What do you say?
I am the bona
There are
fide
3 items of property
Yes, Mr.
and all of them he has purchased. Yes. All the 3.
One property has been purchased.
1.
Yes.
Only one property.
What about the other 2?
Other properties are in joint in the name of 3 and 4. Mr. The 2 and 3. Mr.
They still have it.
Yes, yes. Then now the respondent number 2 has alienating the properties to the some other person. Mr. That reason now file the Mr.
Direct you not to.
No, I am not responding. Who, my lord?
2 and 3. Mr. 3 is Mr. the
I am appearing for 3, my lord.
3 ಇದಾರಲ್ಲ.
either.
I am appealing for 3.
One of the properties is in your name.
Yes, Mr.
Next date.
During the pendency of the appeal, please do not alienate the suit.
Yes, Mr. That is.
Berkeley. Next para. However, it is hereby directed that the respondents shall not alienate the suitable property during the pendency of this appeal. IA number 1 of 2024 is accordingly disposed.
Two, my lords. TI is applicable IA number 2. IA number, I file withdrawal of that IA number 1, my lords.
Aye.
Yes.
Appeal.
Sir, today. Yes,
Huh?
today, sir.
Please.
Withdraw ಮಾಡ್ಕೊ.
As IA number 1 for withdrawal.
Number 1 of 2024 is also disposed of since the appellant is not pressing
Yes.
IA number. Yes.
Serial number 17, Siddharudha B. Pujari.
Not complied, but in this matter, order passed on 14 July 2023, 9 months is granted them to comply the order. Madam. Even after 1 year, they have not complied. Relevant paragraph at page number 16, my lord. Writ petition was allowed and directed the respondent to conduct the 4D and durasti in respect of survey number 65 situated at Tavargere village. After issuing necessary notice to all stakeholders, demarcate the land and regularize allot to each of the petitioner and thereafter issue form number 10. Till today, even notice also not issued to the petitioners, the complainants. But in this matter, my lord,
Yes.
but in this matter, my lord, durasti has to be, my lord, there is a direction to
Yes.
durasti has to be done.
Yes.
Durasti has to be done, my lord, only ADLR.
Huh?
Durasti, my lord, has to be done by the only ADLR. But ADLR not party before the Honorable Civil Judge. Only, my lord, direct.
So the principal secretary,
Yes, ma'am.
revenue
Yes, ma'am.
cannot issue any direction.
Because, my lord, ADLR is the necessary party. ma'am.
ಗೊತ್ತಾಯ್ತು sir. We have understood.
Yes, ma'am. He can,
Principal secretary is a party to the proceedings. Respond number 1.
please, ma'am. That's why
Directions are given to all the respondents. Isn't it?
respondent authorities, ma'am.
Yes. Then
Now, my lord, we requested the ADLR, Taslar is present before the court. ma'am. He requested the ADLR to make the durasti and all. But that after issuing the notice to the all, my lord, ADLR do it, my lord.
yes,
It will take time, my lord, that's why I will also.
ADLR is present.
Not the Tasildar, man.
Tahsildar.
Only ADLR, he is requested to the ADLR to make the durasti and submit the report to us. Thereafter, my lord, that will be considered. How put the notice? Survey.
Submission, sir. Already ತಹಸೀಲ್ದಾರ್ ಅದು ಇದು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಅಪ್ಡೇಟ್ ಮಾಡಿಬಿಟ್ಟು ADLR ಪುಷಪ್ ಮಾಡಿ
ಯಾವಾಗ?
ಸರ್ 10/10/2020
10/10. ಅವ್ರೇನು ಮಾಡಿಲ್ಲ ಇದುವರೆಗೂ.
ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್. ಎಂಟೈರ್ ಸ್ಟೇಟ್ ಲೆವೆಲ್ ಇದು ಪ್ರೊಸೆಸ್ ನಡೆದಿದೆ ಸರ್. ಬೇಸಿಕಲಿ ಇದು ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಸರ್. ದಟ್
ಅದಲ್ಲ ಇಲ್ಲ. All those contentions can only come from the government. You don't worry about that. You see that the orders are complied. ಅಷ್ಟೇ. So you have returned to the ADLR. ಕೊಡಿ.
Not ADLR, Tasildar, man. He is, yes.
You have returned to the ADLR.
Yes, yes.
ಕೊಡಿ ಅದನ್ನ ಕೊಡಿ.
ಇಲ್ಲಿ letter ಇದೆ. Letter ಕೊಡಿ.
ಇನ್ನೊಂದು ಸಿಟ್ಟಿದೆ. ಇದು ADLR ಬರ್ತಂತದ್ದು.
ಆನ್ಲೈನ್ ಅಂಡ್ ಮ್ಯಾನ್ಯಲ್ ಬೋತ್ ಕಂಪ್ಲೀಟೆಡ್.
ಬರ್ಕೊಳ್ಳಿ. Learned government advocate submit. That the fourth respondent, Tahsildar, Kalaburagi Taluk, is present before the court. And on instructions, it is submitted that the Tahsildar has made a communication to the concerned assistant director or additional director? Additional director of land records. Additional director of land records.
ADLR.
Assistant director.
Kalaburagi on 10/10/2024.
ಈ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಸರ್ವೆ ನಂಬರ್ ಬರೀತಾರೆ.
ಇದರಲ್ಲಿ ಈ ಡೀಟೇಲ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Detail
ಈ ಡೀಟೇಲ್ಸ್ ಅಲ್ಲಿ ಇವರ ಇದ್ರ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿದೀರಾ?
ಸರ್ ಇದ್ರ ಬಗ್ಗೆ 1 to 5 ಪ್ರಪೋಸಲ್ ರೆಡಿ ಮಾಡಿ ಕಳ್ಸಿದೀವಿ ಸರ್.
ಹಾ?
1 to 5 ಫಾರ್ಮ್ 1 to 5 ಸರ್. To ಕೊಡಿ.
ಸರ್ವೆ ನಂಬರ್
Since the Hadbast and Podi is required to be conducted by the ADLR. Full stop. Next para. The concerned ADLR is hereby directed to proceed to conduct the Podi and Durasti in terms of the directions issued by the learned single judge. Learned government advocate is directed to communicate a copy of this order to the concerned ADLR for further action. Full stop. Since notice is required to be issued to the neighboring landowners, and thereafter the Podi and Durasti is required to be conducted, the ADLR is hereby directed to proceed to issue notice to the neighboring landowners and thereafter conduct the Durasti and Podi and submit a copy to this court. Full stop. Next para. Release this matter on 9th of December. Yes.
Serial number 18, Liaquat Fareed Ustad.
It's time for the respondent to.
My lordship, kindly 1 week's time, my lordship.
Huh?
1 week's time, my lordship.
It's, I have filed an affidavit, my lord, see.
Notice yet to be ordered in respect of response number 1 and 2. Yeah, yes, Mr.
It's, I filed an affidavit, my lords.
Ah,
Kindly see, my lords, the direction issued by the learned single judge, my lords, at page 9, my lords, in the content. Fourth para is relevant, my lords. Shri Liaquat Fareed Ustad, learned counsel appearing for petitioners vehemently contended that the representation dated 26 November 2019 has not been considered by the respondent authority. In that view of the matter, without expressing any opinion, this was the direction, my lords. The case of the petitioner before the learned single judge, my lords, there are street hawkers, my lords. Due to them, my lords, they have difficulty to pass through and access to their property, my lords. But they made a representation. Your lordship may kindly see the affidavit, my lords, on 26/8/2024, page 4, my lords, in my affidavit. An endorsement was issued saying that, my lords, there are certain writ petitions pending filed by the street hawkers at page 4, my lords. So endorsement is issued, my lords, the contemplating, my lords, the corporation needs to examine the pending writ petition. Pardon?
paragraph number 4.
Page 4, my lords, it's endorsement, only one para. In my affidavit, my lords, it's not in the
Affidavit of the commissioner.
commissioner, my lords.
City Corporation.
Please, notes. Page 4, 26/8/2024. This is the first endorsement issued, my lords, to.
ಯಾವ್ದ್ರ page 4?
Lords, ಇದು 4 ಪೇಜ್ ಇಂದ ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿ.
New file.
ಯಾವ್ದು?
Page 4.
Pagination ಮಾಡಿಲ್ಲ ಎಲ್ರು page 4 ಅಂತೀರ ನೀವು.
R1A, may I pass?
R1A pagination ಮಾಡ್ರಿ.
Please, I'm sorry.
Ah.
Endorsement, my lords, endorsement contemplates, my lords, there are writ petitions pending filed by the street hawkers and the corporation, my lords, needs to examine. Kindly turn to next page, my lords.
What merely because there is a writ petition pending? Can they be permitted to occupy the footpath and encroach upon footpath?
Kindly see next page, my lords. Now the decision is taken by the corporation, my lords, in second para, contemplating that, my lords, in that street, my lords, the corporation has identified the place, my lords, which is dedicated to the street hawkers, that is to
Annexure R2B.
R2B, my
Ah.
lords. Second para.
Ah.
ಮುಂದುವರೆದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠದಲ್ಲಿ ದಾಖಲಾದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೊ ಅಂಡ್ ಸೋ ಬೀದಿ ವ್ಯಾಪಾರಸ್ಥರ ಸಂಘ ಇವರು ದಾಖಲಿಸಿದ ಪ್ರಕರಣಗಳನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿರುತ್ತವೆ. ಸದರಿ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾರಾಟ ವಲಯಗಳನ್ನು ಗುರುತಿಸುವ ಕುರಿತು ಈ ಕಾರ್ಯಾಲಯದ ದಿನಾಂಕ 9/9/24 ಬೀದಿ ಬದಿ ವ್ಯಾಪಾರಿಗಳ ಬೆಂಬಲ ಕಾರ್ಯಕ್ರಮ ಅಡಿ ಅಧ್ಯಕ್ಷರು ಪಟ್ಟಣ ಮಾರಾಟ ಸಮಿತಿ ಅವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಜರುಗಿದ ಪಟ್ಟಣ ಮಾರಾಟ ಸಮಿತಿ ಸಭಾ ನಡುವಳಿಗಳಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ಸಂಖ್ಯೆ WP ಸೊ ಆದೇಶಗಳನ್ವಯ CTS ವಾರ್ಡ್ ನಂಬರ್ 3 ಮಹಾನಗರ ಪಾಲಿಕೆ ವಾರ್ಡ್ ನಂಬರ್ 13 CTS ನಂಬರ್ ಸೊ ಆಸ್ತಿಯ ಮಾಲೀಕತ್ವದ ಆಸ್ತಿಗಳ ಮಾಲೀಕರಿಗೆ ದೈನಂದಿನ ಸಂಚಾರಕ್ಕೆ ತೊಂದರೆ ಆಗುತ್ತಿರುವುದರಿಂದ ಸದರಿ ರಸ್ತೆಯ ಜಾಗದಲ್ಲಿ ಬೀದಿ ಬದಿ ವ್ಯಾಪಾರಿಗಳ ಕುಳಿತುಕೊಳ್ಳುತ್ತಿರುವುದನ್ನು ತೆರವುಗೊಳಿಸಲು ತಿಳಿಸಿದ್ದರಿಂದ ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ಒಂದು ಬದಿಗೆ ಮಾತ್ರ 4 ರಿಂದ 6ರಂತೆ ಅಳತೆ ಮಾಡಿ ನಿಯಮಾನುಸಾರ ಗುರುತಿಸಿ ಚೀಟಿ ಮತ್ತು ವ್ಯಾಪಾರ ಪ್ರಮಾಣ ಪತ್ರ ಹೊಂದಿದ ಬೀದಿ ಬದಿ ವ್ಯಾಪಾರಗಳಿಗೆ ಮಾತ್ರ ಕುಳಿತುಕೊಳ್ಳಲು ಅವಕಾಶ ಮಾಡಿಕೊಡಲು ತೀರ್ಮಾನಿಸಲಾಗಿದೆ. ಉಳಿದಂತಹ ವ್ಯಾಪಾರಿಗಳ ತೆರವುಗೊಳಿಸಿ ಸದರಿ ರಸ್ತೆಯ ಮಾರಾಟ ನಿರ್ಬಂಧಿತ ವಲಯವೆಂದು ಘೋಷಿಸಲಾಗಿರುತ್ತದೆ. ಆದುದರಿಂದ ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈಗಾಗಲೇ ವಿಜಯಪುರ ನಗರ CTS ವಾರ್ಡ್ ನಂಬರ್ 3 ಮಹಾನಗರ ಪಾಲಿಕೆ ವಾರ್ಡ್ ನಂಬರ್ 13 CTS ನಂಬರ್ ಸೊ ಆಸ್ತಿಯ ಮಾಲೀಕತ್ವದ ಆಸ್ತಿಗಳ ಮಾಲೀಕರುಗಳಿಗೆ ದೈನಂದಿನ ಸಂಚಾರಕ್ಕೆ ತೊಂದರೆ ಆಗುತ್ತಿರುವುದರಿಂದ ಸದರಿ ರಸ್ತೆಯ ಜಾಗವು ಪ್ರದೇಶದಲ್ಲಿ ಒಂದು ಬದಿ ಮಾತ್ರ 4-6ರಂತೆ ಅಳತೆ ಮಾಡಿ
Is repeated.
Notes.
What have you done now? Consequent to this.
Notes. Now I am told that, my lords, the places were identified, my lords. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿವಸ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ ಅದೆಲ್ಲ ಸೆಟ್ ರೈಟ್ ಮಾಡಿ. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿವಸ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ.
You can simply go and say there is a direction given by the High Court. We have to do it immediately. Please do it. You put it on the court. Just because they have filed a writ petition, you cannot slow pedal these things. Please do it. We will issue directions.
Please.
Purple. Otherwise, it will be very difficult for you. Unless there are directions from the High Court. It will be very difficult for you to manage all these things to get them.
We filed a report before the Leonard Single Judge, my lords, identifying the properties. Now the street hawkers not want to, my lords, follow the street vending zones report. One or the other way, my lords, they are taking time before the Leonard Single Judge.
I know all these things because I have conducted the public interest litigation in the first court, in the principal bench for more than 5 years. I know what is the difficulty that was faced by the BBMP there. Even last year, this problem was there in respect of that Gandhinagar area.
Gandhinagar.
Similar problem.
There is a specific report, my lords.
Therefore,
we have identified the
directions
properties.
issued by the court, it will be difficult for you. We will pass directions. You please go ahead.
Please.
Purple. Learned Counsel. For the second respondent, Commissioner, City Municipal Corporation, Vijayapura, submits that an affidavit of the Commissioner has been filed on 19/11/2024 along with 2 endorsements issued to the petitioner Full stop. Next para, we have gone through the endorsements. Dated 6/8/2024 and 9/9/2024. Full stop. We find that a decision has been taken by the corporation to ensure that a designated place for street hawkers measuring about 4 into 6 feet at definite intervals in the public street in question will be identified and earmarked full stop. Thereafter, only the persons, only street hawkers who have been given permission will be permitted to do the business at the designated places. Full stop. All other persons who have been squatting on the footpaths will be evicted. Full stop. Next para. Having regard to the decision taken by the commissioner of the corporation and an endorsement being issued on 9/9/2024, we do not see any reason why the decision taken by the corporation is not implemented till date. Full stop. We therefore deem it necessary and thereby direct the second respondent, commissioner of the Vijaypura City Corporation, to proceed and implement the resolution
Please.
and decision taken by the corporation and ensure that all unauthorized persons who are squatting on the public street in question are evicted at the earliest. Full stop. Since the decision was taken even prior to 9/9/2024, we are of the opinion that the process for designation of the area for street hawkers have been done. Full stop. The decision and resolution is therefore required to be implemented at the earliest.
Please.
Full stop. Action taken report shall be submitted before this court by the next date of hearing. Full stop.
May,
Release this matter on 2nd of December 2024.
may I request, notes, the commissioner may be permitted to take the help of the police notes
The
concerned.
commissioner, the jurisdictional police
Please.
are also hereby directed to give all necessary protection
Please.
for implementation of the resolution taken by the corporation. Full stop. A copy of this order shall be served on the learned government advocate and learned counsel for the second respondent, city municipal corporation. Stop. Learned government advocate is directed to communicate to the jurisdictional police the orders passed by this
Please.
court. Yes.
Obliged.
Serial number 19. Arun Margun.
In this matter, my lord, take notice for responder one, my lord. Lord, in persons of the direction, my lord. Sorry, my lord, now only I received this order endorsement. Yes, no copy, my lord.
Bill number 19.
Bharat.
ಇದಲ್ರಿ ಸರ್ ಇದು ಯಾವ್ದು 00. My lord, it is in respect of 20. It is in respect of next matter, my lord, this endorsement.
I'm sorry. Sorry, but in this matter, my lord, Tahsildar is present, my lord. But I praise a week's time, my lord, to take notice for the respondent, my lord, Tahsildar. Responder one, my lord, I will take notice and I will file
Under
the
a
order.
registered sale deed which took place long back, mutation is not affected. By taking undue advantage of, my lord, purchaser name appearing in the ROR, there are sale and, my lord, some bank loan is also raised. Conduct of, my lord, Tahsildar, even after passing speaking order at the hands of this learned single judge, it seems, my lord, abnormal. My father purchased long back and he died also.
In this matter, my lord, I may make submission. My lord. There was the already one mutation entry was there, my lord. There was already there, but he given the application to mutate his name. But we requested him to unless set aside that mutation entry, but we are no power because we cannot cancel that mutation entry also. For that is the reason, my lord, we requested him, but he is not going to file the appeal against the earlier mutation order. Now, my lord, we return letter to the, my lord, we going to issue, my lord, letter to him, my lord, unless set aside.
ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
Vendor ಹೆಸರಲ್ಲಿ. Though he sold property,
Sir, before that, my lord, he is before the court, my lord.
ನನ್ನ ಫಾದರ್ಗೆ ಯಾರು ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ ಅವ್ರ ಹೆಸರಿಗೆ ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್. ಯಾರು ವೆಂಡರ್ ಅವರು ಮಾರಿದವರು. ಹೌ ಕ್ಯಾನ್ ಇಸ್ ನೇಮ್ ಬಿ ಕಂಟಿನ್ಯೂ?
Sale deed dated 15/3/1991.
Yes, ma'am. It is a registered sale deed.
Your father purchased.
Yeah, my father purchased from, my lord, one Madivalappa. His name continued despite, my lord, he parted with the title. Therefore, my father, including my mother, were making continuous representations before the revenue authorities to mutate their name. Pursuant to, my lord, registered sale deed, though the revenue authorities are under statutory obligation to mutate pursuant to registered sale deed. They failed to do so. And my vendor's name continued. My vendors and, my lord, their sons approached civil court and they obtained some collusive decree among them. After having, my lord, sold the said property, even said suit all came to be dismissed for default also. And they, my lord, by assigning, my lord, irrelevant reasons, stating that since name of their sons, sons of my vendor is continued, they cannot mutate the name of my father. That is what all the contentions, my lord, of private respondents was turned down by this honorable court.
But as per the sale deed, my lord, already affected the mutation. This is the record, my lord.
ನನ್ನ ಹೆಸರು ಬಂದ್ರೆ ಸಾಕು, ನನಗೇನ್ ಬೇಕಿಲ್ಲ ಸ್ವಾಮಿ.
This is the mutation. But in the records of right, my lord, that was not affected.
ಜೆ ಫಾರ್ಮ್ ಅವಾಗೆ ಹೋಗಿದೆ ಸ್ವಾಮಿ.
1991 ಇಂದ ನೀವೇನ್ರಿ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
ಅಲ್ಲ ಜೆ ಫಾರ್ಮ್ ಹೋಗಿದೆ. ದೇ ಆರ್ ಅಂಡರ್, ಮೈ ಲಾರ್ಡ್, ಆಬ್ಲಿಗೇಷನ್.
ಜೋರಾಗಿ ಹಾರಾಡ್ತೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ.
What were you doing from 1991?
I don't know. For that, my lord, I have no explanation.
ಮತ್ತೆ
I fairly concede.
ಇವರಿದ್ರ ಅವಾಗ?
ಇವ್ರು ಇದ್ದಿಲ್ಲ.
ಮತ್ತೆ?
My lord, my submission is, my effort is, even after the orders of this honorable court, my lord, how can they keep silence, my lord?
So his name was entered.
Yes, my lord, already
Consequent
entered.
to
His
this.
father name is, my lord,
No,
as per the sale deed, my lord, his name is entered.
Ah.
That is the, my lord, in the year 1991 itself.
Then how it was removed thereafter?
Not removed,
On
my
his
lord,
note.
not
my
removed.
lord.
His name is not entered in the records of right.
ಯಾರ್ದು?
He's the purchaser name.
ಇವಾಗ ಪ್ರೆಸೆಂಟ್ ಆರ್ಟಿಸ್ಟ್ ಯಾರ ಹೆಸರಲ್ಲಿದೆ? ಸೆಲ್ಲರ್ ಹೆಸರು ಯಾರು ಮಾರಿದಾರೆ ಅವ್ರ ಹೆಸರು. ಮತ್ತೆ ಇಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಇವ್ರ ತಂದೆ ಹೆಸರು ಬಂದಿದೆ ಅಂತ ನೀವ್ ಹೇಳ್ತಾ ಇದೀರಾ?
ಅದು ಅದರಲ್ಲಿ mutation ಆಗಿದೆ.
ಕರೆಕ್ಟ್.
But records of right ದಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ.
Why?
That is the reason, my lord, why it is not affected. Manual ಇತ್ತು ಸ್ವಾಮಿ, ಅವಾಗ 1991 ದಲ್ಲಿ manual ಆಗಿದೆ.
ಆಯ್ತು.
Even that time it is not, my lord, affected. Even that time he can question it before the Labour authority or requested them to enter his name.
Hmm.
But that is not done.
Now what is the endorsement that he gave?
no, my lord, no endorsement.
Now,
ಅಂದ್ರೆ ಇದು ಯಾವ್ದೋ ಕಮ್ಯುನಿಕೇಶನ್ ಅಂತ ಹೇಳಿದಾರಲ್ಲ,
ಅದೇ
ಸೆಟ್
ಕೊಟ್ಟಿದ್ದು.
ಅಸೈಡ್ ತಾನೆ?
Yes, my lord.
Huh?
He is citing is because
23/6/2022
yes, my lord, because
communication was given by the Tahsildar.
yes, my lord.
ಏನಂತ?
ಅದು because son's name of vendor is continued in the ROR, therefore they cannot effect mutation in favor of deceased father of petitioner. That is what they say.
Anyway, that communication has been set aside.
Yes, ma'am.
And a direction was issued.
Yes, ma'am.
He is directed to consider the grievance of the petitioners and make entries in accordance with law in terms of the registered sale deed.
Yes.
Inaction ತಗೊಂಡ್ರ ಅದಾದ್ಮೇಲೆ?
That is done already, my lord. That mutation entry is already done in persons of the sale deed.
ಅದಲ್ರಿ, now in terms of the directions issued by the learned single judge,
Yes, my lord.
what action is taken?
Oh, that is, my lord, we return. Letter ಬರ್ದು.
Sir,
In that, there is endorsement is there, my lord. In that one.
ಆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ is set aside.
ಅಲ್ಲ ಇನ್ನೊಂದು ಮತ್ತೆ submission
endorsement
ಹೌದು ಹೌದು. ಅದರಲ್ಲಿ
ಅಂತ.
earlier Tahsildar given that endorsement.
That 23/6/2022.
ಅಲ್ಲ ಮತ್ತೆ subsequently ಮತ್ತೆ endorsement ಕೊಡಿ. ಇದೇನಾ? 30/3/2024.
ಇವ್ರು ಇರ್ಲಿಲ್ವಾ ಅವಾಗ?
ಇವರಲ್ಲ, ಬೇರೆ.
ಬೇರೆಯವ್ರು ಇದ್ರು. ಏನಂತ ಹೇಳ್ತಾರೆ? ಏನಂತ ಹೇಳಿದಾರೆ ಇದ್ರಲ್ಲಿ?
ಅದು ಅನೇಕ ಜನ ಮಾಡ್ಲಿಕ್ಕೆ ಅನೇಕ ಜನ ಕೂಡ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಹಾ?
ಸೆಟ್ ಅಸೈಡ್ ಆದದ್ದು ಒಂದು ಕಾಪಿ ಕೂಡ ಅಂತ ಕೇಳಿದ್ದಾರೆ ಸರ್.
He requested the submit some documents, my lord. Thereafter they gave, given the documents or not.
ಆದ ಕಾರಣ ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ ಸಾಹೇಬರು ನೀಡಿರುವ ತಿದ್ದುಪಡಿ ಅನೆಕ್ಷರ್ ಎ ದಿನಾಂಕ 23/6/2022 ಪ್ರತಿಯೊಂದಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ನಿಮ್ಮ ಅರ್ಜಿಯ ಕುರಿತು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು. ಏನಂದ್ರೆ
Earlier application which is set aside by this
that
court, my
communication
lord,
has been set aside.
along with that documents which was given, my lord, requested because we don't
That
have
is
that
not so.
documents.
That is not so. Please read it.
Lord, we'll WhatsApp next week, my lord, I will file the update and necessary. ಅಲ್ಲ ಇದ್ರೆ ಮೇಲಿನ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖನ ಸಂಬಂಧಿಸಿದಂತೆ ಇಳಂಗೇರಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ನೇದರ ಜಮೀನಿಗೆ ದಿನಾಂಕ 25/1990 ಅಂತಹ ನೋಂದಾಯಿತ ಖರೀದಿ ಪತ್ರ ಪ್ರಕಾರ ಖರೀದಿದಾರರ ಹೆಸರುಗಳನ್ನು ದಾಖಲು ಮಾಡುವ ಅರ್ಜಿ ಕುರಿತು ಸಲ್ಲಿಸಿದ್ದು, ಕಾರಣ ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಸಾಹೇಬರು ನೀಡಿರುವ ತಿದ್ದುಪಡಿ ಅನೆಕ್ಷರ್ ಎ ದಿನಾಂಕ 23/6/2022 ಪ್ರತಿಯೊಂದಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ಕುರಿತು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು.
ಏನಂದ್ರೆ
ಅಂದ್ರೆ earlier document which is submitted, my lord, documents which is submitted,
No.
that
you
we
please
request.
please read it again. If there is something wrong, you please admit.
ನಾನು ಅದನ್ನೇ ಹೇಳಿದೆ.
Don't try to justify.
ಈಗ ನಾವು ಮಲ್ಲೋಡ್
He is asking for copy of a communication dated 23/6/2022, which has already been set aside by the court.
Yes.
Why is he asking for a copy of that? That communication is there with you only.
earlier Tahsildar done mistake, my lord, that now my lord will take care of that, my lord. We also pay out next week, my lord, I will do it.
Immediate ಆಗಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ ಅವ್ರಿಗೆ ಪ್ರೀವಿಯಸ್ ವೆಂಡರ್ ಅವ್ರು ಇದ್ರೆ ಸರಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ, ಇಲ್ಲ ಅವ್ರ ಮಕ್ಕಳಿದ್ರೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ, ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೇಟ್ ಪ್ರಕಾರ ಅವ್ರಿಗೆ ಅವ್ರ ಹೆಸರು ಎಂಟ್ರಿ ಮಾಡಿ.
ಈಗ ಆಲ್ರೆಡಿ ಒಂದು ಮುಟೇಶನ್ ಆಗಿದೆ ಸರ್. ಮಕ್ಕಳಿಗೆ ಹಕ್ಕು ಬಿಟ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ರೀ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ರಿ ಅವ್ರಿಗೆ.
ಎಸಿ ಅವ್ರಿಗೆ ಇದೆ ಸರ್. ಎಸಿ ಸರ್ ಇದೆ ಸರ್. ನಾವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ನನಗೆ ಅಧಿಕಾರ ಇಲ್ಲ ಸರ್. ನಾನು ಕಳಿಸ್ಬಿಟ್ಟು ಇಮಿಡಿಯೇಟ್ ಮಾಡಿಸಿ. ಮುಟೇಶನ್ ಸೆಟಲ್ಮೆಂಟ್
ಯಾವಾಗ ಎಂಟ್ರಿ ಆಗಿದೆ ತೋರಿಸಿ. ಅವ್ರ ಹೆಸರು ಯಾವಾಗ ಎಂಟ್ರಿ ಮಾಡಿದ್ರಿ?
1991 ಮುಟೇಶನ್ ಆಗಿದೆ.
14 ನಲ್ಲಿ ಹಕ್ಕು ಬಿಟ್ಕೊಟ್ಟಿದ್ದಾರೆ.
2014 ಅಲ್ಲಿ ಅವಾಗ ಇವ್ರು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರಾ? ನಿಮ್ಮ ಮ್ಯೂಟೇಶನ್ ಪ್ರಕಾರ ಇವ್ರ ತಂದೆ ಹೆಸರು ಅವಾಗ್ಲೇ ಎಂಟ್ರಿ ಆಗಿತ್ತು ಅಂತ ಹೇಳ್ತೀರಾ?
ಮುಟೇಶನ್ ಅಲ್ಲಿ ಆಗಿದೆ ಸರ್.
ನೀವೇ ತೋರಿಸ್ತಾ ಇದೀರಲ್ಲ ಈಗ.
ಸರ್ ಮುಟೇಶನ್ ಅಲ್ಲಿ ಎಫೆಕ್ಟ್ ಆಗಿದೆ ಸರ್. ಪಾಣಿಯಲ್ಲಿ ಬರ್ದಿರಲಿಲ್ಲ ಸರ್.
ಯಾಕೆ ಬರ್ಲಿಲ್ಲ?
ಹಿಂದೆ ಬರ್ದಿಲ್ಲ ಸರ್. ಹಾಗೆ ಬಿಟ್ಟಿದೆ. ಸಮಸ್ಯೆ ಆಗಿದೆ
ಸರಿ. ಇದೆ ಎಲ್ಲ ಚೆನ್ನಾಗಿ ಗೊತ್ತಾಗುತ್ತೆ ಏನೇನ್ ನಡೆದಿದೆ ಅನ್ಬಿಟ್ಟು. ಈಗ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ, ಯಾರು ಖಾತೆದಾರರು ಇದ್ದಾರೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ, ಕೋರ್ಟ್ ಇಂದ ಈ ತರ ಡೈರೆಕ್ಷನ್ ಬಂದಿದೆ, ಅವರ ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೇಟ್ ಪ್ರಕಾರ ಅವ್ರಿಗೆ ಅವ್ರ ಹೆಸರು ಎಂಟ್ರಿ ಮಾಡಬೇಕು ಅಂತ ಬಂದಿದೆ, ಆದ್ರಿಂದ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೆ ಅಂತ ಹೇಳಿ ಅವ್ರನ್ನ ಕೇಳಿ, ಅವ್ರು ಏನ್ ಹೇಳ್ಬೇಕಿದ್ದಾರೆ ಅದನ್ನ ಕೇಳಿ ಆಮೇಲೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ ಬರ್ಕೊಳ್ಳಿ.
I'll take notice, my lord. He served the, my lord.
Learned government advocate submits. Learned government advocate seeks leave of this court to appear for respond number 1, Tahsildar Muddebihad, who is also present before this court. Full stop. On instructions of the Tahsildar, it is submitted that the officer who was earlier holding the post of the Tahsildar Muddebihad has issued a communication. Yenri adu kodre adu. Communication dated 30/3/2024 calling upon the petitioner to furnish copy of the sale deed dated 25/1991 along with the communication dated 23/6/2022 earlier made by the Tahsildar. Full stop. Next para. We do not see any reason why copy of the communication dated 23/6/2022 is called for from the petitioner. Full stop. That communication, which was impugned before the learned single judge, has been considered and set aside. And thereafter, directions are issued to the Tahsildar, issued to all the respondents, including the Assistant Commissioner Vijayapura and the Tahsildar Muddebihad, to proceed and consider the representations given by the petitioner for entering their names in the land records pursuant to the registered sale deed dated 15/3/1991. Full stop. Next para. We therefore direct the Assistant Commissioner Vijayapura and the Tahsildar Muddebihad proceed to implement the orders passed by the learned single judge. Full stop. For that purpose, notices shall be issued to the previous owner of the property or his legal heirs whose name may have been entered in the land records. Full stop. Necessary orders shall be passed by the Assistant Commissioner to mutate the names of the earlier vendor or his legal heirs, and thereafter proceed to enter the name of the petitioners who are the legal representatives of
One Subhash, my lord, Subhash Gowda Patil,
Subhash Gowda Patil,
the purchaser.
who purchased the property in question under registered sale deed dated 15/3/1991. Full stop. The entire process shall be completed as expeditiously as possible and at any rate within a period of 3 weeks from today. Full stop. Release this matter. On 9th of December.
Lordship is directed, Lord, if we not complied that within that month, liberty may be given to review this.
Huh?
Before that, we'll do it, my lord.
Beda. We are not disposable.
9th of
You
December.
please do it and get it.
Please.
CL number 20, Arun Kumar Amargundappa.
In this matter, my lord, Superintendent of Police is present before Lordship, my lord. He served the notice.
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅವ್ರು ಇದನ್ನ ಕಾಪಿ ಕೊಟ್ಟು ಏನ್ರಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದೀವಿ ಇದ್ರಲ್ಲಿ ಅವ್ರಿಗೆ ಕಾಪಿ ತೋರಿಸ್ಬಿಟ್ಟು ಅವ್ರ ಕಡೆಯಿಂದ ಆರ್ಡರ್ ಮಾಡಿಸ್ಬೇಕಾಗಿರೋದು ಅದನ್ನು ಮಾಡಿಸಿ ಆಮೇಲೆ ಇವ್ರ ಹೆಸರು ಮಾಡಿಸ್ಕೊಡ್ತೀವಿ. ಎಸ್.
But in this matter, my lord, we
20,
complied the,
Arun Kumar Amargundappa.
we complied the direction of the 11th single judge, my lord. Sorry, my lord, now only issued.
ಕಂಪ್ಲೈನ್ಸ್.
Yes, my lord. We,
ಇದು
Rowdy sheet.
Rowdy sheet, my lord.
ರೌಡಿ ಶೀಟ್.
Yes, we issued the, my lord, letter to the, my lord, sub-inspector, my lord, to comply the order passed by the honorable court. Thereafter, my lord, he submitted the, my lord, worthy, but issued the endorsement to the, my lord, complainant. That is also served on the complainant.
Specific direction is, my lord, given to Superintendent of Police to pass appropriate orders on representation in accordance with law.
Yes.
Not aware, my lord, whether SP is.
9/11/2024, my lord, this is the endorsement is issued.
This endorsement is given by,
That there are no criminal cases pending against the petitioner, but based on the ill advice of the people who are inimical towards the petitioner, his name is enlisted in Rowdy sheeter. That was your contention.
yes, ma'am.
Now it is
In
found
fact-
that 2 criminal cases are pending against you.
That is 78, my lord, KP Act.
Huh?
If I am correct, my lord, that is 78 of KP Act.
ಯಾವ್ದ್ರಿ ಇದು 2 ಕೇಸುಗಳು?
Crime number, my lord, 306 of 2017 under section, my lord, 87 KP Act. And another one, my lord, 211 of 2022, that is also KP Act provision.
ಯಾವ್ದು
notice.
ಇಲ್ಲಿ ವರದಿ ಅಂತಿದ್ಯಾ ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಹೌದು, ಅದರಲ್ಲಿ ಇದೆ ನೋಡಿ. I'm sorry, my lord, one copy.
87. 87 ಹೌದು. ಇದು 87 ಎರಡೂನು 87. ಅಡಿಯಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿದ್ದು ಸದರಿ 2 ಪ್ರಕರಣಗಳಲ್ಲಿ ಮತ್ತು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಲ್ಲ ಘನ ನ್ಯಾಯವು ಕ್ರಮವಾಗಿ 300 ಮತ್ತು 200 ದಂಡ ವಿಧಿಸಿ ಶಿಕ್ಷೆ ನೀಡಿರುತ್ತದೆ.
He requested not to close that Rowdy sheeter, my lord. This is the request by the sub-inspector to the, my lord, thereafter, my lord, endorsement came to be issued.
Where is the consideration in accordance with law?
But that is the, my lord,
What criminal case is pending?
9/11/2024, my lord.
Huh?
9/11/2024, my lord, if it is there, my lord.
ಹೌದ್ರಿ, ಅದ್ರ ಹಿಂಭಾಗದಲ್ಲಿ ವರದಿ ಅಂತ ಇದೆ ನೋಡಿ.
ಅದೇ ಅದೇ ಇಂಬರ, ಇಂಬರ ಅಂತ. ಈ ಇಂಬರದ ಮೂಲಕ,
ಹಾ,
ಈ ಇಂಬರದ ಮೂಲಕ
ಹ್ಮ್.
ನಿಮಗೆ ಪಡಿಸೋದೇನೆಂದ್ರೆ, ನೀವು ಈ ಹಿಂದೆ ದಿನಾಂಕ 10/1/2024 ನಿಮ್ಮ ವಿರುದ್ಧ ಅಫ್ಜಲ್ಪುರ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಅದಿದೆಯಾ? ಅಲ್ಲಲ್ಲ, ಒಂದು ನಿಮಿಷ. ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಮೇಲೆ
ಎಸ್, 2 ಗುನ್ನೆಗಳು ದಾಖಲಾಗಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ 2 ಗುನ್ನೆಗಳಲ್ಲಿ ದಂಡ ವಿಧಿಸಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ಅದರಲ್ಲೇ ಕೆಳಗಡೆ
ಹೌದು, ದಂಡ ವಿಧಿಸಿ ಕಂಡು ಬರುತ್ತದೆ.
ಹಾ.
ಈ ಸಂಬಂಧ ನಿಮ್ಮ ಮೇಲೆ ಸೂಕ್ತ ನಿಗಾರಣೆ ಮಾಡುವ ಅಗತ್ಯ ಕಂಡು ಬಂದಿದ್ರಿಂದ ಈ ಹಿಂದಿನ ಠಾಣಾಧಿಕಾರಿಗಳು ರೌಡಿ ಶೀಟರ್ ತೆರೆದಿದ್ದು ನಿಮ್ಮ ಮೇಲೆ ಸೂಕ್ತ ನಿಗಾ ವಹಿಸುವ ಸಂಬಂಧ ಸದರಿ ರೌಡಿ ಶೀಟರ್ ಮುಂದುವರಿಸುವ ಅಗತ್ಯ ಕಂಡು ಬಂದಿರುತ್ತದೆ ಅಂತ ಈ ಮೂಲಕ ನಿಮ್ಗೆ ತಿಳಿಸಲಾಗಿದೆ.
ವಾಟ್ ಆರ್ ದಿ ಗೈಡ್ಲೈನ್ಸ್ ಫಾರ್ ಓಪನಿಂಗ್ ದಿ ರೌಡಿ ಶೀಟರ್ ಅಂಡ್ ಕ್ಲೋಸಿಂಗ್ ಇಟ್?
Yes.
But that is my lord, any my lord activities, my lord, illegal activities, my lord.
That is that though in both those criminal cases, fine have been imposed and the case is closed. What more remains?
Madi, let him explain, my lord.
Yes,
Sir, total 2 cases have been registered against the petitioner.
ಆಯ್ತ್ರಿ, ಅದು ಕನ್ಸಿಡರ್ ಆಗಿ ಕೇಸ್ ಕ್ಲೋಸ್ ಆಗಿದೆ. ಅದು
He is a associate of one criminal called.
there has to be criminal cases registered. If there are no criminal cases registered,
No criminal case pending.
Then is there any other ground on which you can continue the rowdy sheeter?
He is involving in land settlement.
There has to be some case registered.
No case.
ಮತ್ತೆ improper consideration. What do you want to do? You are the Justice Dixit.
Yes, yes, my lord. Yes, I cited my lord in the previous petition also. I'll make my lord, because now this endorsement is made available to me.
Copy ಕೊಡಿ ಅವರಿಗೆ.
Yes.
I give,
There are directions issued by
Yes, yes,
Lordship
I'll-
Justice Krishna Dixit.
Yes, yes.
How such a application for removing the entry has to be considered. Please go through that one.
yes, my lord, you will pass the order, my lord. There is a direction to pass the order, my lord.
ಹಾ.
Superintendent of police
ಮತ್ತೆ ಈ
will
ತರ
pass the
ಸುಮ್ಮನೆ
order.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡೋದು ಏನ್ ಬಂತು?
Will pass the order, yes, sir, order.
ಅದಕ್ಕೆ ಅವತ್ತನ್ನೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿದೆ.
ಹೌದು.
ಹಾ, ಪೂರ್ತಿ ಹಾಕಿದಾರೆ ಅದರಲ್ಲಿ.
I have the copy, my lord. I will submit.
Will take notice for him, first respondent.
Learned government advocate takes notice for both the respondents.
Please.
Who is present today?
Superintendent of police, he only,
Kalaburagi.
yes, Kalaburagi.
Next para. The first respondent, Superintendent of Police Kalaburagi, is also present before this court. Full stop. Learned government advocate has furnished a copy of a memorandum dated 10/9/2024 issued by the first respondent.
Not by first respondent.
No, no, we requested the sub-inspector to submit the report.
This is sub
This letter is, my lord, requested to the, my lord, police sub-inspector to comply the direction of the learning secretary. We intimated to him. After passing.
Police adhikshakaru.
Upadhikshak.
ನಾವು ಲೆಟರ್ ಅವ್ರಿಗೆ ಬರ್ತೀವಿ.
This is a communication
Yes,
made by
communication.
the SP
Respect to the
to the police
Sub-ins-
inspector.
yes, sub-inspector.
So ಇದ್ರ ಮೇಲೆ ಇನ್ನೂ ಆಕ್ಷನ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ನಂತರ ದಟ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಈಸ್ ಇಶ್ಯೂ.
ವರದಿ
ಹೌದು,
ಇಂಬರಹ
ಅದು ಕೊಟ್ಟು ಇಂಬರ ಕೊಟ್ಟು ನಮ್ಗೆ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡು ಅಂತ ನಾವು ಹೇಳಿದ್ವಿ. ಅದ್ರ ಪ್ರಕಾರ ಅವರು ಇಂಬರ ಕೊಟ್ಟು ಬಿಟ್ಟು ದೇ ಸೆಂಡ್ ದಿ ಕಮ್ಯುನಿಕೇಶನ್ ಲಾಸ್ಟ್ ಒನ್ ಲೆಟರ್ ಇಸ್ ದಿ by him to the.
No, no,
superintendent.
but who is the competent authority to pass this order?
SP.
There is a direction to the honorable court to pass the order by the SP only, my lord. The Rowdy sheeter, my lord, their level only, my lord, whether it is continued or not.
No, no, the SP has to call for information.
Yes, my lord, that now
from
they
the
written letter.
concerned, police station.
Yes, ma'am.
So he can call for that information. Ultimately,
He has
he
to
only
pass.
has to pass that order. This endorsement given by the inspector of police.
Yes, ma'am. Now they communicated to us, my lord, we'll pass the order, my lord. That's why, my lord.
Issued by the Superintendent of Police, Kalaburagi, to the Sub Inspector of Police, Afzalpur Police Station. Pursuant to which the this endorsement is issued by whom?
Sub inspector.
An endorsement dated 9/11/2024 is issued by the Sub Inspector of Police, Afzalpur Police Station. Full stop. It is opined in the endorsement that since the petitioner has paid the fine in 2 criminal cases, namely crime number 306 of 2017 for offense under section 87 of the Karnataka Police Act, and crime number 211 under section 87 of the KP Act. It is necessary to continue the name of the petitioner in the Rowdy sheet, Full stop. Next para. However, the authority to consider the application for removal of the name from the Rowdy sheeter is the Superintendent of Police. Full stop. The Superintendent of Police, who is present before the court, is also requested to go through a recent judgment passed by a learned single judge this court. First page ಅಲ್ಲಿ ಅಲ್ಲ ಅಮ್ಮ ಇದು ಕೊಡ್ಬೇಕಲ್ಲ ಅವರು
Shri B.S. Prakash. B.S. Prakash.
In the case of Shri B.S. Prakash versus the state of Karnataka and others, in WP number 4504 of 2021, dated 22nd of April 2022, and proceed to pass necessary orders in terms of the directions issued by the learned single judge. Full stop. Next para, release this matter on 27th of November.
Please. Right.
Serial number 21, Ravindra Reddy.
For the petitioner, my lord. The notice on respondent number 3 was served as per the directions of the Sound Court, and the counsel was appearing in the writ petition, my lord. But he has refused to accept the notice Lord, on the reason that he is no more appearing. But at the same time, Lord, notices have been sent by through the
This
court,
is
my
matter
lord.
after service of notice on respondent number 3.
There is a thing, my lord, have done right, but is it? it's a tender matter, not wherein contract was awarded to the appellant. But that award was challenged. Not wherein in regard to remittance of the deposit amount, performance guarantee, and everything was as per the information given by the respondent owner corporation. Lord.
Already you have
So
also
that
taken
was
out
challenged by the
you have
rival
also
content.
taken out hand summons.
Hand summons have been taken out, my lord. The council has refused to accept the
could not
hand
serve.
summons.
Could not serve.
Could not serve, my lord, for that reason. The short point, my lord, wherein as per the corporation's notice, the appellant has already remitted the entire contract amount, and even contract award has been passed, my lord, and only possession was to be handed over. At that stage, my lord, the respondent 3 challenges the award of contract to the appellant. If it is taken up on Friday, my lord, I'll make in the meantime if notice is served.
ಹೌದ್ರಿ, you did not pay the license fee in terms of
Entire
clause
amount has
40.
been remitted. Entire amount has been remitted, my lord, as per the intimation given by the corporation. Only, my lord, because there was some delay, my lord, even after delay, my lord, there was an intimation. Again, time was extended by the corporation, my lord. Within that time, amount has been remitted.
Why?
And it has been accepted, and even award has been passed, my lord.
Why that was not submitted
Work
before
out.
the learned single judge?
Lord, we have submitted, my lord, only on the ground that because without noticing the payment, the corporation has given a notice to the respondent number 3 to come forward to make an offer on the offer which was made by the appellant. But at that stage, not they notified that payment has already been made and award has been already passed. But that intimation was withdrawn. That intimation which was withdrawn, no, that was challenged. That has not been considered by the single judge, my lord. Once award has been passed, not the respondent 3, but without challenging that award, my lord, only withdrawing the intimation, not writ petition has been filed. Writ petition itself was not maintainable. He has not challenged the award of work which was given in favor of petitioner. But he has remitted the amount of around 14 lakhs, not by borrowing from the third parties. Not in view of that, he is now paying interest, not, and he has hired labor also. He has kept everything ready, not for carrying out the works as per the award of the work. But at that stage, not if the award is cancelled, not it will cause hardship to him. And he was the eligible bidder, not wherein he was the highest bidder. It's not that he was not qualified. That is not the reason.
Yes, admittedly, you did not pay the amount within the stipulated period.
Yes,
And
ma'am,
they could not have entered into an agreement with you.
but in spite of that, not because there was a even delay in giving intimation, not for that reason, not, and moreover, not the time extended time was granted, and within that time, I have remitted the amount,
There
and
is no
after
provision,
remittance,
sir.
not
There is no provision
yes,
for
ma'am.
extension.
In regard to not,
This is what has been found by the learned.
I'll make out a case, not kindly have it on Friday, my lord.
ಬರ್ಬೇಕಲ್ಲಪ್ಪ ಅವರು.
Monday.
But there is entry mortem, not may be extended.
You are appearing for the corporation.
Corporation.
But the presence of respondent number 3 is necessary.
That's what.
Yes.
Monday or Tuesday.
Huh?
Not on Friday, my lord. There is some.
No, you have said list it after service of. Yes.
Entry mortem is there, may be extended.
ಏನ್ entry order?
Entry mortem, stay of order of the learning.
ಸರಿ ಬಿಡಿ ಮತ್ತೆ ನೀವು ಬೇರೆ ಇದೆ ಅರ್ಜೆನ್ಸಿ ಫಾರ್ ಯು ದೆನ್.
Because they are because I was supposed to be given with the award, my lord.
Yes.
Maybe extended for entry mode.
Yes.
Hearing on
Clear.
CL number 22, Niva M. Chimpod.
For early hearing.
Here for respondent number 4, my lord. Niva Chimkod
That
is
is called
applicant.
out. There is no representation for the appellant. Release this matter on 27th of November.
Applies.
CL number 23, Siddharama Reddy, Venkana Paradhi.
My lord, it is a case of injury, my lord.
Hmm.
I am for appellant, my lord. The date of extent is of 2014, my lord. Delay of 120 days. Date of extent is of 1/12/2014, my lord.
ಮಂಡಲಂ ಆಗಿದೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆಯಲ್ಲ.
Agide, sir.
ಹಾ
Aspali sir is appearing on behalf of the respondent.
ಹಾ ಕಂಡನೇಷನ್ ಆಫ್ ಡಿಲೇ
Yes, ma'am.
120 days. Order on IA number 1 of 2018. Delay of 120 days in filing the appeal is condoned while directing that the appellant shall not be entitled for payment of interest during the delayed period. Yes.
CL number 24, RS Siddhapurkar.
Two more weeks time.
Hmm?
2 more weeks time may kindly be granted.
Sufficient to prosecute.
ಇದು ಅದು ಆರ್ಕಿಯಾಲಜಿಕಲ್ ಸರ್ವೆ ನಾನೇ ಲಾಸ್ಟ್ ಟೈಮ್ ತಗೊಂಡು ಅದು ಸರ್ವೆ ಮಾಡಿಸ್ತೀವಿ ಅಂತ ಹೇಳಿ
As to whether the property in question falls within the
ವಿದಿನ್ ದಿ
prohibited area.
ಪ್ರೊಹಿಬಿಟೆಡ್ ಏರಿಯಾ ಅಂತ ಸರ್ವೆ ಮಾಡಿಸ್ತೀವಿ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ಮೇಡ್ ಎ
ಹಾ.
ಸಬ್ಮಿಷನ್. But I am told the district administration is not cooperating with the conducting the survey.
ಹಾ.
We don't have survey department, separate survey department. We depend upon the district administration. Your Lordship can grant me 2 weeks time, my lord, I will see that it. Last time ಇದೇ ಹೇಳೇ ಟೈಮ್ ತಗೊಂಡಿದ್ದೇನೆ.
The archaeological department is in appeal.
Yes, madam.
Huh?
Yes, madam. It's a deemed conversion order passed by the deputy commissioner.
Huh.
A writ petition was filed and an order was passed saying that there is a deemed conversion, you can take the benefit of the deemed conversion. Without making the archaeological survey as party, my lord, the writ petition was filed. Only deputy commissioner and the state of Karnataka were made parties before the writ petition. And since it falls within.
In order of stay?
Pardon?
Order of stay is there in your favor? Huh?
It is passed by the deputy commissioner himself. I have enclosed also that. Thereafter, I approached the deputy commissioner.
Adalri, after you filed the appeal,
Please,
is there an order of stay passed by this court?
there is.
No, there is no interim order, my lord. However, contempt is tagged with writ appeal.
Till next date of hearing. 23 February 2022.
Interim order. ಹೌದು.
Extend ಆಗಿರ್ಲಿಕ್ಕಿಲ್ಲ mostly.
Meanwhile, operation and implementation of the impugned order did passed in, he stayed till next date of.
ಹೌದು till next date ಅಂತ
ಅದಾದ್ಮೇಲೆ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
My lord, my submission twice, my lord.
Interim order of stay passed on 23/2/2022. In writ appeal number 2/00029 of 2022 shall stand continued until further orders.
Please. My lord, may I make one, sir?
Yes.
In this case, twice, my lord, they have taken time
ಹೌದ್ರಿ,
to
survey
conduct survey.
ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ?
Yes.
ಸರ್ವೆ ಕಂಡಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ ಅದೇ twice or thrice, my lord, adjournment is given.
Deemed conversion order, sir, if the
No, my-
area falls within the prohibited.
No, my lord, I have,
ಅದನ್ನ ನೋಟ್ ಚೆಕ್ ಮಾಡೋದಕ್ಕೆ we have directed
Yes, yes.
conducting of survey.
yes,
Survey is not conducted.
yes,
Then what to do?
my lord, all adjoining lands are already convicted. Recently, my lord, they issued, my lord, one more no objection certificate. I'll demonstrate, my lord, if lordship given some time. Yes, please.
Why is it that you are doing like this?
ಅದನ್ನೇ
You can
ಕೇಳ್ಬೇಕು,
choose.
ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೇಕು ಅಂತ ಅದನ್ನೇ ನಾನು had directed the officers to
What
be
have you,
present.
what action have you taken in respect of the other orders passed by you?
In respect of 402/*1, there, idontu.
402/1,
Yes.
402/2, 402/3, 402/4,
To the extent of,
2/5.
it is hereby informed to you that said conversion of land is not within the purview of Archaeological Survey of India. None 401, my lord, 401/1, all adjoining, my lord. 400/7 also.
Adjoining ಅಂತಂದ್ರೆ it depends.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು ಪಕ್ಕದಲ್ಲೇ ಇದೆ. ಆಮೇಲೆ
ಪಕ್ಕದಲ್ಲಿ ಇರ್ಬೋದ್ರಿ.
yes, may request.
Distance ನೋಡ್ಬೇಕು.
Do you have the copy of your sketch or something?
I have a sketch map, my lord, but it's not authenticated.
May make one more. They themselves have issued
ಹೌದ್ರಿ.
endorsement.
If they are sure that it doesn't fall within the prohibited distance, they can give it.
Allah, in respect of my survey number also, they declared that they have issued NOC.
402, 401. ಎಲ್ಲಿದೆ ರೀ? 402, 401, 401.
ಈ 400 ಇದೆ. ಇಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿ 401.
401. 402 ಎಲ್ಲಿದೆ? (403), 402.
402 ಆದ್ಮೇಲೆ 401 ಬರುತ್ತೆ ಸ್ವಾಮಿ.
402 ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಪರ್ಮಿಷನ್ ಅಲ್ಲ?
ಹೌದು, ಹೌದು. ದೇರ್ ಆಫ್ಟರ್ ಮೈ ಲ್ಯಾಂಡ್ ಈಸ್ ಮೈ ಲ್ಯಾಂಡ್ ಕಮ್ಸ್. Annexure R2, my lord, produced along with, my lord, statement of objections may kindly be looked into. They themselves have declared.
Mr. Siddhapurkar,
please.
We have marked in red all the 3 survey numbers. All of them fall within the prohibited area according to you.
Yes.
According to this.
Yes.
402 also falls within that area. How did you give permission?
ಅದೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಇವರು ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಾರ.
ಇವಾಗ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ, ನೀವು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ನಾವು 3 ಮಾರ್ಕ್ ಮಾಡಿದೀವಿ ನೋಡಿ ರೆಡ್ ಅಲ್ಲಿ.
ಹೌದು.
Then how did you give permission for 402?
I'll just verify, my lord, this copy is given to me.
You can't do this pick and choose. ಆಗೋದಿಲ್ಲ.
Now, if it is really so, my lord, I will not press the appeal.
Huh?
If it is really so,
Ah.
I will not press the appeal.
Surrounding, my lord, buildings have come up.
ಅದು ತೆಗ್ದಾಕ್ ಕೊಡಿ. ಇದು ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡಿಂಗ್ ತೆಗ್ದಾಕ್ ಕೊಡಿ ಬೇಡ ಅದು. Learned counsel for the
Respondent.
Complainant in the contempt petition bar writ petitioner submits that the appellant superintending archaeologist, Department of Archaeological Survey of India, Kalaburagi,
Allah, Hampi circle.
Hampi circle.
Hampi circle.
Hampi circle has given permission
No objection.
bar no objection in respect of survey numbers 202, 402 bar 1, 402 bar 2, 402 bar 3, 402 bar 4 and 402 bar 5. But is raising objection in respect of survey number 401. Full stop. It is pointed out that even in terms of the map submitted by the appellant, 402, survey number 402 also falls within the prohibited area. Full stop. It is therefore contended that the appellant is arbitrarily issuing NOCs in favor of some persons and declining to give the NOCs in favor of the complainant. Full stop. Next para. Learned counsel for the appellant is therefore requested to secure instructions from the appellant. Full stop. If it is true that NOC has been given in respect of survey number 402, which also falls within the prohibited area in terms of the map submitted by the appellant, then the question is why such NOC is being declined to the complainant bar writ petitioner. Full stop. Next para. Release this matter on 27th of November.
Great.
CL number 26, Harshavardhan R. Mali Patil.
Your Lordship, this appeal is by the defendant number, LRs of the defendant number 3. We have filed a permission to prosecute, Your Lordship.
Huh?
This appeal is by the LRs of the defendant number 3, Your Lordship. Purchaser, defendant number 3 was the purchaser.
Hey, other side.
No, Your Lordship.
Huh?
Notice has not. Your Lordship, one Mahendra Kumar was the defendant number 3 before the trial court.
Defendant number 3.
Please, Lordship. And he has deceased
When?
after the 3 months of the passing of the judgment, Your Lordship.
After the judgment.
Please,
was passed.
please.
So that is why the appeal is filed by the legal representative.
Please, Lordship.
Along with this application.
Please, Lordship.
Huh?
Please, Lordship. And there is a delay of
For? Huh?
and there's a delay of 387 days in filing, Your Lordship. We have filed an application.
Issue notice.
Please, Lordship.
We have to hear the other side and
Please.
thereafter consider all the applications.
Please, please, Lordship.
Issue notice to the respondents. On IA number, IAS number 1 to 3 of 2023. Yes.
Okay.
CL number 27, Shravan Kumar Mutt.
I'm for the appellant, my lords. Restitution of conjugal rights petition has been allowed, my lords. But if I join my husband, my lord, or matrimonial house, himse ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ ಅದಕ್ಕೆ ಹಾಕಿರೋದು. Maybe refer to mediation, my lords. I will persuade the parties. ಶ್ರೀ ಬಸವರಾಜ್ ಮಠ ಇದ್ದಾರೆ ಅವರಿಗೂ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಸರ್.
Huh?
ಬಸವರಾಜ್ ಮಠ್ ಸರ್ ಇದ್ದಾರೆ.
Parties, the parties are directed to appear before the mediation center, Kalaburagi.
ಹೌದು.
For mediation.
Oh.
Full stop. Yes.
On any date could.
Huh?
Date.
Release this matter on
Mediation date, sir.
mediation. The parties are directed to appear before the mediation center on. You tell us.
29th November.
ಯಾಕೆ ಅಷ್ಟು ದೂರ ಯಾಕ್ರಿ?
ಅವರು ಬೆಂಗಳೂರಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿದ್ದರು ಕಮ್ಯುನಿಕೇಶನ್ ಮಾಡಿ.
ಮಂಗಳೂರಾ?
ಇಲ್ಲ ಬೆಂಗಳೂರು ಸರ್. ಅದಕ್ಕೆ ಶಿ ಇಸ್ ಟೇಕಿಂಗ್ ಸಮ್ ಕೋರ್ಸ್ ಅಂತ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಹೇಳಿ ಮತ್ತೆ ಬರೋಕ್ಕೆಲ್ಲ ಅನುಕೂಲ ಆಗ್ಬೇಕು.
29th of November.
Obligement. I will inform the Basaraj.
Bill number 28, Nanta Girda.
Lordship, there's a delay of 22 days, Your Lordship. And I filed an IA for condoning delay, Your Lordship.
Huh?
There's a delay of 22 days, Your Lordship.
You had filed the case.
Yes, Your Lordship. For the husband.
Of course.
Yes, Your Lordship. That has been dismissed, Your
Has
Lordship.
been dismissed.
Yes, Your Lordship.
Delay of 22 days in filing the appeal is condoned.
Please.
IA number 1 of 2023 is accordingly disposed of. Yes.
Kindly it may be referred to mediation if there's a possibility of settlement that can be done, Your Lordship.
Same order. Mediation center. 29th, huh?
Yes.
Huh?
Maybe.
All right.
Bill number 29, Santosh Patil.
I appear for appellant in the case. Being aggrieved by the dismissal of divorce petition filed by the appellant, this MFA is filed before this honorable court and there is delay of 98 days in.
Wife had filed the.
No, husband had filed a petition for divorce.
Dismissed.
Dismissed. And hence 98 days, there is delay in 98 days.
Same order. Delay of 98 days is condoned. IA 1 is disposed of. Go before the mediation center.
Since 30 years, they are living separately. Your Lord. Maybe there is no.
Despite that, if your petition is dismissed, what can we say?
Since December 1995,
Yes,
they are
having
residing.
said-
With the same facts, if your petition has been dismissed, then what should we understand? If that is a very good ground
Yes.
for allowing the petition,
Yes.
and that has not been accepted,
Yes.
then. Huh?
Cruelty.
Hmm.
And
That 30 years, if you are
Yes.
saying, then the ground should have been desertion. Adilwala. Anyway, we'll see. Go before the mediation center
Please.
on 29th of November.
Please.
Yes.
Seal number 30, 30, Siddharuda V. Pujari.
My lord, in this case, the fifth respondent herein was the applicant before the tribunal. He filed the application.
Lord, on the last occasion, I was asked to, my lord, produce. My lord, with regard to the similar, my lord, official
yes.
memorandum, if any, my lord.
Rule 3.1.
My lord, yes, ma'am.
Yes.
We can file, my lord, a similar OM, my lord, verbatim,
Yes.
my lord, which I have produced. My lord, OM, my lord, 14,793. Which is at,
OM.
yes, my lord. Even, my lord, in the A.N. Mohanan case also, my lord, very,
That was some, those were not government servants.
yes, my lord, government servants. Yes, ma'am.
No. ಯಾವ್ದೋ ಬೇರೆ ಇದ್ರದ್ರಿ ಅದು.
Mohanan.
Public sector ಅದು. That is why.
ಅದು ಸೆಂಟ್ರಲ್ ಇರ್ಬೇಕು ಅದು ಸೆಂಟ್ರಲ್ ಅದರಲ್ಲಿ
Where are the rules?
yes
Huh?
Here,
Where are the rules?
my lord, here, my lord, lordship may kindly, my lord, see Mohanan's case, my lord, initially. My lord, in that. Put in.
ಗೊತ್ತಾಯ್ತ್ರಿ, there was into OM.
Yes,
we
ma'am,
understand.
ಅದರಲ್ಲಿ ಕೂಡ few rules as contained in the OM need to be noted ಅಂತ ಇದೆ ಅದರಲ್ಲಿ.
OM, all those, all their rules is in OM only.
Their rules.
ಅಲ್ಲಿ.
As I understand.
Ah.
And now, my lord, I will only to, my lord, this, the same, my lord, the remains the same. That one thing, my lord. Now,
one ನಿಮಿಷ. Police inspector.
Yes, my lord. In the case on hand, my lord, it is police inspectors.
So the Karnataka.
Karnataka State Police disciplinary proceedings rules.
Yes, rules.
Yes, lordship may
That
kindly
would apply. And all other provisions of the CCA rules.
No, my lord. Only insofar as disciplinary proceedings are concerned, my lord, KSPDP rules. And insofar as, my lord, the other, my lord, KCSR and other rules, my lord, as applicable to other governments. And now, my lord, the KSPDP rules, my lord, lordship may kindly see, my lord, in the amended rules, my lord, the censure, my lord, in page 2, my lord, in 4A, disciplinary penalties.
Yes.
My lord, the censure, my lord, at A1, my lord, is one of the measure for, my lord, punishment for misconduct. And, my lord, here, censure being one of the, my lord, the punishment.
Yes.
And now, my lord, as early as, my lord, 96, my lord, my lord, the Supreme Court, my lord, in Qureshi's case, which is, may I pass it on?
Allah, pidi. So why should we go to other things now? We have noticed certain orders passed in the judgment of the Supreme Court in Monan's case, which you wanted to place reliance on.
And, my lord, I believe, my lord, this is more pertinent, my lord, than Mohanan's case, my lord. May I pass it on? This is more pertinent, my lord, than Mohanan's case, in Qureshi's case.
The tribunal has passed orders based on this
Mohanan's case.
So then, therefore, we'll have to reconsider that one.
My lord, may I only, my lord, to bring it to the notice of this?
Amel Norna, we will see it later.
Please.
We wanted to see whether the similar provisions are there. The rules governing the disciplinary proceedings.
Yes,
in respect of the parties here.
Yes, ma'am.
Yes.
I could find, my
Let
lord.
us see that.
Please. My lord, I could found, my lord, one that OM, my lord, which I have produced now. And, my lord, the subsequent OM also, my lord, of 2010, which I have produced earlier.
No, why should we fall back on OM, sir, when the rules are there?
The answer would be, my lord, this Qureshi's case. Qureshi's. This is, my lord, I believe it to be pertinent. Lordship may kindly, my lord, for a moment. May, please.
There is nothing in this one? This notification?
Yes, my lord. In that notification, my lord, that I have produced, my lord, only to show, my lord, that censure is.
Of course, that is there.
Yes.
ಅದಕ್ಕೇನು ಇದಲ್ಲ ನೀವು even in the original rules it can be found.
It can be found. It
Yes.
can be found. And now, my lord, lordship may kindly see, my lord, in this last para, page, my lord, para 4.
See, why we are saying all this is, you are also sufficiently experienced in the civil service matters.
Yes.
We have come across many cases where such orders of censure are passed only on the ground that it will not affect the service conditions of the party.
Yes, yes.
That is the ground on which orders of censure are passed.
Yes.
Please understand.
Maybe you're keeping in mind, my lord, that it may not.
Then, if that is so, how can you now say censure also is a punishment and therefore you will not be entitled for promotion?
Only, my lord, it is, my lord.
That is why
even
he said when you based your argument on Monan's case, that was passed having regard to these provisions.
Provisions.
Why we are called upon you to show whether similar provisions are there in the
Yes.
rules governing the disciplinary action to be initiated against the parties.
I
How
could,
you are coming with some OM instead
OM,
of rules.
since Lordship my lord had pointed out, but I could lay my hands only to that OM my lord. Maybe my lord that is not incorporated in rules. It is an OM.
ಇದು 1993 OM.
OM and 2010 also, my lord, which I have produced earlier.
Why it is not incorporated in the rules?
I'm
They found that this should be the proper provision. And from 1993, if they found this should be implemented, why is it not brought into the rules?
But my lord, the fact remains, my lord, across all the departments, my lord, insofar as when an censure is, my lord, imposed against a government employee, my lord, in every other case, my lord, they do, my lord, they take it prospectively for promotion. They do in the, my lord, practice, in the practice mode. Maybe that is,
There should be several judgments then
yes, my lord.
in this regard,
My lord,
based on our state rules.
State rules.
Why should we fall back on some judgment of the Supreme Court which pertains to some other rules?
But even, my lord,
If you are so clear in your mind that having regard to the rules of the state governing the disciplinary proceedings, similar provisions were there, and therefore the courts have been consistent in their order.
yes.
Ashtondidre, you please show them.
My lord, even before, my lord, this A.N. Mohanan's case, my lord, my lord, in even the Qureshi's case, my lord, I had, my lord, even without referring to, my lord, this OM, may I, my lord, for the sake of convenience, please. Lordship, may kindly, my lord, see, my lord, last para. My lord, in the first page, my lord, the last para, 4. May I read? Shri S.K. Agnihotri, the learned counsel appearing for the appellants, has submitted that the tribunal was in error in directing opening of the sealed cover in the facts of this case. In this context, Shri Agnihotri has invited our attention to the circular dated so-and-so, which contains the guidelines in the matter of giving effect to the minor punishment of censure about the promotion of government servants. A translated version of the said circular has been filed on behalf of the appellants. Clause 192 of the said circular are reproduced here and there. White letter dated 31/1964. This has been directed that in the cases of those officers against whom either departmental inquiry is pending or who have been suspended on the recommendations of the DPC should be kept in the sealed cover, and that should be opened only when the delinquent officer has been fully exonerated by the departmental inquiry. Otherwise, it should not be opened. The meaning of this is very clear that if the delinquent employee has been punished by the departmental inquiry, then his case, which has been kept in the sealed cover, will not be opened and he will not be granted promotion on the basis of the recommendations of the DPC, which is kept in the sealed cover. Hence, once the punishment has been granted, the delinquent employee is not entitled for promotion irrespective of the nature of punishment. Furthermore, in the letter dated 27/75, this direction has been explained in more detail. In this letter, it has been explained that till the time the delinquent officer who has been punished by the departmental inquiry will not be considered or will not be considered eligible for promotion to the next post. Regarding those government employees who have been awarded minor punishment, it would not be proper to delete their names from the subsequent DPC on this ground that they have been punished. The cases of such government employees who have been awarded minor penalties should be kept before the subsequent.
This sentence goes against you.
Yes.
In spite of this observation regarding those government employees who have been awarded minor punishment, it would not be proper to delete their names from the subsequent DPC on this ground.
Yes.
That they have been punished.
Yes. Further, my lord,
that is the opinion.
Further, it is clarified. Who have been awarded should be. It means that the minor penalty will not disentitle the delinquent officer from promotion on the basis of the recommendation of the subsequent DPC. If on the basis of the previous documents and valuation of the DPC, it is necessary to promote any officer who has been awarded with minor punishment, then in that case, it would be proper to promote the said officer with prospective effect. And that case, it would be proper, and the promotion in any event should not be from retrospective effect. This is also being clarified that if the punishment of stoppage of increments or promotion, so and so. This is not. And coming to last para.
Even stoppage of one increment would be a punishment. It is a minor punishment. No doubt, censure also is a minor punishment.
Yes.
But as I said, such orders are being passed with an understanding that it would not amount to punishment.
Yes.
That is why in many such cases we have been seeing that orders of censure are passed.
And my lord, here in the case on hand, my lord, what had happened, my lord, he had accepted and he had not gone on appeal. And
Appeal,
even
yes, that is why.
and
See, all of us have understood this. People who are practicing on the service side have understood this concept in this manner. That an order of censure will not amount to punishment.
but my lord, there is a slight difference, my lord, the thinnest difference, prospective and retrospective. My lord, maybe that, my lord,
Allah,
but
if it is not a punishment,
then my
all
lord,
this argument will not
not
come
stand.
into-
Yes.
It is as good as the person being exonerated,
Yes, ma'am.
isn't it?
There is a very thin line. But my lord, what had happened, even my lord, maybe the other side, my lord, with that understanding, my lord, he had not appealed that. And he had personally come before the tribunal.
Yes.
And my lord, even he didn't contest the matter. And though it was ಎಲ್ಲರೂ ಹೇಳಿದ್ರು that he can keep, my lord, any counsel of his choice. But he, my lord, graciously accepted. And now, my lord, now it is their contention, my lord, that even, my lord, prospectively also, my lord, now they have taken, my lord, steps for his promotion.
ಪ್ರಮೋಷನ್ ಕೊಟ್ರೆ ನಿಮ್ಗೆ ಅಫೆಕ್ಟ್ ಆಗುತ್ತಾ?
ನನಗೇನು ಎಫೆಕ್ಟ್ ಆಗೋದಿಲ್ಲ. ನನಗೆ 32 ಕೊಟ್ಟಿದ್ದಾರೆ. ನನಗೆ ರೆಗ್ಯುಲರ್ ಆಗಿ ಅದೇ ದಿವಸದಿಂದ ಕೊಡಿ ಅಂತ ನನಗೆ ಇವರು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಟ್ರೈಬ್ಯುನಲ್. And even, my lord, he will also be eligible. But, my lord, he will also get promotion now. But that would be, my lord, prospectively.
Why?
Only for the reason of this being the censure.
ಬಿಟ್ರೆ otherwise you are not also going to be affected. If retrospective promotion is given to him.
My lord, what happens, my lord, since, my lord, the next post, my lord, is of junior scale, class 1 junior scale ಬರುತ್ತೆ. My lord, if, my lord, if he gets, my lord, retrospectively, and, my lord, the next
You are below him only earlier.
I am below him. Though I stand, my lord, in the seniority.
Because of this turn of events, now you want to say no, I should
ಇಲ್ಲ ಅದು ಏನ್ ಮಾಡಿದ್ದಾರೆ, my lord, they have not given me, my lord, ಅವಾಗ ಏನಾಯ್ತು, I was the last, ಒಂದು 4 ಜನ ಪ್ರಮೋಷನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ I was the last, my lord, in my lord, the line of the my lord, 3 ಜನರಿಗೆ ಮೇಲೆ they had given regular promotions under 42B. Though, my lord, under the zone of consideration, my lord, all of us were zone of in the consideration. I was found to be fit and eligible only because, my lord, he had that, my lord, departmental inquiry, my lord, his name was not considered. My lord, finally, my lord, I was given, my lord, under rule 32 of KCSR instead of, my lord, giving it under 42B. After discrete inquiries, my lord, it was found, my lord, that, my lord, only because, my lord, he was facing departmental inquiry, my lord, that I have been temporarily, my lord, placed under rule 32. My claim, my lord, subsequently, my lord, since it ended in censure, anyhow, my lord, they'll have to provide me promotion under 42. That was my contention. Now, even he will also get promotion, my lord. Now, my lord, by virtue of his, my lord, the censure, he will also get promotion. And now, my lord, I am told, my lord, that they have already, my lord, kept his promotion order also ready. ಅಂದ್ರೆ ಆಮೇಲೆ ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ, my lord, it has been considered in detail. Censure ಹೇಳಿದ್ದಾರೆ in Qureshi's case, ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ. May I read, my lord?
Yes, I have read it. Same ಅದು ಮೋನ್ ಅಂತರನೇ ಇದೂನು ಇದೆ.
ಅದೇ ಇದೆ. But here, my lord, ಇದರಲ್ಲಿ it is on circular, based on circular. And, my lord, such circulars, my lord, even 2010 ಅಲ್ಲಿ ಇದೆ, 93
promotion should be considered along with those whose promotion was given in terms of the sealed cover procedure, or it should be given prospectively in the next DPC is the question.
Yes.
ಅಷ್ಟೇ ಇರೋದು,
My lord,
ಇನ್ನೇನು ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
In this case, my lord, whether the fifth respondent is entitled for promotion or not is the question.
No,
Because my
that
lord,
is not the question.
because my lord,
It is about you.
my lord,
You are not questioning his promotion, sir. That was given long back.
but tribunal, my lord,
Sir, you-
allowed the
You
application.
are aggrieved
Yes.
with the prospective promotions ought to be given to you. Aste. You cannot now question the promotion given to that person. ಅದ್ ಬರೋದಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
Not promoted him, my lord. He is not promoted at all.
Under rule 32.
32 is not a promotion. 32 is not a promotion. It is only
ಅದನ್ನ
temporary.
ಬಿಡಿ.
32 is.
You forget about him.
He.
You forget about him, sir.
Yes, ma'am.
After this order of censure has been passed against you, what is the position?
My lord,
ಅಷ್ಟೇ ನಾವು
whether the unreserved candidate seek a direction to reserved post, my lord, there is a judgment of the honorable this
ಅದು
court.
ಬರೋದಿಲ್ರಿ ಇವಾಗ. The question now is that in the departmental proceedings, you have been awarded a punishment of censure.
Janaki Raman case is there, my lord. Even assuming, my lord, there is a inquiry or criminal case is pending, the employees entitled the promotion, promotion. Janaki
What-
Raman case is there.
Sealed cover procedure contemplate ಆದ್ಮೇಲೆ,
Yes.
after the proceedings are completed and order is passed by the disciplinary authority, what is the position?
My lord, here,
If you are completely exonerated, you should be given promotion, opening the seal cover, same day promotion.
my promotion is, already order has been passed, my lord. My lord, I produced the documents, my lord.
Yes,
Annexure C, my lord.
yes.
Entire reading of the order, my lord. From page 64. DPC proceedings. Typed copy is at 67.
ಇದು ಯಾವುದು DPC proceedings?
ನಾನು ಕೊಟ್ಟಿದ್ದು promotion. ನನಗೆ now given the promotion to the me.
Subsequent DPC.
Subsequent DPC. My lord, here, my lord, Rajya, from first page, Rajya Police ಇಲಾಖೆಯ PI KSSI ಕರ್ನಾಟಕ ವೃಂದದಿಂದ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ವೃಂದಕ್ಕೆ ಸ್ಥಾನಪನ್ನ ಮುಂಬಡ್ತಿ ನೀಡುವ ಕುರಿತು ಸರ್ಕಾರದ ಅಪರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿಯವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ದಿನಾಂಕ 24/2/2023 ಇಲಾಖಾ ಮುಂಬಡ್ತಿ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ಶ್ರೀ ಬಸವರಾಜ್ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್, ದಿಸ್ ಇಸ್ ದಿ ಪಿಟಿಷನರ್ ಮನ್, ಇನ್ಸ್ಪೆಕ್ಟರ್ ಜ್ಯೇಷ್ಠತಾ ಕ್ರಮ ಸಂಖ್ಯೆ ರವರ ಸಂಖ್ಯೆ 6 ರವರ ವಿರುದ್ಧ DIG ಆಡಳಿತ ISD ರವರು ದಿನಾಂಕ 11/1/2023 KSP DP ನಿಯಮಗಳ 1965/89 ನಿಯಮ 7
ಎಲ್ಲ ಪೂರ್ತಿ ಓದ್ಬೇಕಾಗಿಲ್ರಿ. You please read the relevant.
ರಿಲೆವೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಮೀಟರ್. ಪ್ರಸ್ತುತ ಶ್ರೀ ಬಸವರಾಜ್ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ರವರ ವಿರುದ್ಧ ಪ್ರಾರಂಭವಾಗಿದ್ದ ವಿಚಾರಣೆ ಮುಗಿದಿದ್ದು, ಸದರಿಯವರಿಗೆ ಪ್ರಕರಣದಲ್ಲಿ 28/3/2023 ವಾಗ್ದಂಡನೆ ವಿಧಿಸಲಾಗಿರುತ್ತದೆ ಹಾಗೂ ಸದರಿಯವರ ವಿರುದ್ಧ ಯಾವುದೇ ಇಲಾಖಾ ವಿಚಾರಣೆ ಬಾಕಿ ಇರುವುದಿಲ್ಲ ಎಂದು ಹಾಗೂ ಶ್ರೀ ಬಸವರಾಜ್ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ರವರಿಗೆ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ KSISF ವೃಂದದ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ನೀಡಲು ಕಮಾಂಡೆಂಟ್ KSISF 2ನೇ ಪಡೆ ಶಿವಮೊಗ್ಗ ಇವರು ಶಿಫಾರಸು ಮಾಡಿರುವ ಶಿಫಾರಸಿನ ಪ್ರತಿಯನ್ನು ಹಾಗೂ ಶ್ರೀ ಬಸವರಾಜ್ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ರವರ ಕಳೆದ 5 ವರ್ಷದ ವಾರ್ಷಿಕ ಕಾರ್ಯನಿರ್ವಹಣಾ ವರದಿಯನ್ನು ಲಗತ್ತಿಸಿ DG ಮತ್ತು IGP ರವರ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿರುವುದನ್ನು ಸಮಿತಿಯು ಗಮನಿಸಿತ್ತು. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 00 ದಿನಾಂಕ 3/10/2016 ಕರ್ನಾಟಕ ಅಧಿಸೂಚನೆ ಕಮಾಂಡೆಂಟ್ ಹುದ್ದೆಗೆ ನೇರ ಹುದ್ದೆ ರದ್ದುಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 00 ದಿನಾಂಕ 24/1/22 ಹೊರಡಿಸಿರುವ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಕೈಗಾರಿಕಾ ಭದ್ರತಾ ಪಡೆ ನಿಯಮಗಳು 2021 ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ವೃಂದದಿಂದ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ವೃಂದಕ್ಕೆ ಮುಂಬಡ್ತಿ ನೀಡಲು ಕೆಳಕಂಡ ಅವಕಾಶಗಳನ್ನು ಆಯ್ತು. ಇದು ನಿಯಮಗಳ ಬಗ್ಗೆ ಹೇಳಿದ್ರು. ಅದಾದ್ಮೇಲೆ ದೇರ್ ಆಫ್ಟರ್ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳಲ್ಲಿ ನಮೂದಿಸಿದಂತೆ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ವೃಂದದ 5 ತಾತ್ಕಾಲಿಕ ಹುದ್ದೆಗಳನ್ನು ಪ್ರಸ್ತುತ ಮುಂಬಡ್ತಿಯಿಂದ ಭರ್ತಿ ಮಾಡುತ್ತಿಲ್ಲವಾದ ಕಾರಣ ಮಾಡಲಾದ 24 ಕಾಯಂ ಹುದ್ದೆಗಳಿಗೆ ಮಾತ್ರ ಮುಂಬಡ್ತಿ ಮೂಲಕ ಭರ್ತಿ ಮಾಡಬೇಕಾಗಿರುವುದು ಸಮಿತಿಯು ಗಮನಿಸಿತು. ಸರ್ಕಾರಿ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ದಿನಾಂಕ 22/2/2023ರಲ್ಲಿ 24 ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಹುದ್ದೆಗಳಲ್ಲಿ 4
All those requirements you have fulfilled, that's pretty.
Yes, ma'am. Next, last, my lord, page 66 ಅಲ್ಲಿ ಬಸವರಾಜ್ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರು ದಿನಾಂಕ 14/9/2019 ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿ ಹೊಂದಿದ್ದು 3 ವರ್ಷ 7 ತಿಂಗಳು ಆಗಿರುತ್ತದೆ.
All that you have complied.
ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಹುದ್ದೆಯು ಗ್ರೂಪ್ ಎ ಶ್ರೇಣಿಯ ವೇತನ ಶ್ರೇಣಿ 52,650 97 ಹುದ್ದೆಯಾಗಿದ್ದು ಮೀಸಲಾತಿಯು ಅನ್ವಯವಾಗುತ್ತದೆ. ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಒಂದದ ಅಧಿಕಾರಿಗಳಿಗೆ ಸ್ಥಾನೋನ್ನತ ಮುಂಬಡ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ದಿನಾಂಕ 28/12/22 ರನ್ವಯ ರೋಸ್ಟರ್ 1ನೇ ವೃತ್ತದ 1ನೇ ಬಿಂದುವಿನಿಂದ ಮುಂಬಡ್ತಿಗೆ ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ. ದಿನಾಂಕ 4/3/23ರಂದು ಹೊರಡಿಸಲಾದ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ವೃಂದದ 3 ಹುದ್ದೆಗಳಿಗೆ ಸ್ಥಾನಪನ್ನ ಮುಂಬಡ್ತಿ ನೀಡಲಾಗಿರುತ್ತದೆ ಹಾಗೂ 1 ಹುದ್ದೆ KCSR ನಿಯಮ 32 ದಟ್ ಈಸ್ ಗಿವನ್ ಟು ದಿ 5th ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಿಯರಿಂಗ್ ರಲ್ಲಿ ಸ್ವಾತಂತ್ರ್ಯ ಪ್ರಭಾರದಲ್ಲಿ ಇರಿಸಲಾಗಿರುತ್ತದೆ. ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ದಿನಾಂಕ 4/3/2023 ಬಸವರಾಜ್ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವರು SC ವೃಂದದ ಅಧಿಕಾರಿಯಾಗಿರುತ್ತಾರೆ. ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ವೃಂದದ ಅಧಿಕಾರಿಗಳಿಗೆ ಸ್ಥಾನಪನ್ನ ಮುಂಬಡ್ತಿ ನೀಡಿರುವ ದಿನಾಂಕ 4/3/2023 ಅಧಿಸೂಚನೆಯಲ್ಲಿ SC ಮೀಸಲಾತಿಯ ಅಧಿಕಾರಿ ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ 1ನೇ ವೃತ್ತದ ಬಿಂದುವಿನಲ್ಲಿ SC ವರ್ಗದ ಬಿಂದು ಖಾಲಿ ಇರುತ್ತದೆ. ಸರ್ಕಾರಿ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 4/3/2020-23ರಲ್ಲಿ ಶ್ರೀ ಶರಣಬಸವ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಜ್ಯೇಷ್ಠ ಸಂಖ್ಯೆ 3 ರವರಿಗೆ KCS ನಿಯಮ 32ರಲ್ಲಿ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಹುದ್ದೆಗೆ ಸ್ವತಂತ್ರ ಪ್ರಭಾವದಲ್ಲಿರಿಸಿರುವುದನ್ನು ಹಿಂದಿಗೆದುಕೊಳ್ಳಲು ಸಭೆಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು.
You are aggrieved by this portion?
No.
ಅವರು
Not aggrieved by this portion, my lord.
Why?
He not challenge anything. My lord, his case is, my lord, before the tribunal. He made a representation. He made a representation. For considering the representation, he filed the case, my lord. That's only. He not challenged any my order.
Let us see the application.
It is at page 22.
For consideration of representation.
22-23.
Page 42.
Sought for quashing the, my lord.
Passing up his 32 only.
4/3/23. Insofar as not promoting me, my lord, substantial.
This is only 32, rule 32 was challenged by him.
Direct the respondents to grant him promotion to the cadre of assistant commandant substantively under rule 42.
Yes, my lord.
Since initially rule 32 was given, my lord, sought for.
Since there is no post available to the 5th respondent, my lord. There is no post available. That one post, remain post is reserve post. It belongs to the scheduled caste candidate.
That will be carried forward.
No.
In an additional roster.
There is no such rules.
It will be carried forward in the additional roster.
Even Supreme Court, my lord, Pavitra 192 case held, my lord, the reserve
Who
post.
had filed the application
Please.
even before the
promoting me, my lord.
Your application was filed earlier.
Yes, my lord, my promotion, my lord, once I was given, my lord, promotion under rule 32.
After that you filed.
Immediately I filed, my lord, seeking, my lord, for substantial.
Without bringing into these all these facts, my lord, the tribunal allowed the application.
When was it allowed?
It is
13th of August 2023.
Yes.
ನಿಮ್ದು ಅದು ಯಾವಾಗಲೇ ಅದು resolution pass ಆಗಿರೋದು?
4/8/2023, my lord. Because of the tribunal order.
4/8/2023.
Yes, ma'am.
4/8/2023.
Yes.
So just before this order could be passed,
Even serving.
a decision was taken.
Yes, ma'am.
To promote you.
Yes, ma'am.
But, my lord,
and that was not the subject matter of the application.
No, my lord, no.
It was not brought to the notice, and neither, my lord, subsequent any orders were passed on
By
this.
misleading the tribunal, my lord, obtained the order, my lord.
No, this,
These facts are not brought to the tribunal, my lord. In the order is itself so clearly says, my lord, even serving the notice to the respondent, before serving the notice to the respondent, obtain the order.
My lord, here on 4/8,
Annexure D, my lord, I have produced.
my lord, on 4/8/23, my lord, this DPC was, my lord, was drawn. On
Annexure-
13/8,
annexure
my lord,
D,
if
my
the
lord,
matter was
page-
resolved much earlier.
page 68, my lord.
My lord,
Page
when the-
68,
When the matter was reserved, my lord, this, my lord, DPC, my lord, was drawn.
page 68, my lord, last para, my lord, last 69. ಪ್ರಸ್ತುತ ಸಹಾಯಕ ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ 69 ಅಲ್ಲಿ ಪ್ರಸ್ತುತ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಘಟಕದಲ್ಲಿ ಒಂದು ರಿಕ್ತ ಸ್ಥಾನವಿರುತ್ತೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಶ್ರೀ ಶರಣಬಸವ ಮೀನ್ಸ್ ದಿ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಸ್ವತಂತ್ರ ರವನ್ನು ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಹುದ್ದೆಯಲ್ಲಿ ಕ್ರಮಬದ್ಧಗೊಳಿಸಲು ಕೈಗೊಳ್ಳುವಂತೆ ಆದೇಶಿಸಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಶ್ರೀ ಶರಣಬಸವ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಸ್ವತಂತ್ರ ಪ್ರಭಾರ ಇವರು
ಒಂದ್ ನಿಮಿಷ. In paragraph number 2 of the order of the tribunal.
Yes.
Paragraph number 2.
Please. Please.
ಕೆಳಗಡೆಯಿಂದ ಒಂದು 7 or 8 line.
Please.
After the issuance of promotion orders of fifth respondent has been imposed with a punishment of censure, thereby making him ineligible for claiming any regular promotion retrospectively.
Please.
This cannot be the ground for consideration.
No.
As on the date when the DPC took a decision, this no order was passed as against this appellant.
Yes, no, order was passed.
Huh?
Order of censure was passed.
No. DPC. When the DPC was held.
When the first DPC was held, my lord, he was found, my lord, not eligible for the.
ಇಲ್ಲ ರೀ, ಅವಾಗ ಇನ್ನು proceedings were
pending-
still going
pending.
on against him. That is why still sealed cover process was adopted.
Yes, my lord, once, my lord, the articles of charges are issued.
We'll come to it later. You filed the application
Yes, my lord.
immediately after the decision of the DPC.
After
To
giving,
grant you promotion only under Rule 32.
immediately after, my lord, issuing of orders
Alva?
under Rule 32.
You were only aggrieved that instead of the regular promotion under Rule 42, you were given promotion under Rule 32.
Yes.
That
Yes.
was your grievance.
Yes, ma'am.
That was the grievance with you went before the tribunal.
Yes, ma'am. Yes,
Huh?
yes.
What was the tribunal required to consider?
My lord,
Whether you were eligible,
Yes, ma'am.
yes, ma'am.
whether you were eligible
Yes.
for grant of promotion
Yes.
under Rule 42
Yes.
or Rule 32.
Yes, ma'am.
ಅಷ್ಟೇ ಕನ್ಸಿಡರೇಷನ್ ಬೇಕಾಗಿದ್ದು.
Yeah, that was, my lord,
Subsequent event has been taken note of here.
yes, ma'am.
The subsequent event of punishment imposed on this person has been taken note of,
Please.
which is not permissible in law.
My lord, here, my lord,
And one more thing, my
only, my lord, when I, my lord, become, my lord, ineligible, if I don't show, my lord,
The tribunal was required to consider was
whether
whether your contention that you should have been considered for regular promotion on under Rule 42.
yes, my lord,
As on the date when the DPC took the decision,
yes, my lord.
all the subsequent events could not have been taken into consideration.
My lord, my lord,
ಬರೋದಿಲ್ಲ.
my lord, here,
Understand? You went before the tribunal, filed an application on the ground
please,
that you should have been considered under Rule 42
please,
and not Rule 32.
please.
All the subsequent events, which was not the ground on which you were granted promotion under Rule 32, it could not have been considered by the tribunal.
My lord, by the time I filed my application, my lord, the order of censure was passed.
Correct.
And I took it, my lord, in our, it was very much the contention of the,
Huh?
yes, my lord. May I?
Even if you have taken contention,
Please.
that is not relevant.
he is not eligible at all, my lord.
That is not relevant for your consideration of your contention. What is relevant?
My lords, it becomes,
Whether as on the date when the DPC met and took a decision, they could have taken a decision that a regular promotion under Rule 42 should be given to you,
yes,
or whether their decision to grant promotion only under Rule 32 was correct.
my lord,
So the subsequent events would not have been considered.
my lord, it becomes relevant for the simple reason, my lord. Because, my lord, the very, my lord, the promotion of mine under Rule 32 was for the simple reason, my lord, that, my lord, he was still, my lord, facing, my lord, departmental inquiry. My lord, that could not have been done in the normal course, as because the next eligible person, my lord, should have to be granted promotion. They cannot, my lord.
Only on that ground, if you have some decision, you please point. Don't go to the other contention that he was subsequently given punishment of censure and therefore he should reconsider. Adalla. Went before the tribunal immediately after decision was taken by the DPC.
DPC, my lord.
You question the such decision of the DPC.
DPC.
So therefore, subsequent events cannot be considered by the tribunal or by this.
My lord, it cannot be, my lord, termed as subsequent event, my lord, as because, my lord, as on the day of my filing my application, very much the order of censure was passed. Because I can take one.
Facts were relevant, which was taken into consideration by the DPC. Only that is required to be considered.
My lord, insofar as, my lord, the order, while passing the orders, my lord, DPC, my lord, they found, my lord, eligible, my lord, in all respects, my lord, insofar as, my lord, the next post is concerned. None eligibility, my lord, it was considered. The DPC considered, my lord, my eligibility. That is not in dispute. And, my lord, after, my lord, holding me eligible.
Or all you are required to point out is that for this reason, the decision of DPC was not correct. Please point.
And, my lord, the order, my lord, of promotion.
My lord, the
That is
tribunal,
at,
my lord, one
page
finding of the tribunal can't come to the finding is, my lord, page number 31.
56.
Page number 31.
Yeah, they have gone to other events,
Subsequent
events. That is not relevant.
Not relevant. No.
Yes.
Because, my lord, page 56, my lord, this is the. My lord, here, ರಾಜ್ಯ ಪೊಲೀಸ್ ಇಲಾಖೆಯ ಕೆಳಕಂಡ PI ವೃಂದಗಳಿಗೆ ವೇತನ ಶ್ರೇಣಿ ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ವೃಂದಕ್ಕೆ ಸ್ಥಾನಪನ್ನ ಮುಂಬಡ್ತಿ ನೀಡಿ ಆದೇಶಿಸಿದೆ. ಅದರಲ್ಲಿ, my lord, the seniors of mine, my lord, all three, my lord, that came. And ಭಾಗ 2ರಲ್ಲಿ ರಾಜ್ಯ ಪೊಲೀಸ್ ಇಲಾಖೆಯ PI KS
concerning you.
Concerning me, ಅವರಿಗೆ ವೇತನ ಶ್ರೇಣಿ ಸೋನ್ಸೋಕೆ 32ರ ಸಹಾಯಕ.
So we are only required to consider this aspect of the matter and the decision of the DPC with the facts that prevailed and enabled the DPC to take a decision.
Yes, but if
subsequent events cannot be taken into consideration.
My lord, if subsequent events, for a moment, my lord, let us assume, my lord, that subsequent events, my lord, could not have been taken.
Yes.
And, my lord, but the fact still remains, my lord, even, my lord, now, my lord, if I become, my lord, ineligible, even otherwise, my lord, also, my lord.
Not that you were not eligible.
Eligible idru kuda post illa.
Post, that post was
reserved,
earmarked for a scheduled caste candidate.
Yes, ma'am.
Therefore, that post was reserved.
Yes.
And you were not eligible to occupy that post.
Yes, ma'am. Very much.
Therefore, such a decision was taken by the DPC.
Then, my lord, in that event, my lord, the order of the censure does matter. Order date of the censure does matter.
Ad baradilla, ad aamele. That whatever he has to suffer, he will suffer. We are only concerned with your challenge raised to the decision of the DPC, which were taken under these circumstances.
If that is to be so, my lord, I was under the zone for consideration of promotion to the next post, and undisputedly, my lord, I was eligible in all aspects to be promoted.
Correct.
And, my lord, I was considered in the DPC and found to be fit.
Correct.
And there were no reasons for them, my lord, to promote me under Rule 32. Because there are
the last post, which which you were asking for.
Scheduled caste.
Was a post reserved for a scheduled caste candidate. Therefore, the DPC took a decision. All right, we will promote you under Rule 32.
That is wrong. because I was in the zone for consideration for.
Correct, correct.
I
Yes.
could not have been,
Why?
because, my lord,
There was no post available for you.
yes, my lord, no post available for me, my lord, but the rules does say, my lord, but once, my lord, the reserved candidate is not available, my lord, the next roster has to follow, and in the meanwhile, my
Not
lord,
available ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
andre, my lord, now that post is
Person was available.
available, but he was not fit. He was not fit.
No, 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 no. See, all these decisions are based on the subsequent decision taken by the competent authority. We see you questioned the decision of the DPC with these sets of facts. So you are required to restrain your contentions only in respect of these facts. Please don't go to the subsequent events.
Yes.
What was the facts available for the DPC for consideration?
The facts available.
Only on that aspect of the matter you can canvass.
Yes.
Not the subsequent events.
Yes, my lord. Even, my lord, if I could restrict my argument only to that extent, my lord, once, my lord, a charge sheet, my lord, is issued, my lord, it is well known as to, my lord, seal cover procedure has to be adopted. And seal cover procedure was adopted insofar as, my lord, the petitioner is concerned. And thereafter, my lord, the DPC met. DPC met, my lord, and no doubt, my lord, though I am senior, my lord, when the roster is operated.
How many posts were available?
4 more.
There was 4 posts.
Only 4 were available.
I was the 4th person.
Huh?
4 posts. I was the 4th person.
Excluding him.
My lord, it was it was his post, 4th post. But, my lord, since he was not fit, and, my lord, though my lord, I'm senior in the seniority list, my lord, when roster is operated, he will get the.
Huh?
Actually,
you were actually senior to him.
Actually senior to him, but when the roster is operated, it is his post. Roster operate ಮಾಡ್ತಾರೆ. ಆದ್ರೆ ಈಗ ಅವರು ಫಿಟ್ ಇರದೇ ಇರೋದಕ್ಕೆ, ಮನೋಡ್ ಜನರಲ್ ಅಲ್ಲಿ ಕೋರ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಕೊಡ್ಬೇಕು ಅದು ಕೊಡ್ತಾ ಬರ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ, ಮನೋಡ್, ವೆನ್, ಮನೋಡ್, ದಿ ಹಿಸ್, ಮನೋಡ್, that will be carried forward. That
then we'll have to remand the matter back to the tribunal, because all irrelevant consideration has gone into.
But what happens, my lord, here, since, my lord, addition ಈಗ ಅದು ಆತರ ತಗೊಂಡ್ರು.
The tribunal was required to consider this case only on the basis of the facts that were available for consideration of the DPC, not the subsequent events.
ಅದನ್ನು ಮಾಡಿದ್ದಾರೆ ಅವರು. ಅದನ್ನು ಮಾಡಿದ್ದಾರೆ.
ಅದ್ರ ಬಗ್ಗೆ ಮಾತ್ರ ಇದ್ರೆ please point out. Let us not go into the subsequent events. The punishment given to him, censure, ಅದು ಅವೆಲ್ಲ ಬರೋದೇ ಇಲ್ಲ ಇಲ್ಲಿ.
If it so happens, my lord, because when I'm aware, my lord, as on that day, my lord, an order of censure has been issued, and he was a party. He was a party to the proceedings before the tribunal.
But advocate engage ಮಾಡಿಲ್ಲ ಸುಮ್ಮನೆ.
See, mistakes committed by the advocate cannot be put on the parties.
ಇಲ್ಲ, even, my lord, we have response. ಅವರೇ ಬಂದಿದ್ರು personally. We have requested ನೀವು ಯಾರಾದ್ರೂ counsel ಇಡಿ ಅಂತ.
That cannot be taken as a waiver.
No, that
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Yes.
And, my lord, as on, my lord, that day, my lord, I was, my lord, and
please point out from the impugned order that there is consideration of the relevant provisions with these sets of facts. We will consider.
Yes, my lord. Here, it is from, my lord, 4th, page 28. My lord, page 28, para 4.
Para 4.
Para 4. From the pleadings and averments made by the learned counsel for the applicant in the application, it is clear that the seniority list of the police inspectors, which is a feeder cadre for the post of assistant commandants, has been finalized and published on 2/3/23 by second respondent as per annexure A1, which has a seniority list of local cadre of Hyderabad, Karnataka under Article 371J of the Constitution. Name of the applicant is at serial number 3 in the said list, and respondent number 5 is at serial number 6 in the local cadre of Hyderabad, Karnataka. Respondent number 5 belongs to scheduled caste category, as could be seen from the seniority list. The first respondent, by notification dated 4/3/23, by annexure A3, have promoted 3 officers of the rank of police inspectors.
See, if you were at serial number 3, how is it that promotion was given to other 3 persons?
No, may I draw the attention, my lords, at page 49.
Who should have been at serial number 3 then?
Page 49, seniority list.
49.
Page 49. ಈಗ ಅದರಲ್ಲಿ ಅನುಬಂಧ ಆದಲ್ಲಿ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಜಗನ್ನಾಥ್ BK ಅಂತಿದೆ. ಅದಾದ್ಮೇಲೆ ಶರಣ್ ಬಸವ
You are at serial number 3.
3. ಅದರಲ್ಲಿ ಇವರು 6 ಅಲ್ಲಿ ಇದ್ದಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 6. He is the only my lord.
First 3 persons ಗೆ
Please.
First 2% general, first two post are general.
General.
Third and fourth post are scheduled caste and scheduled tribe manner. 2 post are reserved for scheduled caste and scheduled tribe. ಇಲ್ಲಿ SC ST ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
Fifth one name.
ಇಲ್ಲ ಏನಾಗಿದೆ?
number 5.
My lord, what had happened, my lord? Serial number 1, 2 and 5 are promoted.
Serial number 5
1, 2, 5 are promoted.
Serial number 5 is
That
ST.
is why we are asking you, how is it that after 1 and 2?
ಇಲ್ಲ after 1 and 2 admittedly ಇವ್ರು ಬರ್ಬೇಕು. Because my lord ಇದು ಒಂದು ಇದು 5 ಬರ್ಬೇಕು. ST ಬರ್ಬೇಕು. 5 ಬರ್ಬೇಕು.
ST ಕೊಟ್ಟಿದ್ದಾರೆ.
1, 2 and 5.
1, 2 and 5.
1, 2, 5. ಅದಾದ್ಮೇಲೆ ಒಂದು ಶೆಡ್ಯೂಲ್ ಕ್ಯಾಸ್ಟ್ ಕೊಡ್ಬೇಕು 6th.
First roster point
ನಮಗೆ
schedule caste ಅಲ್ವೇನ್ರಿ?
Yes, what happens my lord? ಇದು ರೋಸ್ಟರ್ ಪಾಯಿಂಟ್ ಮೊದಲಿಂದ ಆಪರೇಟ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ
as on the date when the list was prepared, what was the availability, in which order it was available?
That my lord,
first post
government my lord,
second post is scheduled tribe, then general 2. General 2
my lord, what happens my lord in government department ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಪ್ರಮೋಷನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ earlier 33 cycle ಇತ್ತು.
Correct.
ಈಗ 100 cycle.
They'll continue from the cycle from where it was left.
Yes, when in most of the department what happens my lord, ಅವ್ರು ಒಂದು ರಿಜಿಸ್ಟರ್ ಮೇಂಟೈನ್ ಮಾಡ್ಬೇಕು. ಅಂದ್ರೆ 1, 2, 3 33 ಅಲ್ಲಿ ಬರುತ್ತೆ. ಅದಾದ್ಮೇಲೆ 1, 2, 3 33 ಬರ್ಬೇಕು. ಅವರು ಅದು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಲ್ಲ, DPC ಅಲ್ಲಿ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಲ್ಲ. ಆಮೇಲೆ ಅದು ನಾವು ಎಲ್ಲಿ ಈಗ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಕೇಳಿದ್ರೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಅವ್ರು. ಮಲೋಡ್ ಅದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಬಂದ್ರೆ ಅದರಲ್ಲಿ ಎಲ್ಲಿ ಕೊಡ್ಬೇಕು ಏನು ಅಂತ ಕರೆಕ್ಟ್ ಆಗಿ ಗೊತ್ತಾಗುತ್ತೆ. ನಾವು ಮಲೋಡ್ ಈಗ DPC ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಕೊಡ್ತಾರೆ ಅದ್ರ ಮೇಲೆನೆ ಹೋಗ್ಬಿಡುತ್ತೆ ಯೂಶುವಲಿ. ನಾವು ಬೈ ದಟ್ ಅಸಂಪ್ಷನ್ ಮಲೋಡ್ ಮಲೋಡ್ ಸೇಫ್ಲಿ ಅಡ್ಮಿಟ್ ಮಲೋಡ್ ದಟ್ ಅವ್ರಿಗೆ ಬರ್ಬೇಕಾಗಿತ್ತು ಅದು.
Then we will do one thing. We will remand the matter back to the tribunal. We will direct them that they will not take into consideration the subsequent events. They will not take into consideration the subsequent events. And they will call for the records. Let them call for records and see what was the manner in which the posts were available, promotional posts. Because we are not able to understand why, though you were at serial number 3, you were at serial number 3.
Yes,
why after 1, 2, it went to serial number 5?
That
what was the order of
roster operation
point? We are not aware. Neither you are aware, nor he is aware.
That is there.
Without looking into the records, all this has been done.
So that is one aspect. And my lord, now my lord, even if it is my lord held that I am my lord fit or unfit, my lord, again my lord, the next question comes, my lord, even that censure question comes. ಅದಾದ್ಮೇಲೆ censure my lord ಅದು ಬಂದೇ ಬರುತ್ತೆ ಅದಾದ್ಮೇಲೆ, because when his eligibility is counted, again my lord, it relates back to this.
So there again, you will have to participate in the next DPC. If the promotional cadre is available for you.
Yes, Lord. If
there are a second DPC has to take place.
Let them, my Lord.
Therefore, that is why we are saying, ಈಗ second DPC ಆಗೋಗಿದೆ.
ಇಲ್ಲ, ನಮ್ದು ಈಗ ಆಗಿಲ್ಲ.
Then they'll have to consider them. Consider along with him then.
My Lord, then my Lord, suitable orders may be passed. My Lord, with regard to taking into account, my Lord, even the censure part also.
Yes. That can be done.
Please let them take addition, my Lord.
So we'll set us. What is the directions given now by the tribunal?
Tribunal, my Lord,
give the retrospective promotion.
Respondents are directed to grant promotion to the applicant to the cadre of assistant commandant substantively under Rule 42. Retrospectively. So now that the disciplinary authority has taken a decision in his matter.
Yes.
And he will stake claim for promotion.
Yes.
Yes. Both of your consideration, both of your candidature should be considered by the next DPC.
Already
In
my
accordance.
case is already considered, my lord, by the.
ಆಗೋಗಿದ್ಯಾ?
ಆಗೋಗಿದೆ.
ನೆಕ್ಸ್ಟ್ DPC ಅಲ್ಲಿ
next DPCL ನಾನು promotion order
ಆಗಿದ್ಯಾ?
ಆಗಿದೆ promotion.
Where is it?
ಇಲ್ಲಿದೆ. I have. Because of KT order not issued.
ಅದೇ ಇವಾಗ ಓದಿದ್ರಲ್ಲ ನೀವು
ಅದೇ
DPC. ಅವ್ರದ್ದು ರದ್ದು ಮಾಡಿ ನನಗೆ
My lord, here, my lord, when the matter was reserved for orders, my lord, before the tribunal, my lord, this, my lord, DPC came to be, my lord, issued. And it is, my lord, thereafter consequential order agli or promotion agli yaudu kottilla. And still I remain to officiate under Rule 32 as of this day.
Promotion order, but not issued, passed but not issued.
ಆಗಿದೆಯಲ್ರಿ ನೋಟಿಫಿಕೇಶನ್ ಆಗೋಗಿ
ಇಲ್ಲ ಅವರು ಅದು ಏನೋ ಅನ್ಅಫಿಷಿಯಲಿ ತಗೊಂಡ್ಬಂದಿರ್ಬೇಕು, ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಇಶ್ಯೂಡ್.
ಎನಿವೆ
Because of tribunal order, my lord. In pursuant to the subsequent DPC, I was promoted, but the order is not issued to the petitioner because of tribunal order. That's only.
You understood what is the line of thinking of this court? Your application was based on the proceedings drawn in that DPC.
Yes.
You said, no, they should not have, they should have given regular promotion under Rule 42. With the sets of fact that were available before the DPC, whether the decision taken is correct or not was what was required to be considered by the tribunal. But they have gone on the subsequent events, which was not what was to be considered by the tribunal.
Yes, well, even that way, my lord, taken into consideration also, my lord, when, my lord, I am in the zone for consideration for promotion. My lord, I ought to have been, my lord, I ought to have been, my lord, given under Rule 42, because when I am in the zone for, if I am not considered for, that is a different aspect. When I am considered for promotion, they'll have to do it correctly.
For that one, the questions that was now put by the court was what the relevant questions which should have been considered by the tribunal. They should have called for the information as to what were the order of posts that were available for promotion. Why after serial number 1 and 2, it was given to serial number 5.
But even otherwise, my lord, if he, my lord, if it is concluded, my lord, that, my lord, he, my lord, by way of the operation of roster, my lord, he should have been considered first. My lord, still my case remains for the simple reason, my lord, that I was in the zone for consideration of promotion, and as on that day, my lord, he was facing departmental inquiry and he was unfit. He was unfit. So if those facts are taken into consideration also, my lord, my case stands. That is my.
My lord.
What will happen in the normal course? Okay, suppose he was completely exonerated.
Then, my lord, I had no, my lord, I'll have to, my lord.
ನಿಮ್ ಕೊಟ್ರ ಪ್ರಮೋಷನ್ ನ ತೆಗಿತಾರ?
ಇಲ್ಲ, ಅವ್ರು ರೂಲ್ 32 ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಅವರಿಗೆ ರೆಗ್ಯುಲರ್ ಅವ್ರಿಗೆ ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ಲಿ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಅವ್ರಿಗೆ ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ಲಿ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಜಾನಕಿ ರಾಮನ್ಸ್ ಕೇಸ್ ನೋಡಿ ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ಲಿ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
That is if vacancy is available.
No, my lord, I'll have to ನನಗೆ ರಿವರ್ಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ನನಗೆ ರಿವರ್ಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ, ನನಗೆ ರಿವರ್ಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಬಟ್ my lord, ನಾವು ಸಿನ್ಸ್ ಓನ್ಲಿ ಫಾರ್ ದಿ my lord ಸೆನ್ಶೂರ್ ಇರೋದ್ರಿಂದ ಅವ್ರಿಗೆ ತೊಂದರೆ ಅಷ್ಟೇ.
Therefore, if you want to challenge this subsequent DPC, it is open for you. This consideration could not have been done in your application, is what we are saying.
Because as on that day, my lord, if it was my, my lord, censure iradrinda, my lord, it was my duty to, my lord, and as on that day, my lord, ನನಗೆ, my lord, that order was also, my lord, available ಇರಲಿಲ್ಲ. I took a contention saying as to censure ಅಂತ order pass ಮಾಡಿದ್ದಾರೆ, that later ನಾನು ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಅಂತಾನು ಇದು ಮಾಡಿಲ್ಲ. ಅವರೇ ಅದಾದ್ಮೇಲೆ ಅವರೇ ಏನೋ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ.
My lord, reservation.
This was the.
My lord, this honorable court, my lord, reservation is concerned. when the reserved candidate is not available at the time of that post may be
Carried forward ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
not carry forward manner. It is treated as a backlog vacancy.
ಮತ್ತೆ ಬ್ಯಾಕ್ಲಾಗ್ ಮಾಡಿ ಮುಂದೆ ಅದು ಯಾವಾಗ ಬರುತ್ತೆ ಅಡಿಷನಲ್ ರೋಸ್ಟರ್ ಪಾಯಿಂಟ್ ಅಲಾಟ್ ಮಾಡಿ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
Therefore, ನಿಮ್ಗೆ ಅಲ್ಲಿ ಕೊಡೋದಕ್ಕೆ ಪೋಸ್ಟ್ ಇರ್ಲಿಲ್ವಲ್ಲ.
ಇಲ್ಲ ಬಟ್ ಆಸ್
How can you stake claim, sir?
it should be as on that day, my lord.
As on the date when the DPC considered your candidature.
Yes, my lord.
There was no post available.
There was a post, my lord. There was a post.
ಯಾವುದು?
The fourth post. The fourth post was there. Available vacancy, clear available vacancy.
That is reserved post, my lord.
Reserved post ಅದು.
Reserved post ಇರಬಹುದು. ಆದ್ರೆ my lord, when reserved person is not available, my lord, it will pass on to the it will pass on to the regular incumbent.
These were the proper provisions and something that should have been considered by the tribunal, not the subsequent events.
My lord, fact of
Even, my lord, let them, my lord, consider that, my lord, even that aspect also, even the censure, even my DPC, even his DPC, let them consider.
ಇವಾಗ ಆಗೋದಿಲ್ಲ. You are at liberty. If you don't get a posting, a regular posting, a promotion, in terms of the consideration of relevant provision, subsequently, when a promotion is given to him under the next DPC, if you are agreed with that, you can question it.
But no.
ಇಲ್ಲಿ ನಿಮ್ಮ ಈ application ಅಲ್ಲಿ, those were not the relevant considerations which should have been gone into by the tribunal.
But my lord, there is no order available for me to challenge. Only DPC ಬಿಟ್ರೆ ಮುಂದೆ ನನಗೆ ಚಾಲೆಂಜ್ ಮಾಡೋದಕ್ಕೆ ನನಗೆ ಏನು ಇಲ್ಲ. I could have challenged other.
ಇನ್ನು ಮಾಡಿಲ್ಲ, ಮಾಡ್ತಾರೆ, ಅದು ಬೇರೆ ವಿಚಾರ. ಏನಿದು?
Judgment backlog vacancy, treating the backlog vacancies.
ಯಾವ್ದು, ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
My lord, fact of the case is, my lord, first paragraph itself, my lord. These writ appeals are arise out of order dated 28/9/5/1990 of this court in writ petition number so and so. The petitioner, one by name MP Jaishankar, working as Deputy Development Officer in Karnataka Industrial Area Development Board. So I had prepared the writ petition being agreed by action of the employer. Board in notifying the post of development officer, a promotional post to persons working in the cadre of deputy development officers as post to be filled up by the promotion from among eligible candidates belongs to scheduled caste and scheduled tribe community, as the post as being notified as backlog vacancy and had eliminated opportunity to the persons like petitioner. My lord, after considering all these things, my lord, the honorable, this court, my lord, para 30, my lord.
30.
Yes. Karnataka Scheduled Caste, Scheduled Tribe and Other Backward Classes Reservation of Appointment Act 1990, which received the assent of the President on 4/3/1991, published in Official Gazette 7/3/1991, read with Karnataka Scheduled Caste, Scheduled Tribe and Other Backward Classes Rules 1992, in terms of notification dated 22/12/1993, which is a piece of legislation which makes to it compulsory for providing reservation in favor of scheduled caste, scheduled tribe and other backward classes to the extent provided for from time to time in orders made by the government under clause 4 of Article 16 of the Constitution of India. Such orders are deemed to be an order under this very enactment and made applicable mutus mundis to services and posts in the public sector, and as the board is undoubtedly an establishment in public sector, all the orders which are preferred to earlier and force undoubtedly are relied upon by the PS Rajgopal and Council for the appellant in WA number so and so have the force of law made by the legislature, and therefore the appointment made in favor of the appellant while filling up the post backlog vacancy in respect of the post reserved for scheduled caste person is definitely a valid appointment and in consumption with the act and the constitutional provisions. After the conclusion of the this honorable court, my lord, page number 34. the writ petitioner, in our view, it is not entitled for such benefit to two reasons. Firstly, when once it is held that providing for reservation to post of development officer is valid and sustainable, and if the vacancy in the post of development officer as per the roster point become available to a personal belonging to scheduled caste, notwithstanding the fact that writ petitioner might have been senior to such person in the scheduled caste category, the person cannot claim promotion at that point of time, as no vacancy arose for being filled in the general category. Therefore, writ petitioner and appellant in
All
the
right, we'll do one thing. As we said earlier, we will remand the matter back to the tribunal. Let them call for the records and reconsider as the facts available as on the date when the DPC took the decision. Whether they could have placed in, given you promotion under Rule 32, or whether it was permissible for them to give a promotion under Rule 40. That's all. No other consideration.
May I request, my lords?
Yes.
Kindly say, instruction is, my lord, para 4 of the, my lord. Whether, my lord, fifth respondent is, my lord, entitled for prospective or respective. That is the clarification is given by the department, my lord, para number 4. This on report, my lord, order dated 16/2/2024, my lord, directed us to para 4. That is the explanation by the department.
ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದೆಯಾ?
ಇಲ್ಲ ಸರ್, that is only one.
ಏನ್ ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ? This is the first time that the post of assistant commandant is being promoted.
Yes.
First time ಅಂದ್ರೆ ಫಸ್ಟ್ ಸೈಕಲ್.
ಎಸ್ ರಿಸರ್ವ್.
ನೀವ್ ಹೇಳೋ ತರ ಇದು ಮುಂಚಿಂದ ಯಾವ್ದು ಇಲ್ಲ. So the very first post is to be reserved for SC. That is what they have said here.
Yes.
So all the information that you have got is incorrect. This is the first time that the post of assistant commandant is being promoted. On 24/2/2023, there were 4 vacancy posts vacant in HK cadre, and having found that the petitioner, who was at serial number 6 in HK cadre PI seniority list and belongs to SC category, was facing departmental inquiry. The first post, it is not the third or fourth one as you were trying to say. First post was to be earmarked for him.
Maybe, my lord, yes.
Aita, it is pertinent. The petitioner, it is pertinent to mention here that as per first cycle of roster point, the first post reserved for SC category as per circular dated so and so, which both of you are familiar. The first post was to be reserved for scheduled caste candidate. So therefore, he was to be posted at serial number 1. With a notification dated 4/3/2023 at annexure 3 in this writ petition, 3 police inspectors were considered for promotion as assistant commandants as per seniority list. The remaining 1 post of assistant commandant was considered for keeping the 5th respondent belonging to GM category under Rule 32.
I believe, my lord, it is the third roster point. It must be for scheduled caste.
This is the
Third.
This
Third.
is
And
the-
the first post of scheduled caste when roster is operated, ಮೂರನೇ ಸ್ಥಾನದಲ್ಲಿ ಏನೋ ಬರ್ತಾರೆ
ಮೂರನೇ ಸ್ಥಾನ
3-7 ಈ ತರ ಇದೆ.
ಇಲ್ಲ ಫಸ್ಟ್ ಪೋಸ್ಟ್ ರಿಸರ್ವ್ ಮಾಡಿ
ಫಸ್ಟ್ ಪೋಸ್ಟ್ ಇರ್ಬೋದು, ಫಸ್ಟ್ ಪೋಸ್ಟ್ ಆಫ್ ರಿಸರ್ವೇಶನ್ ಇನ್ ಶೆಡ್ಯೂಲ್ ಕ್ಯಾಸ್ಟ್ ಥರ್ಡ್ ಪೊಸಿಷನ್ ಅಂದ್ರೂ ಕೂಡ ಬರ್ತಾರೆ.
ಅಂದ್ರೆ ನನಗೆ ಪ್ರಮೋಷನ್ ಬರುತ್ತೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಮಲೋಡ್ ವೆನ್ ಮಲೋಡ್ ಯಾವಾಗ ಕೊಡ್ಬೇಕು ರೋಸ್ಟರ್ ಅಲ್ಲಿ 1, 3, 7, 12, 21 ಯಾವ ತರ ಕೊಡ್ತಾ ಬರ್ಬೇಕು.
One is SC, isn't it?
ಥರ್ಡ್ ಇರ್ಬೇಕು.
1
ಐ ಬಿಲೀವ್ ಮಲೋಡ್
ಇದು ತೆಗಿರಿ
33 ಸೆಕೆಂಡ್.
SC ST ಬ್ಯಾಕ್ವರ್ಡ್ ರಿಸರ್ವೇಶನ್ ಇದೆಯಲ್ಲ ಅದ್ರಲ್ಲ ಇದು ರೋಸ್ಟರ್ ಪಾಯಿಂಟ್ಸ್ ಇದೆ.
ಫಸ್ಟ್ SC ಬರುತ್ತೆ. But
even otherwise, my lord, we can find it in my lord, the DPC.
My lord, ಇಲ್ಲಿ DPC ಅಲ್ಲಿ page number 66 ನನ್ನ ರಿಟ್ ಪಿಟಿಷನ್ 66
ರೋಸ್ಟರ್ ಪಾಯಿಂಟ್ ಬ್ಲಾಕ್
ಅದು ಕೂಡ ಆಗಿದೆ. ಪೇಜ್ ನಂಬರ್ ಇಂಕ್ ಪೇಜ್ 66
ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಮಲೋಡ್
66 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಮಲೋಡ್
ಇಲ್ಲ ಅದರಲ್ಲಿ
ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ಗ್ರೂಪ್ ಎ ಹುದ್ದೆ ಕಿರಿಯ ಶ್ರೇಣಿ ವೇತನ ಶ್ರೇಣಿ ರೂಪಾಯಿ 52,652 ಹುದ್ದೆ ಆಗಿದ್ದು ಮೀಸಲಾತಿ ಅನ್ವಯವಾಗಿರುತ್ತದೆ. ಸಹಾಯಕ ಕಮಾಂಡೆಂಟ್ ವೃಂದದ ಅಧಿಕಾರಿಗಳಿಗೆ ಪದೋನ್ನತ ಮುಂಬಡ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ರನ್ವಯ
ಒಂದನೇ ವೃತ್ತದ 1ನೇ ಬಿಂದುವಿನಿಂದ ಬಡ್ತಿಗೆ
ಮುಂಬಡ್ತಿಗೆ ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ.
ಇಲ್ಲ ದಟ್ ಮೇ ನಾಟ್ ಬಿ ದ ಕರೆಕ್ಟ್ ಪೊಸಿಷನ್ ಮಾಡ್ರಿ. ಯಾಕಂದ್ರೆ ಒಂದನೇ ವೃತ್ತ ಅಂದ್ರೆ ಒಂದನೇ ಸೈಕಲ್, ಫಸ್ಟ್ ಸೈಕಲ್. ಬಿಂದು ಅಂದ್ರೆ 1ನೇ ಬಿಂದು ಅಂದ್ರೆ ಶೆಡ್ಯೂಲ್ ಕ್ಯಾಸ್ಟ್ ಅಲ್ಲಿ ಇಷ್ಟು ಕೊಡ್ಬೇಕು, ಅದರಲ್ಲಿ 1ನೇ ಬಿಂದು ಅಂದ್ರೆ ದಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ ಅದರಲ್ಲಿ 33 ಸೈಕಲ್ ಅಲ್ಲಿ
ಪ್ಲೀಸ್ ಅವ್ರು ಕೊಡ್ರಿ ಅವ್ರಿಗೆ, ಪ್ಲೀಸ್ ಗಿವ್ ಇಟ್ ಟು ಹಿಮ್, ಕೊಡ್ರಿ ಅವ್ರಿಗೆ.
ಸರ್ಕಲ್ ಅಂದ್ರೆ ಒಂದ್ ಸರ್ಕಲ್ ಮುಗಿಯೋವರೆಗೂ ಒಂದ್
ಸರ್ಕಲ್ ತೆಗಿರಿ
1978 ಸರ್ಕುಲರ್.
Anyway, these were the relevant considerations which should have been gone into. We cannot accept this order which is based on the subsequent events. ಬರೋದಿಲ್ಲ, ಅದು ಇನ್ನೊಂದ್ಸರಿ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್.
But my
when he is to be reconsidered now in the next DPC, if you are agreed, you can challenge that one. And as on the date when you filed the application, it was on what grounds?
It was
only that one should have been considered by the tribunal. Not the subsequent event.
My lord, ink page 31, my lord, of the judgment of the tribunal, contrary to their own observation, come to the wrong conclusion. My lord, page number, ink page 31.
We'll continue. We'll continue at 2:30. ಅದನ್ನ ಸ್ವಲ್ಪ ತೆಗ್ದಿಡ್ರಿ. ಆ ರೋಸ್ಟರ್ ಪಾಯಿಂಟ್ಸ್, that also we'll consider. Sorry, Angara will continue.
CL number 3030, Siddharuda B. Pujari.
Lord. I have found, my lord, it is the first, my lord, scheduled caste, second scheduled tribe, third unreserved. Now, my lord, coming to seniority list at page 49. Serial number 6, my lord, he has to come first. Says he is the only, my lord, the scheduled caste.
But I'm sorry.
Serial number 5.
I'm very sorry, my lord. We are producing that girl, my lord.
Bandra,
Basappa.
here one second.
Please, please.
Yes.
Writ of habeas corpus petition. Ilapa error.
Lord, I pray for Pasore. Her parents are coming on the way. They are coming from Raichur. I called them. I pray for Pasore.
ಎಷ್ಟೊತ್ತಾಗುತ್ತ್ರಿ?
ಅರ್ಧ ಗಂಟೆ. Half an hour. They are already nearby city, Gulbarga city. Half an hour.
First to hear this lady.
Barley, let them come.
Yes.
We'll see if it's necessary, we will.
Half an hour.
Yes. No. If it is necessary, we will pass over. We will hear the matter.
Say, allowed to come that side.
Huh?
You want to say, my lord, before also. Allowed to come to that side.
Baram.
Go.
Let it happen in the presence of their parents, because he is minor.
It is better if the parents are not there.
All right.
ಅರ್ಥ ಆಯ್ತಲ್ಲ?
All right.
It is better.
ಈ ವಿಡಿಯೋ
Cut now. ಅದನ್ನ we'll have to consider in the light of these facts. When that post was not filled up by anyone, it was kept vacant.
Yes.
Now that he is eligible to be posted.
I understood. But here, my lord, the PPP rules comes into
Anyway,
picture.
that is not something that this court can consider now.
Please.
The tribunal also could not have gone into these aspects of the matter. We are of clear opinion that your application was required to be considered on the basis of the decision taken by the DPC, having regard to the facts obtained as on that date. These are subsequent events, and you may get a cause of action to raise a challenge if now a posting is given to this person promoting from that retrospective date. It will be open for you to raise a challenge. Now, would you want this matter to be remanded only for, I don't think it will serve any purpose.
My lord, even my lord, in so far as my rights are considered, my lord, the PPP.
The matter to be remanded, we'll remand. No difficulty.
My lord, here, since my lord, there are so many other issues like my lord, the pension, promotion and PPP rules. My lord, wherein my lord, under which circumstances, my lord, the retrospective promotions can be made. In one such, my lord, clause, my lord, my case falls. My lord, if I can canvass, my lord, or otherwise, my lord, if it's remitted, my lord, I will.
We will do that. We will remit the matter with these observations. Huh? Merkel. The petitioner who was respondent number 5 before the Karnataka State Administrative Tribunal in application number 20275 of 2023. He is before this court. Aggrieved of the impugned order passed by the tribunal on 13th of August 2023. Full stop. Next para. The undisputed facts that led to the fifth respondent herein filing an application before the tribunal is that in terms of a copy, in terms of the final seniority list prepared on 2/3/2023, six persons who were working in the cadre of police inspectors in the Karnataka State Industrial Security Force, bracketally KSISF, Kalaburagi, were enlisted, were shortlisted for consideration before the DPC for promotion to the cadre of assistant commandant.
Yes. Yes.
comma, under the local cadre under Article 371 bracket J of the Constitution of India. Full stop. The petitioner herein was at serial number 6, comma, belonging to the scheduled caste category. Full stop. Respondent number 5 was at serial number 3 under the general category. Full stop. However, since departmental inquiry was pending, departmental inquiry and disciplinary proceedings were pending against the petitioner herein, the DPC took a decision on Elidadu.
Annexure C. Annexure C, madam.
Annexure C.
Page 64. On 4/8/2023.
On 4/8/2023. To promote the officers at serial number 1 and 2
And also 5.
Huh?
And 5 also.
I think what is the reason there? 5, how could he come up?
5, my lord, ST.
Serial number 3 bರುತ್ತೆ.
Serial number 5 ಅಲ್ಲಿ scheduled tribes.
Serial number 2. In the roster point, second one will be scheduled tribe.
Yes.
Probably for that reason.
Yes, 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 yes.
But ಅದನ್ನ ಇಲ್ಲಿ ಸರಿಯಾಗಿ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿಲ್ಲ ಅವರು. ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ.
ಹಾ?
ಬರೀ ಈ ದಿಸ್ ಪೋಸ್ಟ್
ಇಟ್ ಇಸ್ ಬರೀ ಎಸ್ ಮಾತ್ರ ಹೇಳಿದ್ದಾರೆ.
ಅದು ಆಲ್ರೆಡಿ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಸ್ ಟಿಗೆ.
ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್. ಇಟ್ ಇಸ್
ಪ್ರಮೋಟೆಡ್.
ಅಲ್ಲ, ದೇರ್ ಇಸ್ ನೋ ಡಿಸ್ಕಷನ್ ಇನ್ ದಿ ಇದು.
ಇದರಲ್ಲಿ ಮಾಡಿ
1 and 2 in the general category and serial number 5 Sri Gujjala Bhimesha at serial number 5, comma, since he belonged to scheduled tribe category. Full stop. The number of posts available for promotion was 4. Full stop. The DPC expressed its opinion that since the promotion to the post of assistant commandant was being given for the first time, and in terms of the reservation roster points, the post at serial number 1 should be given to a scheduled caste person, and at serial number 2 it is to be given to scheduled tribe person, and the third was to be given to unreserved category.
third and fourth. 3 and 4. As per the roster, 1 and 2 are the reserved post. 3 and 4 are unreserved.
Actually, this is not the roster point. It's a different thing.
Yes.
This is not the roster points.
ಇಲ್ಲ, ಶ್ರೇಷ್ಠ
ಲೈನ್ ಆಗಿದೆ.
ಕ್ರಮ ಸಂಖ್ಯೆ ಅಂತ ಹೇಳ್ತಾರೆ. 1 to 5 ಅಂತ ಹೇಳ್ತಾರೆ.
Where is that?
Only
Not available here?
not available.
ಇಲ್ಲ ಇಲ್ಲ. ಇಲ್ಲಿ ನೋಡಿ, ತಹಸೀಲ್ದಾರ್ ಬಂದ ತಕ್ಷಣ ಇಲ್ಲಿ ಚೇಂಜ್ ಆಗುತ್ತೆ. So this is not the roster points which are issued by the government. Anyway, we will take it at 3 unreserved.
Yes.
Comma. And since it was not permissible in law to promote the fifth respondent herein to a post which is reserved for a scheduled caste person, it was decided that promotion may be given to the fifth respondent under Rule 32. Full stop. Questioning, they said the decision of the DPC, the fifth respondent approached the Karnataka State Administrative Tribunal by filing application number 20275 of 2023, arraying the petitioner herein as respondent number 5. Full stop. The tribunal accepted the contentions made on behalf of respondent number 5 herein, that having regard to the subsequent events where the disciplinary proceedings against the petitioner herein ended with imposition of censure, singular comma censure, and having regard to a decision of the Honorable Supreme Court in the case of Union of India and others versus A.N. Mohanan, (2007). Bracket 2007, close 5 SCC 425. The tribunal came to a conclusion that the petitioner herein can only stake claim for promotion in the next DPC, prospectively. Full stop. Accordingly, the tribunal allowed the application filed by the fifth respondent herein and directed the respondent state to grant promotion to the fifth respondent to the cadre of assistant commandant substantively under Rule 42 of the KCSR retrospectively from the date on which he was eligible and to grant all consequential benefits, including seniority and pay in accordance with law. Full stop. Next paragraph. Learned counsel for the petitioner submitted that the tribunal erred in taking into consideration the judgment of the Honorable Supreme Court in the case of A.N. Mohanan, bracketally Supra. Full stop. It was further contended that it is straight law that a promotional post reserved for a person belonging to scheduled caste category, belonging to the reserved category, cannot be filled by a person belonging to the unreserved category. Full stop. Moreover, the said promotional post reserved for scheduled caste person, a scheduled caste category, was not filled in terms of the directions issued by the DPC. Full stop. It was kept open for consideration of the sealed cover insofar as the petitioner is concerned. Full stop. Next para. For contra, learned counsel for the fifth respondent would contend that ಅದೆಲ್ಲಿದೆ ಅವದು ನಿಮ್ದು ಇದ್ರದ್ದು ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Annexure C, my lord, page 64.
64.
By cancelling the rule, placing the by cancellation of the placing the fifth respondent under Rule 32.
64 already. 64 is annexure C.
64.
62 na.
ಇಲ್ಲ 64 my lord. 64 annexure
64 is annexure C. ಅದಲ್ಲ ನಿಮ್ಮ ಇದ್ರದ್ದು ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಇದೆ 64 ಅಲ್ಲಿ DPC
ಅಲ್ರಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ಡರ್ ಬಂತಲ್ಲ ಬೈ ದಿ ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ. ವೇರ್ ಇಸ್ ದಟ್ ಆರ್ಡರ್? ಅವಾಗಲೇ ತೋರ್ಸದ್ರಲ್ರಿ ದಟ್
ಅದು ಪ್ರಮೋಷನ್ ಆರ್ಡರ್.
ಪ್ರಮೋಷನ್ ಅಲ್ಲ, ಪ್ರಮೋಷನ್ ಅದು 4th of August. 4th of August ಇದೆ.
4th of August 23 is the DPC proceedings. Annexure C is the DPC. Government ನವರು ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, when was that order passed? After the conclusion of the departmental proceedings against you, when was that order passed? ಇದರಲ್ಲೇ ಇದೆಯಾ? annexure C ಅಲ್ಲಿ ಇದೆಯಾ?
Yes, here 4th August 23.
That is decision of the DPC, sir.
That is the consequential order, my lord, not yet issued.
ಅಲ್ಲ ಅದಲ್ಲ. See, after the conclusion of the departmental proceedings, the order of censure was passed.
Yes.
Where is that one? Annexure C ಅಲ್ಲಿ ಹೇಳಿದಾರಾ ಅದ್ರ ಬಗ್ಗೆ?
ಇಲ್ಲ ಅದರಲ್ಲಿ
Must be.
Yes, my lord, here, annexure C, my lord. Para number 2.
Para number 2.
ಇದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ವಿಚಾರಣೆ ಮುಗಿದಿದ್ದು ಸದರಿಯವರಿಗೆ ಪ್ರಕರಣದಲ್ಲಿ ದಿನಾಂಕ 28/3/2023
ವಾಗ್ದಾನ.
ಕರೆಕ್ಟಾ?
Yes. ವಾಗ್ದಾನ.
ಏನಂತ? Content that after conclusion of the departmental proceedings against the petitioner herein, the disciplinary authority proceeded to pass an order on 28/3/2023 imposing the punishment of censure, and thereafter in the next DPC held on 4/8/2023 a decision was taken to grant promotion to the petitioner herein. Full stop. Therefore, it was contended before the tribunal that punishment of censure imposed on the petitioner is also a punishment, and therefore he cannot be retrospectively promoted in terms of the judgment of the Honorable Supreme Court. Full stop. Having heard the learned counsels, alli innond paragraph sesku. Learned government advocate has today placed the information which was earlier called for at the hands of the respondent state. Full stop. The learned AGA pointed out that the DPC took note of the fact that the promotion to the post of assistant commandant was being given for the first time, and therefore they were required to consider grant of promotion having regard to the reservation roster points. Full stop. The DPC took note of all these aspects and came to a conclusion that since the fifth respondent cannot be appointed, cannot be promoted to the post of assistant commandant, which was reserved for a scheduled caste category, it was decided that the fifth respondent may be promoted under Rule 32 on temporary basis. Full stop. Next paragraph.
I also relied the judgment of this honorable court.
We will say that was not the relevant consideration. We will keep all that open. If subsequently there is any need for you to challenge it in those lines, you can do it. Having heard the learned counsels and on perusing the petition papers, we find that the fifth respondent herein had approached the tribunal immediately after the decision of the DPC to promote the officers at serial number 1, 2, and 5 and to reserve the post at serial number 1, which was meant for scheduled caste category, and await the results of the disciplinary proceedings which were underway against the petitioner herein.
My lord, one
Full stop.
submission, my lord, in this regard. My lord. For that page 41, my lord. Lordship, I have, my lord, specifically stated, my lord, with regard to, my lord, the censure and, my lord, even the copy and all, my lordship may kindly.
41.
My lord, page 41. Grounds alle para 3B2. 3B2 only. It is to submit that after the issuance of the promotion orders, the fifth respondent has been imposed with the punishment of censure, thereby making manager for claiming any regular promotion retrospective. A copy of the same would be produced at a later stage. It is well settled that the imposition of censure would only entitle an official for promotion prospectively and not retrospectively. A copy of the circular dated.
You may have taken the ground also.
Yes.
But that would be irrelevant for the consideration.
Yes.
Because you sought to question the decision of the DPC.
Yes, sir.
Which was taken at on yavatado data?
4/3/23.
4/3. ಅವಾಗ ಇನ್ನು dispute proceedings were pending. So therefore, what was taken into consideration by the DPC
Please.
was required to be reconsidered by the tribunal. This question of being imposed with the punishment of censure was not the facts available before the DPC. That was not the ground on which the Rule 32 promotion was given to you.
Yes, my lord.
Correct,
As
alva?
on the.
Therefore, that is what you are finding. You may have taken that ground subsequently, but your contention, your challenge was in regard to the decision taken by the DPC at that relevant point of time.
Yes.
Where these were all subsequent events, which were not considered by the DPC.
Not considered by the DPC.
Correct. So therefore, you will have to restrain your contention as regards the decision taken by the DPC at that point of time. No doubt, subsequently, all these events have happened. Now there is a reconsideration. There is a second DPC that is held. If you are aggrieved of that one, you may challenge it.
Again, my lord,
but
that.
what was required to be considered by the tribunal was whether the decision taken by the DPC at that point of time was correct or not.
Some, my lord, findings are there of the tribunal with regard to.
Whether that would be sufficient. Adanna pakkakku itbiಟ್ಟು they have gone only on this ground. Subsequently he has been imposed with this punishment, and therefore at any rate he will not be eligible for promotion retrospectively. That was the line of the decision of the tribunal.
Now, my lord, even considering the subsequent, if my thing, my lord, remains the same also, my lord. My lord, I would, my lord, since already I was in the zone for consideration, considered, and my lord, it could not have been taken back.
That is why we are saying the tribunal was only required to consider whether the decision of the DPC at that point of time not to grant you substantive promotion under Rule 42 was correct, or whether their decision to give promotion under Rule 32 was correct. That is what is required to be considered.
42 not granted to him.
32.
32 ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
32.
And the
42 ಅಲ್ಲಿ ಕೊಡಬೇಕಾಗಿತ್ತು, ಕೊಡ್ಲಿಲ್ಲ ಅಂತ our contention. Whether that decision of the DPC was correct or not is something that is required to decide. not with regard to the subsequent developments. Of course, we are repeating again and again. Now the second DPC has been held. A decision has been taken. Recommendation has been made that he shall be granted promotion.
And also,
ಅವ್ರೇನಾದ್ರು ಅದ್ರ ಮೇಲೆ ಏನಾದ್ರು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ ಪ್ರಮೋಷನ್ ಕೊಟ್ರೆ you will get a new
then I will get a cause of action to challenge.
question later. Full stop. ಇನ್ನೊಂದ್ಸರಿ ಹೇಳಿ. ಅಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್ ಪ್ಯಾರಾಗ್ರಾಫ್. Under those circumstances, what was required to be considered by the tribunal was whether the decision of the DPC in recommending grant of promotion under Rule 32 to the fifth respondent herein was valid or not. Full stop. In the considered opinion of this court, the tribunal could not have gone into the subsequent events, that is, the imposition of penalty of censure on the petitioner herein and whether the petitioner herein would be entitled for retrospective promotion. Full stop. That was not the issue before the tribunal. Full stop. No doubt. Comma, if subsequently another DPC was held and a recommendation is made in the DPC to grant retrospective promotion to the petitioner herein, comma, it will be a subsequent cause of action for the fifth respondent to raise a challenge. Full stop. We should also notice at this juncture the submission made by the learned counsel for the petitioner that the decision of Mohanan, the decision in A.N. Mohanan bracket Supra will have to be considered having regard to the relevant rules governing the promotion of the parties herein, along with the fact that the post that was reserved for scheduled caste category was not filled up by the DPC, was not recommended to be filled up by the DPC. Full stop. Therefore, comma, the petitioner may also contend that the decision in A.N. Mohanan cannot be straightaway applied to the facts of these cases, facts of this case. Full stop. Nevertheless, comma, these are all issues that may require consideration if a challenge is raised by the fifth respondent herein to the decision taken in the subsequent DPC. Full stop. Next para. Consequently, we allow the writ petition in part. Full stop. The impugned order passed by the Karnataka State Administrative Tribunal, Kalaburagi bench in application number 20275 of 2023, dated 13th of August 2023, is hereby quashed and set aside. Full stop. The matter stands remitted back to the tribunal to reconsider the grievance of the fifth respondent herein. Having regard to the facts obtained before the DPC when it took the decision on
DPC decision.
the data?
DPC.
4/8/2023.
4/8/2023.
Annexure C, case 64, 4/8/23.
This is a subsequent one.
Adultery.
Earlier.
Clearly. Not in our para number 4, my lord, this is 24/2/2023. In our para number 4, my lord, admitted fact that DPC was conveyed on 24/2/2023.
ನಿಮ್ಮ application ಅಲ್ಲಿ ಏನ್ರಿ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು?
My lord, the promotion order, my lord, under rule 32.
Notification. Decision of the DPC and notification issued on 4/3/2023. Correct?
Yes.
Full stop. Ordered accordingly.
My lord, time limit. Time limit maybe.
ಅಲ್ಲ ರೀ ನಿಮ್ಗೇನ್ ತೊಂದ್ರೆ ಇದೆ ಈಗ?
ಅಲ್ಲ ನಂಗೆ ಪ್ರಮೋಷನ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. ಡೈರೆಕ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಟು ಇಶ್ಯೂ ದಿ ಪ್ರಮೋಷನ್ ಆರ್ಡರ್. Because of the impugned order passed by the tribunal, promotion order not issued, my lord. Passed but not issued.
When these issues are, my lord, still, my lord, to be heard by the tribunal. My lord, now how can, my lord?
It is a result post, my lord. I am entitled, my lord.
My lord, that has to be decided, my lord, by taking the observations of this court.
But ಈ subsequent DPC ಅಲ್ಲಿ he was not reconsidered.
Reconsidered, cancel his 32, my lord. ಮಾಡಿ ನಾನು ಪ್ರಮೋಟ್ ಮಾಡಿದೆ.
So ಅವ್ರಿಗೆ ಟೋಟಲ್ ಆಗಿ ಹೋಯ್ತು.
Yes. Yes.
Order issue ಮಾಡಿಲ್ಲ ಅವರು.
Order pass ಮಾಡಿದ್ದಾರೆ, issue ಮಾಡಿಲ್ಲ.
That you are not even questioned.
ಇಲ್ಲ ನನಗೆ the order is not available for me to challenge. Only DPC ಮಾಡಿ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
That is why we said as and when you get a cause of action, you can challenge.
Yes, I will.
My lord,
not going to say anything about.
Allah, first respondent directed to issue the promotion order.
If that is so,
because
then
I am suffering unnecessarily.
Lord, when everything is observed, now it will
get the promotion.
Nothing will remain for me to, my lord.
When we have said the tribunal could not have gone insofar as the subsequent events are concerned, how can we in that application direct the authorities to grant you?
You only challenge 32 promotion, my lord.
Now that you can furnish a copy of the order passed by this court, that we have found fault with the order of the tribunal, that they could not have gone on the subsequent events, and nothing would prevent the state to issue notification for promotion. You can give a representation.
Even it is observed.
We can't issue a direction in this matter.
My lord, time limit.
Even it is observed.
Time limit may be fixed, my lord, because already I am suffering from 2023.
Of course, he also would want to.
Yes, I also would want, my lord. Let there be.
The tribunal shall reconsider the matter and pass orders as expeditiously as possible, and at any rate within a period of
3 months. 3 months.
3 months,
The tribunal is sitting only for 1 day in a week.
1 day.
1 day in a week.
Okay, this is something that can be decided in 2 sittings.
In that, my lord, we not filed the reply statement there. That is the confusion, my lord. and permit the,
within a period of 3 months from the date of receipt of a copy of this order.
and
Stop. The respondent state and its authorities may be permitted to file a written statement along with all the relevant
please,
information and records
and even
for
petitioner
the
also,
reconsideration of the tribunal.
even petitioner also permitted to file reply statement, because he is only not engaged the advocate.
The petitioner may also be permitted to file statement of objections or reply statement as the case may be.
And even all parties, my lord, even,
Nimdenu?
my lord, since, my lord, I need to establish, my lord, with regard to the, my lord, the
Subsequent events ಏನು ಇಲ್ವೇ ಇಲ್ಲ.
subsequent illa. Previous, my lord, with regard to, my lord, my consideration of my promotion.
Correct. ಅದಕ್ಕೆ ಆ ಗ್ರೌಂಡ್ಸ್ ಮೇಲೆ ನೀವು ಹೋಗಿರೋದು.
Any,
They were required to consider, call for the records, verify them and see whether the decision taken by the DPC was correct or not. So all that information will be given by the government now. Yes.
Case number 2, writ of habeas corpus petition. Ilappa Yarod.
ಬಂದ್ರ ಅವರು ಬಂದ್ರಾ? ಹಾ.
ಬರ್ರಿ.
ಅವ್ರ ತಂದೆ ಬಂದಿಲ್ವಾ?
Still he's in hospital. He's now
Mother ಯಾರು?
mother Kalpana.
ಹಾ?
ಇವ್ರು ಯಾರು? ಸಿಸ್ಟರ್. ನೀವು ಆ ಕಡೆ ಇರ್ಲಿ. ಮದರ್ ಅಷ್ಟೇ ಇರ್ಲಿ. ನೀವು ಆ
ಯಾರು
ಕಡೆ-
ತಾಯಿ ಯಾರು?
ಇವ್ರೇ ಮನೆ.
ಹುಡುಗಿ
ನೀವು
ತಾಯಿ
ಅಲ್ಲೇ
ನೀನೇನಮ್ಮ?
ಹೌದು.
ನೀವ್ ಹಿಂದೆ ಕೊಡೋದು.
ನೀವು ಅಲ್ಲಿ ಹೋಗ್ರಿ.
ಹಿಂದೆ ಹೋಗಮ್ಮ.
ನೀವು ಹಿಂದೆ ಹೋಗಿ.
ಇವ್ರು ಸಾಕು ತಾಯಿ. ಸಾಕು ತಾಯಿ ಇವರು. ಕೂತ್ಕೊಳ್ಳಮ್ಮ ಅಲ್ಲಿ ಕೂತ್ಕೊ. ಇಲ್ಲೇ.
ಏನಮ್ಮ? ಸರಿ ಒಂದ್ಸರಿ ಇದೇ ತರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ರಿ ನೀವು, ಹೌದಾ? ಸರಿ ನೀವು ಒಂದ್ಸರಿ ಇದೇ ತರ ಓಡೋಗಿದ್ಲು ಹುಡುಗಿ, ಹೌದೇನಮ್ಮ? ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ರಿ, ಹೌದಾ? ಆಮೇಲೆ ಪೊಲೀಸವ್ರು ಕರ್ಕೊಂಡ್ಬಂದ್ರು. ದಿಸ್ ಮ್ಯಾಟರ್ ವಾಸ್ ಕನ್ಸಿಡರ್ಡ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್?
No.
ಇಲ್ಲ.
When their parents of the accused were brought before the police station, accused surrendered and produced the girl, produced the victim.
You are not.
ಇಲ್ಲ, no court proceedings.
Not come to the
No
court.
court proceedings.
ಆಯ್ತು.
So he voluntarily given the statement before the magistrate and the report was filed.
ಅವಾಗ ಆಕೆ ಏನು ಹೇಳಿ, ನಿಮ್ಮ ಮಗಳು ಏನು ಹೇಳಿಲ್ಲಂತೆ, ನನಗೆ ಈ ತರ ಜಬರ್ದಸ್ತ್ ಮಾಡಿ ಯಾರೋ ಬೇರೆ ಹುಡುಗನಿಗೆ ಮದುವೆ ಮಾಡಕ್ ನೋಡ್ತಾ ಇದಾರೆ, ನನಗೆ ಇಷ್ಟ ಇಲ್ಲ ಅಂತೆಲ್ಲ ಹೇಳಿಲ್ಲಂತೆ. ಇಲ್ಲ ನಾವೇನು ಹಂಗೇನು ಜಬರ್ದಸ್ತ್ ಮಾಡಲ್ಲ ಅಂತ ನೀವು ಹೇಳಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರಂತೆ. ಅದಾದ್ಮೇಲೆ ಯಾವ್ದೋ ಈ ಬೇರೆ ಹುಡುಗನ ಜೊತೆ ಎಂಗೇಜ್ಮೆಂಟ್ ಮಾಡಿ ಮದುವೆ ಮಾಡಕ್ ನೋಡ್ತಾ ಇದೀರಂತೆ. ನಿಮ್ ಮಗಳು ಇವಾಗ ನಮ್ಮ ಮುಂದೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದಾಳೆ, ಅವಳು ಮೈನರ್ ಅನ್ಬಿಟ್ಟು ನೀವಿಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತೀರಾ, ಆದ್ರೆ ಆ ಹುಡುಗಿ ಮೈನರ್ ಹುಡುಗಿಗೆ ಮದುವೆ ಮಾಡಕ್ ನೋಡ್ತಾ ಇದ್ದೀರಾ ಈಗ. ಹೆಂಗ್ ಮದುವೆ ಮಾಡ್ತೀರಾ ನೀವು?
She is studying still.
Correct. Please ask her, how is it that
ಮದುವೆ ಮಾಡ್ತೀರಾ? ಆಮೇಲೆ ಆದದ್ದು.
Serial number 31, Mahesh Patil.
Appearing for respond number 2, my lord. I need to get instruction, my lord, the
Selection matter. My lord, the
delay is there, my lord, delay may be condemned and it may be posted for
delays.
need instruction, my lord. I have forwarded copy to the KPIC, my lord.
Learned counsel, you are the contesting respondent.
Both two and
Both,
my
my
lord,
lord, two
in
and
serial number 31, my lord.
Learned counsel for the contesting respondents would submit that the delay of 54 days may be condoned. Stop accordingly. Delay is condoned. And IA number 1 of 2024 is accordingly disposed of. Next para. At the request of learned counsel for respond number 3, release this matter.
My lord, in connected matter, my lord, it is
My lord,
need to
connected
pay PF
matter.
by the petitioner
My lord,
because
in the connected matter, my lord, all of them are served, my lord, and it is in the previous, my lord, hearing it was not shown. And even the postal shara, my lord, shows that, my lord, everybody has been served.
Yeah, our bearer respondents.
private
Private,
response.
all of them have been served.
ಎರಡರಲ್ಲೂ ಒಂದೇ ಸ್ಥಾನ ಸೇಮ್
Same. ಅದು ಕೆಲವೊಂದ್ ಜನ ಬೇರೆ ಇದೆ.
ಬೇರೆ ಇರ್ತಾರೆ ಬೇರೆ.
The postal, my lord, here, Shara shows, my lord, that all of them have been served, and the previous hearing, my lord, it is not shown. It is shown as served. It may help be sufficient.
Allah, we are asking whether they are common parties in both the matters.
ಇಲ್ಲ ಬೇರೆ ಬೇರೆ
ಬೇರೆ ಇದೆ.
So in the connected matter 20080 of 2024, respondents number 4 to 8.
My lord, insofar as 8 is concerned,
Ah.
my lord, in the before the learned single judge, my lord, it was dispensed. Kindly, it has come in the order. At page 16. My lord, ಅದರಲ್ಲಿ 8 ಆದ್ಮೇಲೆ petition against R8 is dismissed. And my lord, insofar as 4 to 7.
Suryakanta. Respond number 8 illunu. Learned counsel, in connected matter, learned counsel for the petitioner submits, appellant submits that respond number 8 did not appear before the learned single judge and the petition was dismissed as against respond number 8. Full stop. Therefore, learned counsel would submit that the appellants may be permitted to take fresh steps for service of notice on response number 4 to 7 only.
4 to 7, my lord, already, my lord, served. It has come in the postal share also. And last time, Torsila, it was held to be PF last time Torsila. First time serve again. Only R8 is shown last.
ಎಲ್ಲರಿಗೂ ಡೆಲಿವರ್ ಆಗಿಲ್ಲ. That is why the office has put up this
But on 13/9, my lord, when the matter had come up, my lord, only in respect of R8 it was shown. Only in respect of R8.
ಅವಾಗ ಇನ್ನು ಬಂದಿರ್ಲಿಲ್ಲ ಅದು. Even now it says dispatched ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಅಷ್ಟೇ. ಹಂಗೆ ಇರ್ಲಿ. 4 to 7. only. Next, accordingly, a week's time is granted to the petitioners to take fresh steps for service of notice on response number 4 to 7. Yes.
Bill number 32, Ravi B. Patil.
Yes.
The dispensation of the Kannada documents.
Translated copies of annexures in Kannada are dispensed for the time being. Yes.
The delay of
Number 1 of 2024 is accordingly disposed of.
delay of 111 days in filing the writ appeal. May be permitted to take notice to counsel representing before single judgment.
Land reforms.
How? Yes. Santosh Belamgi Manod had appeared before the judge.
Learned the government advocate takes notice for response number 1 and 2. 1, 2, 3.
3.
Issue notice to response number
4.
4, 1 and
4.
4, 1 and 1A. Stop.
Only 1A.
The,
Only 1A, 1 also died.
4, 1A. The appellant is also permitted to serve copy of the appeal memo along with annexures on learned counsel Sri Santosh R. Belamgi, who appeared for respondent number 41A before the learned single. Learned counsel for the appellant is directed to serve copy of the appeal memo along with annexures on the learned government advocate and learned counsel Sri so-and-so.
Seal number 33, Bapugoda Siddhappa.
For the appellant claimant's appeal for seeking enhancement. The liability fixed upon the tribunal to the respondent number 1, notice has been go to the respondent number 1. And the second respondent is the branch manager, IPCO Tokyo General Insurance Company.
Learned counsel Sri Subhash Mallapur is requested to take notice for respondent number 2. Issue notice to respondent number 1. Learned counsel for the appellants is directed to serve a copy of the appeal memo along with the annexures on learned counsel respondent number 2.
Yes.
Seal number 34, Bapugoda Siddhappa.
In this also, the liability fixed upon the tribunal, respondent number 1 and 2, owner of the vehicle and rider of the vehicle. The respondent number 4 is the branch manager, United India Insurance Company. Sharanapasappa M. Patil is there. in the Lordship,
Learned Counsel Sri Sharan Basappa in part who is present in the court takes notice for respondent number 4.
four months.
Learned Counsel for the appellant is directed to serve a copy of the appeal memo along with the annexures on Learned Counsel for respondent number 4. Issue notice,
1 to 3 months.
issue notice to response number 1 to 3.
Engineering matters, C number 35, Santosh S. Gogi. 35.
Matter is called out. There is no representation for the complainant. Release this matter on 27th of November.
C number 36, Avinashi Uplonkar.
Same order.
Admission matters, C number 37, Sharan Gowda V. Patil.
Claimants appeal, my lord, seeking announcement.
Notice has been ordered.
Yeah.
Notice has been ordered.
Order.
Preeti Patil Melkundi has taken notice.
Yes.
ಮತ್ತೆ ಯಾರು admission ಕೊಡ್ತಾ ಇದೆ?
Case of injury, my lord. Imputation.
You are seeking enhancement.
Yes.
Injury case.
Injury case, amputation. Amputation, man.
ಮತ್ತೆ ಹೋಗ್ರಿ ಲೋಕ ಅದಾಲತ್ ಮುಂದೆ. ಏನ್ರಿ 2018 ಸುಮ್ಮನೆ ಹಿಂಗೆ
ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ ಅವರು ಇದ್ರೊಳಗೆ ಡಿಸಬಿಲಿಟಿ 85 ಹೋಲ್ ಬಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಬಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಟೇಕನ್ 43%. ಮಿನಿಮಮ್ 75% ಡಿಸಬಿಲಿಟಿ ತಗೊಳ್ಬೇಕು. ಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಕಾಲ ಕಟ್ ಆಗಿದೆ ಸುಮಿತ.
Admit, call for records. Call for trial court records.
C number 38, Inamdar Mehboob.
Partition suits. Partition suits. The plaintiff is the suit properties are the ancestral properties. And the plaintiff is having 1/5 share in the suit properties. But the defendants are denied the relations.
Records call for partition suit. ಬಂದಿದೆಯಾ? Admit. ಬಂದಿದೆ.
C number 39, additional government advocate.
39, my lord, this is IA for CD, my lord, within the, behind, my lord, 120 days, that is before, within the 120 days, my lord, this IA may be CD considerable. Regarding stay, my lord, you will also pay it on 27th, my lord. Other matters are last posted on 27th. 27th. 27/6/11.
ಅಲ್ಲ ಅವು
ಇದು ಬೇರೆ ಅದು ಬೇರೆ 27th ಇದೆ.
ಇದು ಇವೆಲ್ಲ ಡಿಲೇ ಕ್ಯಾನ್ ಬಿ ಕಂಡೋನ್ಡ್. ಮ್ಯಾಟರ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಹರ್ಡ್.
Regarding stay, that is.
ಹೌದು.
60 days.
ಹೌದು. ಇದು ಅದು ಯಾವ್ದೋ ಒಂದು ಆರ್ಡರ್ ಕಾಪಿ ಕೊಟ್ರೆ ನಾವು ಪಾಸ್ ಮಾಡ್ಬೇಕು. ಸೇಮ್ ಆರ್ಡರ್ ವಿಲ್ ಬಿ ಪಾಸ್.
ಇದೆ ಸರ್ 50%.
Yes.
That IA has to be considered, my lord.
ಅದೇ.
Regarding stay, my lord, that has to be posted on 27th. Regarding the stay, my lord.
ಅದೇ ಮತ್ತೆ ಅದೇ. You are asking for that 25%.
Yes, that is only ISCD may be considered.
ಆಗಿದೆ.
ಅದು within ಇದೆ.
ಹಾ
Within.
ಸರಿ, ಅದನ್ನ ಸೇವ್ ಮಾಡು. ಮಾಡ್ಬಿಟ್ಟು ರಿಲೀಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 27th.
For consideration of the interim prayer, that
27th.
IF for stay. Please.
Okay, Ravi B. Patil.
The connected writ appeal was directed to file an affidavit in compliance of previous order. Lord, sorry, I secured my lord affidavit today. I
Destruction
have,
of
yes,
key answers.
yes, it is in respect of, I have supplied my lord, I am furnishing affidavit of respondent, appellant number 1 to the effect that examination papers followed by the office order is already shredded. That is what my lord,
We are not asking for answer papers, sir.
key
We are
answers.
only
Yes,
asking for key answers.
yes, yes, yes. ma'am.
Why
Even-
that will be destroyed?
It is my lord pursuant to office orders. my lord.
The person who set that paper and gave the answer, key answers,
Yes,
you can get it from him also.
like it will be sent to my lord, it will be given to some third party agency, my lord,
Really?
who will destroy.
Why will they destroy? It will be there in their computers.
ಇಲ್ಲ ಇದು shred all papers would be shredded, my lord. That is what office order speaks. Otherwise, my lord, there is no hurdle. Already, my lord, appellant corporation has furnished, my lord, OMR sheet, answer sheet also. It was before, my lord.
For the key answers to compare and see
Yes, yes, ma'am.
whether the marking is correct or not.
It is, my lord, my instructions, my lord, it is after cutoff date of said 2 months, after time limit of 2 months. Therefore, they are not in a
But
position
this is
to.
only to cover up their, my lord, fault, my lord. The reply which they have given under RTI when I have sought for a key answer. Annexure N, page number 87, be kindly looked at. 87, my lord, of the writ appeal. This is the reply, my lord, they gave you in the month of October 2022. They never say that, my lord, these key answers have been destroyed. What they contend is, my lord, under the provisions of RTI, we need not furnish that key answers. And they also provide us, my lord, the information that if they are aggrieved, I should go and appeal. If those key answers were not available or even as on this day, my lord, that is in the month of October, they could have said, my lord, they are already been destroyed, therefore they cannot be given. On the contrary, they take a stand, my lord, that under provisions of RTI that cannot be given. Therefore, I had approached this honorable court challenging this endorsement. And then, my lord, when matter goes, my lord, contrary to them, now they come up with a new defense saying that, my lord, they are being destroyed. If as per the affidavit which has been filed, they say, my lord, within 2 months, my lord.
ಅವ್ರದೇ ಇದು ರೂಲ್ಸ್ ಇದೆ.
Yes.
ಅದ್ರ ಪ್ರಕಾರ ಮಾಡಿದ್ರು.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಆತರ ಇಲ್ಲ ಸರ್.
But the rules their rules prescribe, so what can we do?
ಇಲ್ಲ ರೂಲ್ಸ್ ಆತರ ಇಲ್ಲ. What
ಹೇಳಿದಾರೆ.
Yes, yes. Even I have produced, my lord, along with
state of hearing, lordship had gone into those.
Annexure R1, page
R1,
page number.
Previous affidavit,
No, my lord, along with statement of objections filed before learned single judge only. I supplied, my lord,
Annexure R,
one, my lord,
page number 91.
please.
ಅಲ್ಲಿ ಉತ್ತರ ಪ್ರತಿಗಳು ಮತ್ತೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಮಾರ್ಕ್ಸ್ ಅಷ್ಟೇ ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡೋದು. ಪೇಜ್ ನಂಬರ್ 4. ಮೌಲ್ಯಮಾಪನ ಮಾಡಿದ ಉತ್ತರ ಪ್ರತಿಗಳು. Then my lord, statement of marks.
Statement of marks, my lord, it also includes.
Key answer is totally different.
ಎಲ್ಲಿದ್ದಾರೆ?
My lord,
Page number 4 of my lord, annexure R1.
next
Next page. Adesha
92.
18/10/2010.
ಎಲ್ರಿ ಯಾವಾಗ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದಾರೆ?
Within 2 months, my lord.
ಎಲ್ಲಿದೆ? Please read it.
Yes, please, my lord, sorry.
ಕಾಲಮ್ ನಂಬರ್ 1 my lord, ಮೌಲ್ಯಮಾಪನ ಮಾಡಿದ ಉತ್ತರ ಪ್ರತಿಗಳು. ಅದರಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 4 ನಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಪರೀಕ್ಷೆಯ ಪೂರಕ ಫಲಿತಾಂಶವನ್ನು ಸಪ್ಲಿಮೆಂಟರಿ ರಿಸಲ್ಟ್ಸ್ ಘೋಷಿತ
ಕಾಲಮ್ ನಂಬರ್
4 ನಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ, ದಾಖಲಾತಿಗಳು ಮತ್ತು ದಾಖಲಾತಿಗಳ ಸಂರಕ್ಷಣೆಯ ಅವಧಿ ಹಾಗೂ ವಿಲೇವಾರಿ ರೀತಿ ಅಂತ ಮೇಲ್ಗಡೆ ಟೈಟಲ್ ಇದೆ ಸ್ವಾಮಿ. ಬದಲಾವಣೆಯಾದ ಸಂರಕ್ಷಣೆಯ ಅವಧಿ ಹಾಗೂ ವಿಲೇವಾರಿ ರೀತಿ. ಅಲ್ಲಿ ಪರೀಕ್ಷೆಯ ಪೂರಕ ಫಲಿತಾಂಶವನ್ನು ಸಪ್ಲಿಮೆಂಟರಿ ರಿಸಲ್ಟ್ಸ್ ಘೋಷಿಸಿದ ದಿನಾಂಕದಿಂದ 2 ತಿಂಗಳವರೆಗೆ ಹೊರಗಿನ ಏಜೆನ್ಸಿಗೆ ರೀಸೈಕ್ಲಿಂಗ್ ಮಾಡಲು ಈ ಉತ್ತರ ಪ್ರತಿಗಳನ್ನು ನೀಡುವ ಮೂಲಕ ವಿಲೇವಾರಿ. ಪರೀಕ್ಷೆಯಲ್ಲಿ ಅಭ್ಯರ್ಥಿಯಿಂದ ಅಕಾರ್ಯ ಮಾಲ್ ಪ್ರಾಕ್ಟೀಸ್ ನಡೆದ ಸನ್ನಿವೇಶದಲ್ಲಿ ಹಾಗೂ ಇಲಾಖಾ ವಿಚಾರಣೆಗೆ ಬಾಕಿ ಇರುವ ಸಂದರ್ಭದಲ್ಲಿ ಅಂತಹ ಮೌಲ್ಯಮಾಪನ ಮಾಡಿದ ಉತ್ತರ ಪ್ರತಿಗಳನ್ನು ಇಲಾಖಾ ವಿಚಾರಣೆ ಪೂರ್ಣಗೊಳ್ಳುವವರೆಗೆ ಸಂರಕ್ಷಿಸುವುದು. ಪರೀಕ್ಷೆಯ ಪೂರಕ ಫಲಿತಾಂಶವನ್ನು ಸಪ್ಲಿಮೆಂಟರಿ ರಿಸಲ್ಟ್ ಘೋಷಿತ 2 ತಿಂಗಳ ಒಳಗಾಗಿ 2 ತಿಂಗಳ ಆದ್ಮೇಲೆ ಅವ್ರನ್ನ ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ದಿಸ್ ಡಸಂಟ್ ಸೇ my lord key answers also. It is answer sheets, yes. And statement of marks. And affidavit ನಲ್ಲೂ affidavit
ಅದಾದ್ಮೇಲೆ ಇವಾಗ ಅದು ಡೆಸ್ಟ್ರಾಯ್ ಮಾಡಿ
ಈಗ affidavit ನಲ್ಲೂ ಯಾವಾಗ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳೋದಿಲ್ಲ.
ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ರೂಲ್ಸ್.
Entire affidavit doesn't say when they have destroyed ಅಂತ ಹೇಳೋದಿಲ್ಲ.
Like it will
They
be
say
given
what
to
as per
third
so and so
party
we have done.
agency. It will be given to third party agency, my lord, they'll
ಅದನ್ನು ಹೇಳಿಲ್ಲ.
destroy. In fact, there is one annexure R2 may kindly be perused. It is a little bit specific, my lord, with regard to examinations where, my lord, the complainant has appeared. It refers to, my lord, notification issued in the year 2021. ಮೂರು 2/2022 ಮತ್ತು ಮರು ಮೌಲ್ಯಮಾಪನದ ಫಲಿತಾಂಶವನ್ನು 9/5. This in fact, my lord, is revaluation in respect of petitioner's paper was conducted and examination results were announced on 9/5/2022. And he sought, my lord, key answer in the month of August 2022.
Answer ಹೇಳಿ, dates ಹೇಳಿ.
9/5/2022 is a date when
9/5/2022
my lord. 22 is a date when the complainant's revaluation results are announced.
9/5/2022. Revaluation results.
Yes. Date, my lord, on which the complainant sought key answers is, my lord, is on 22/8/2022. That is after lapse of more than 2.5 months. And my lord, previously in the month of May only.
Now you please read
Yes,
This order that you are talking of.
Yes.
18th of October 2010.
yes,
Huh?
yes,
You please see. ಮೌಲ್ಯಮಾಪನ ಮಾಡಿದ ಉತ್ತರ ಪತ್ರಿಕೆಗಳು.
yes,
Huh?
yes.
When it can be destroyed?
ಪರೀಕ್ಷೆಯ ಪೂರಕ ಫಲಿತಾಂಶವನ್ನು
ಸಪ್ಲಿಮೆಂಟರಿ ಎಕ್ಸಾಮ್ ಆಗಿ 2 ತಿಂಗಳಾದ್ಮೇಲೆ.
ಹೌದು.
ಹಾ.
Yes, ma'am. Yes, ma'am.
ಯಾವಾಗ?
Supplementary exam.
Supplementary exam ಯಾವಾಗ?
No.
When did you hold the supplementary exam?
No, my lord. Here it is not supplementary exam. Original exams were conducted on, my lord, conducted and results in the original examinations were announced on 3/2/2022 itself.
3/2/2022.
Thereafter, he sought for revaluation of paper 3 where he failed in one subject. And it was announced on 9/5/2022. From 9/5/2022, 2 months comes around, my lord, 9/6/97.
Sir, that is why I am asking you to read the rules once again.
Yes,
It doesn't say
please.
2 months after the results are announced. Allah, please understand. Idu main examination papers they are talking of.
Yes,
It can be destroyed 2 months after the supplementary results. Examinations results are announced. Please read it.
ಪರೀಕ್ಷೆಯ ಪೂರಕ ಫಲಿತಾಂಶವನ್ನು
Supplementary results ಅಂದ್ರೆ
Yes, supplementary, my lord.
ಏನು supplementary results?
Once again, my lord, examinations will be conducted. That will be called as a supplementary, my lord. Here is not.
When did you hold the supplementary exam?
No, my lord, supplementary exams were not held. Supplementary exams were not held, my lord.
Sir, the rules require that you can destroy it
Yes,
only after announcements of the results of the supplementary examination. Please understand, there is some meaning in this. Though
please.
the first column talks of the answer scripts of the examination.
Yes,
What is said is, after the supplementary examination results are announced, ಅಲ್ಲಿ ಆದ್ಮೇಲೆ 2 months. There is a lot of wisdom in this. It is not that immediately after 2 months you will be destroying the papers. No. Now you read your affidavit, we'll see. Huh? ಹಾಕಿದ್ದಾರೆ. ಅದೇ ಕಂಟೆಂಪ್ಟ್ ಆದ್ಮೇಲೆ ಇವಾಗ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. Yes. Now you read the affidavit. ಇದೇನಾ? Objection unraised ಮಾಡಿ.
This contention was taken before learned single judge itself. Yes.
Let us see what you have said in the affidavit.
My lord, para 8.
To the rules that we have read now.
Yes.
What is it that you have said in the affidavit?
Para 8, my lord, is concerned with regard to office order and destruction of. I state that appellant corporation in its earlier proceedings dated 17/2/2010 has taken decision to dispose of all the examination papers after 2 months of announcing results through third-party agency.
Itself is wrong. They have not understood the provisions properly.
Except preserving the same in case of departmental inquiries, etc. I further state that said practice of studying disposal of examination papers after the time limit of 2 months are still continued and followed by the appellant corporation. I state that yes, ma'am. I state that the appellant corporation on 15/7/2022, following the office order and after lapse of prescribed 2 months time from the date of announcing exam results, original and
illi they are using the word revaluation results.
Yes.
Original and revaluation results.
As disposed of all the examination papers conducted in the month of March 2021 as per OM dated 15/7/2022.
ಯಾವಾಗ?
ಇಲ್ಲ, ಅದು sorry.
When did they destroy?
15/7, my lord, after 2 months ante,
Of what?
of announcing revaluation results.
Huh?
Revaluation results.
ಎಲ್ಲಿದ್ದಾರೆ? ಎಲ್ಲ dates ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಇದೆ. Revaluation result, as I told my lord, 9/5/2022. So, no, 9/5/2000. Annexure G. My lord, kindly appreciate my lord bona fideness of corporation. They provided answer sheet including OMR sheet.
Examination ಆಯ್ತು.
Yes.
Please read paragraph number 5.
I state that the contesting respondent number 1, herein being an employee of appellant corporation, appeared for departmental examinations conducted pursuant to the notification dated 18/3/2021. I further state that the departmental exam results were announced on 3/2/2022, in which contesting respondent number 1 declared as fail in paper 3. I state that dissatisfied with the marks determined by the appellant corporation, the contesting respondent number 1 sought for revaluation in the failed subject. Accordingly, in the revaluation conducted, the marks determined in paper 3 increased from 29 to 33. The result of revaluation was announced on 9/5/2022. I further state that the appellant corporation, at the request of contesting respondent number 1, and in order to be fair and transparent, have issued answer sheet as well OMR sheet to the writ petitioner. I state that contesting respondent number 1, after declaration of revaluation marks and obtaining answer sheet and OMR sheet, considering himself dissatisfied, again only on 22/8/2022, that is nearly after lapse of more than 2.5 months from the date of declaration of revaluation result, it is incomplete, my lords. He sought for key answers.
What is this revaluation? Supplementary exam ಅಂತ ಯಾಕೆ ಯೂಸ್ ಮಾಡಿದಾರೆ?
ಇಲ್ಲ, ಅದು in respect of my lord general examinations to be conducted by the department. General examinations like competitive exams. Next supplements. The meaning, my lord, of office order is they preserve, my lord, whether it is, my lord, supplementary or revaluation from the date of announcing result, my lord, unless there are any inquiries or, my lord, any malpractices committed by the candidates, they preserve it. Otherwise, my lord, after 2 months, those papers will be sent to disposal.
Where have you stated that this is the period provided for maintaining the documents?
In the affidavit, ma'am.
In this page number 92.
Yes, ma'am.
You please see ಇಲಾಖಾ ಪರೀಕ್ಷೆಗಳ ಮೌಲ್ಯಮಾಪನ ಮಾಡಿದ ಸಂರಕ್ಷಣೆಯ ಅವಧಿ ಮೀರಿದ ಯಾವ್ದದು ಸಂರಕ್ಷಣಾ ಅವಧಿ ಯಾವುದು?
That is 2 months, ma'am.
No, sorry. You are don't try to confuse everything together.
No, ma'am. I am not. As it is black.
No, there are a lot of confusion here. It is for you to throw proper light. ಸುಮ್ಮನೆ ಹಿಂಗ ಅಫಿಡವಿಟ್ಗಳು ಹಾಕೋದಲ್ಲ. ಅವಧಿ ಮೀರಿದ ಉತ್ತರ ಪತ್ರಿಕೆಗಳು ಅದೇನು ಅರ್ಥ ಏನು?
ಅವಧಿ ಮೀರಿದ, yes, my lord, that
Where it is stipulated?
from my lord, from this order itself, we can gather,
No.
that is 2 months. And my lord, may I request annexure R2, my lord, that is R2 ನಲ್ಲಿ. There it is
ಅದು actually
specific ಆಗಿದೆ. But it exactly pertains to, my lord, the exam where
22.
complainant has appeared. Yes, my lord. ಮಾರ್ಚ್ 2021ರಲ್ಲಿ ನಡೆದ ಸಹಾಯಕ ದರ್ಜೆ ಭಾಗ ಎ ಭಾಗ ಬಿ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಹೈಯರ್ ಪರೀಕ್ಷೆಗಳ ಮೌಲ್ಯಮಾಪನದ ನಂತರದ ಫಲಿತಾಂಶವನ್ನು ದಿನಾಂಕ 3/2/2022 ಮತ್ತು ಮರು ಮೌಲ್ಯಮಾಪನ ಫಲಿತಾಂಶವನ್ನು 9/5/2022 ಘೋಷಿಸಲಾಗಿದ್ದು, ನಿಗಮದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ 18/10/2010 ಪ್ರಕಾರ ಇಲಾಖೆ ಪರೀಕ್ಷೆಯ ಮರು ಮೌಲ್ಯಮಾಪನದ ಫಲಿತಾಂಶವನ್ನು ಘೋಷಿಸಿದ ದಿನಾಂಕದಿಂದ 2 ತಿಂಗಳವರೆಗೆ ಸಂರಕ್ಷಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಮಾರ್ಚ್ 2021ರಲ್ಲಿ ನಡೆದ ಪರೀಕ್ಷೆಗಳ ದಾಖಲೆಗಳ ಸಂರಕ್ಷಣಾ ಅವಧಿಯು ದಿನಾಂಕ 9/7/2022 ಮುಗಿದಿರುವುದರಿಂದ ಸದರಿ ಪರೀಕ್ಷೆಗಳ ಉತ್ತರ ಪತ್ರಿಕೆಗಳು, ಅರ್ಜಿಗಳು, ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆಗಳ ಬ್ಯಾಂಕ್ ಮಾದರಿ ಉತ್ತರ ಪತ್ರಿಕೆಗಳು, ಹಾಜರಾತಿ ಪಟ್ಟಿಗಳು ಹಾಗೂ ಇತರ ಪತ್ರ ವ್ಯವಹಾರದ ದಾಖಲೆಗಳನ್ನು ನಿಯಮಾನುಸಾರ ವಿಲೇವಾರಿ ಮಾಡಲು ಆದೇಶಿಸಲಾಗಿದೆ.
So ಇಲ್ಲಿ they have included the word
Yes.
ಮಾದರಿ ಉತ್ತರ ಪತ್ರಿಕೆಗಳು.
Oh.
This is the model
Answers.
This is nothing but key answers.
Yes.
They have included that also here.
This is on 15/7/2022 as per their claim.
ಹೌದು. Anyway, it was much before
But
you
the
gave
reply,
the application.
but what happens once we apply for revaluation, they announce the result. Thereafter, my lord, we seek for a, my lord, answer sheets. Answer sheets are provided to us. Thereafter, we have to re-verify with our answer sheets, and then only, my lord, we can ask.
ಆಗ್ಲೇ ಜೊತೆಗೆ ಕೇಳಬೇಕಾಗಿತ್ತು.
And
ಅದನ್ನ ಒಂದ್ಸರಿ ಇನ್ನೊಂದ್ಸರಿ ಎಲ್ಲ ಆಗುತ್ತೆ.
we have sought everything. They have only provided OMR sheet and the order sheets. ಇದು answer sheets.
So
ಅದನ್ನ ಕಂಪೇರ್ ಮಾಡಕ್ಕೆ ಇರೋದಿಲ್ಲ.
application ಅಲ್ಲಿ along with that application that you also ask for a copy of the key answers. ಎಲ್ಲಿದೆ? Where is your application?
Page 52, my lord.
52.
Yes.
ಅದು
Annexure J.
22/8
ಅದನ್ನೇ ಅವಾಗೆ OMR ಶೀಟ್ ಕೇಳಿರಿ.
ಇಲ್ಲ.
Which is your application?
That is only for key answers.
Huh?
That is only for key answers.
ಹಂಗಾರೆ ಮೀನ್ ಸಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ರ ಅಲ್ಲಿಗೆ. Where is your first application?
Requesting for
So this is arising out of the Right to Information Act. Matter is arising out of the Right to Information Act.
the reply given to me is under RTI.
You filed your application under the RTI Act?
Yes.
Huh?
How?
So you went before the competent authority?
No, my lord. First I had approached this the competent authority by way of a representation. They had not replied. Therefore, I was made to make a representation under RTI. To which they have replied that such things cannot be furnished to me since it is specifically barred under the provisions of RTI. I challenged the said endorsement before this court.
How can you challenge it before this court? There is an appellate authority there.
ಅದನ್ನ ಸ್ಪೆಸಿಫೈ ಮಾಡಿದ್ದಾರೆ annexure N ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
Huh?
Annexure N ದಲ್ಲಿ they have specified that so and so if I am agreed of the endorsement, I have to
go before
approach
that authority?
No, my lord.
Then how is the writ petition maintainable?
But since it was only a key answer which was sought for, all rest of things are.
Sir, your application is under the Right to Information Act.
How the reply which is
The Act provides for remedy. You have to go before that authority. How did you file a writ petition? ಏನ್ರಿ ಇವೆಲ್ಲ ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ರೈಸ್ ಮಾಡಲ್ಲನ್ರಿ ನೀವು?
There, my lord, it is clarified in the letter itself If he is aggrieved, my lord, he has to approach appellate authority.
Then why did you not raise objection that the writ petition is not maintainable? Huh? Section 19, Right to Information Act. Any person who does not receive a decision within the time stipulated in subsection 1 or clause A of subsection so and so is aggrieved by a decision of the Central Public Information Officer or State Public Information Officer, as the case may be, may within 30 days from the expiry of such period or from the receipt of such a decision, prefer an appeal to such officer who is senior in rank to the Central Public Information Officer or State Public Information Officer, as the case may be, in each public authority. ಅದಾದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಇದೆ.
ಇವ್ರು ಈಗ ಹೇಳೋದ್ ಪ್ರಕಾರ ಅದಕ್ಕಿಂತ ಮುಂಚೆನೆ ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಿದ್ದೀನಿ.
Public information officer ಮೇಲೆ ರಿಟ್ ಹಾಕಿಲ್ಲ. He is not a public information officer.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. If the matter is arising out of an application filed under the RTI Act seeking information and you are aggrieved, this process only can be followed. You cannot deviate. No, supervisory jurisdiction on the authority who is permitted to consider an appeal. ಮತ್ತೆ ಅವ್ರು ಹೋಗೇ ಇಲ್ಲ ಅಲ್ಲಿಗೆ.
Public information.
Correct. ಇವೆಲ್ಲ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡ್ಬೇಕ್ರಿ.
Mandamus was sought against not the representations which were made on 22/8/22 and 4/9/22.
Now you conveniently call it a representation.
ಇಲ್ಲ conveniently ಮುಂಚೆನೇ ಆಗಿದೆ. First I made a representation, thereafter I had made a application under
Application under the Right to Information Act.
ಆಮೇಲೆ ಮಾಡೋದು.
ಮತ್ತೆ
First ಹೋಗಿರೋದು representation to the authorities only. That is at page number 54, 52. First representation is dated 22/8/2022 and then 4/9/2022. In spite of which they did not furnish me the records. Therefore, I had made a application under RTI. That is on 27/9/22.
So on your second representation, application,
they have not done anything. On my representation, they have done nothing. And Mandamus was to consider annexure J and K, that is 22/8/22 and 4/9/22.
you did not make, both these are not under the Right to Information Act.
No.
Why are you saying Right to Information Act?
That is information which has been furnished at annexure N is pursuant to application. Page number 85, my lord.
86.
Because they did not furnish me any information, then I filed application under RTI. To which, my lord, they have replied under, my lord, provisions
Correct.
of
So
annexure N.
therefore, what follows is that they have given a reply under your application under the Right to Information Act.
Yes.
Then what follows is that you'll have to follow this procedure.
But that is only with regard to prayer number 1 in the writ petition, insofar as quashing of annexure N is concerned, that is under the provisions of RTI. Insofar as the mandamus which has been sought, which was already, my lord, the representation were already before the authority. And my lord, the direction issued by, my lord, the learned single judge is to consider that representation. That endorsement is held to be invalid, and then thereafter, my lord, the mandamus directing, my lord, the authorities to provide the key answers. And they were given 4 weeks time to, my lord, reply to this mandamus, in spite of which they did not reply.
Where is annexure N? Which is the reply given to this application?
That is under RTA only, 87.
87.
Page 87, annexure N.
87.
ನಿಗಮದ ವತಿಯಿಂದ ಲಾಸ್ಟ್ ಲೈನ್ ಅಬೌವ್ ದ ಟೇಬಲ್ ನಿಗಮದ ವತಿಯಿಂದ ನೇಮಿಸಲಾಗಿರುವ ಮೇಲ್ಮನವಿ ಪ್ರಾಧಿಕಾರಿಗಳ ವಿವರವನ್ನು ತಮ್ಮ ಮಾಹಿತಿಗೆ ಈ ಕೆಳಗೆ ತಿಳಿಸಲಾಗಿದೆ.
Correct.
ಸೊ ಈ ವಾಸ್ ಆಸ್ಕ್ ಟು ಅಪ್ರೋಚ್ ಮಿಲೋಡ್ ಅಪೆಲೆಂಟ್.
ಅದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
They are given the information also.
ಹೌದು. ಕೊಟ್ಟಿದ್ದಾರೆ. If I had only approached, my lord, the authority under RTI, my lord, yes.
ಇವಾಗ ಇಲ್ದೇ ಇರೋದನ್ನ ನಾವು ಹೆಂಗ್ ಕೊಡ್ಸೋದು ನಿಮ್ಗೆ?
ಇಲ್ಲ.
They are saying they have
ಇದೇ ಸ್ವಾಮಿ, they are avoiding. The reason is, my lord, for some other, my lord, they want to safeguard, my lord, the
ತಪ್ಪು
person.
ಮಾಡಿದೀರಾ. You should have asked for all this information in one application.
ಹೌದು, ಒಂದರಲ್ಲಿ ಅದನ್ನ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. I'll produce, my lord, what information, what application I have made. ಅದು
No, in the subsequent representation dated.
ನಿಮ್ಮ ಆನ್ಸರ್ ಸ್ಕ್ರಿಪ್ಟ್ ಕೇಳಿದ್ರಲ್ರಿ?
ಹೌದು.
ಹೇಳಿದ್ದೀನಿ.
ಎಲ್ಲಿ ಬೇರೆ ದಟ್ ಅಪ್ಲಿಕೇಶನ್?
ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ along with petition. I will produce that document. I have the document.
Even there is no reference in the subsequent representation at annexure J, my lord. If he has made, my lord.
Actually, key answer, my lord, is available openly to all the candidates. Here it is the only case where, my lord, key answers are suppressed. Once, my lord, under the provisions of, my lord, once they hold a, my lord, examination, key answers should be made available to all the candidates.
It is made available.
My lord?
It is made available.
Illa.
It is published.
No. They never publish. Let them, my lord.
Then where have you asked for all that? Where, where have you questioned all this?
I'll produce, my lord, that.
For only asking for a copy of the key answer.
ಇಲ್ಲ,
Never said it was not made available.
ಇಲ್ಲ, ಎಲ್ಲನೇ ಕೇಳಿದೀನಿ. I will produce, my lord, that representation which was missing, my lord, in the read proceeding. A day's accommodation, my lord, I will produce.
No use, sir, now. They are saying they have destroyed everything.
How
can we force them to give
only to
something?
safeguard their, my lord, interest, they want to, my lord, deny. They have prepared, my lord, the list of all the employees who have got the marks.
You have not taken a stand that they have not even published it. Now you are saying everything. Then you should have questioned it at that point of time itself. Without giving us the key answers, how can you do the correction anta? You ಒಂದೊಂದಾಗ ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಈಗ. ಬರ್ಕೊಳ್ಳಿ.
my lord, may I take your lordship to page number 43, my lord?
43 of their appeal.
Oh. I specifically said, my lord, I have not furnished with the key answers. Para number 2 dalli ಹೇಳ್ತೀನಿ.
42,
43.
43 of
I'm sorry. That is representation dated 4/9/2022, para number 2. And 54, my lord, page number 54.
our appeal alla.
ಹೌದು.
Page number 52.
54 ಇದೆ.
Same.
Representation dated 4/9/20.
Same.
4/9/2022.
ನಾನು ಈಗಾಗಲೇ ದಿನಾಂಕ 22/8/2022 ನನಗೆ ಆದ ಅನ್ಯಾಯ ಬಗ್ಗೆ ಸವಿಸ್ತರವಾಗಿ ಪತ್ರದ ಮುಖಾಂತರ ತಮಗೆ ತಿಳಿಸಿದ್ದೇನೆ. ನಾನು 22/8/2022 ಕೇಳಿದ ಪ್ರಕಾರ ಮಾರ್ಚ್ 2021 ಮಾಯಲ್ಲಿ ನಡೆದ ಹೈಯರ್ ಪತ್ರಿಕೆ 3ರ ಕೀ ಉತ್ತರಗಳನ್ನು ಕೊಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಕೇಳಿರುತ್ತೇನೆ. ತಾವು ನನಗೆ ಕೀ ಉತ್ತರವನ್ನು ಇಲ್ಲಿಯ ತನಕ ನನ್ನ ಮೇಲ್ ಐಡಿಗೆ ಹಾಗೂ ವಿಳಾಸಕ್ಕೆ ಸಲ್ಲಿಸುವುದಿಲ್ಲ. ನಾನು ಈ ಪತ್ರದೊಂದಿಗೆ ಕೀ ಉತ್ತರಗಳನ್ನು ಸರಿಯಾಗಿ ಇರುವುದು ಸರಿಪಡಿಸಿಕೊಂಡು ನಾನು ತಮಗೆ ಕೀ ಉತ್ತರಗಳ ಸಂಕ್ಷೇಪವಾಗಿ ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿರುತ್ತೇನೆ. ಅಲ್ಲದೆ ಮೊನ್ನೆ ನಡೆದ ಇಲಾಖೆ ಪರೀಕ್ಷೆ ಕೂಡ ನಾನು ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ನಾನು ಈಗಾಗಲೇ ಮಾರ್ಚ್ ಖಾತ್ರಿಪಡಿಸಿಕೊಂಡಿರುತ್ತೇನೆ. ತಾವುಗಳು ನನ್ನ ಕಳಕಳಿಯ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಿ ಮತ್ತೊಮ್ಮೆ ಉತ್ತರ ಪ್ರತಿಗೆ ಮೌಲ್ಯಮಾಪನ ಮಾಡಿ ನನಗೆ ಆದ ಅನ್ಯಾಯವನ್ನು ಇಲಾಖೆ ಪರೀಕ್ಷೆ ಮಂಡಳಿ ಸರಿಪಡಿಸಿಕೊಡಬೇಕೆಂದು ಕಳಕಳಿ. ಆ ಒಂದು ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಮಾಡಿ.
ಅಲ್ರಿ ಕೀ ಆನ್ಸರ್ಸ್
ಪ್ಲೀಸ್
ನಿಮ್ಮ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡಿರಲ್ಲ ನೀವು?
ಇದು ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಕ್ಸಾಮ್ ಆಗಿರೋದ್ರಿಂದ ಇದು
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಕ್ಸಾಮ್.
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಕ್ಸಾಮ್ ನಾರ್ಮಲಿ.
Why is it not published?
I have instructions, my lord, it is not. And reference to annexure K is, my lord, kindly appreciate, my lord, transparency and fairness on the part of corporation. They issued, my lord, answer sheet and also OMR sheet. If we could have sought together, my lord, along with even key answer also, there was no, my lord, impediment for the corporation to furnish.
22/8 ಗೆ ನಾನು ಕೇಳಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ.
No, it is in continuation of, my lord, this 22/8/2022 representation, by which time, my lord, the papers are shredded.
ಇದು ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ the general manager, departmental examination and public information officer of the Karnataka Power Transmission Corporation Limited and the member secretary of the departmental examination board of the said corporation are before this court assailing
before
the impugned order passed to the learned single judge in WP number 203/19 of 2022, dated 20th of September 2023.
Make one.
This is second writ petition ಇದು.
First, only one. May I take only 1 minute of the court, my lord, to only 1 minute of the court to refer to, my lord, the notification which is issued by the authority at page number 46, my lord, which is, my lord, calling for applications for providing answer scripts for the purpose of re-evaluation. February 2022, page number 46.
Calling for?
We can ask for Uttara Pratigala Marumole Mapanake. This is being done on payment of a cost. This we have applied, which I got additional marks also. Then thereafter it is only at the request of the petitioner the answer sheets are being provided.
Correct.
But at the same time, if I want to compare my answers which are
That you should have understood, you should have known it better, sir.
Then Madidin Sami, if I am given 1 day's time, I will produce the record. If
Angidre, there was no difficulty at all.
I had already sought for that key answers. I had already sought for those key answers.
When they gave only the answer scripts, why did you not ask for the key answers to
come? That's the representation. That's answer sheets bandmele representation. I have to compare the answers.
Sir, you should have known better. If they give me the answer scripts out from where I will compare, and you should know, you should have known.
I have sought for key answers and the answer sheets. They only give answer sheets. They do not provide key answers. Our representation.
See, there is nothing on record. You are going on making submissions like this.
This is because of the development which they are.
Next para. The first respondent herein was the petitioner who had approached the learned single judge seeking a writ of mandamus directing the appellant herein to furnish the key answers in respect of paper number 3, paper 3, in a departmental examination taken up by the first respondent herein. Full stop. It was contended by the first respondent that the appellants herein have refused to provide the key answers, although they have furnished the copy of the answer script, at the request of the first petitioner here, first respondent herein. Full stop. The learned single judge had issued a mandamus directing the appellants herein to provide key answers to the examination within an outer limit of 4 weeks. Full stop. After contempt petition was filed at the hands of the writ petitioner, this intra-court appeal has been filed by the appellants. Full stop. Next para. During the course of these proceedings, he had directed the appellants to furnish the key answers. Full stop. However, no, as stated in the statement of objections filed at the hands of the appellants herein before the learned single judge, an affidavit of the first appellant herein has been filed stating that in terms of the rules governing the maintenance and disposal of the answer scripts, question papers, and all other material pertaining to the departmental examination, namely Elder page number ಏನದು?
Page number 94 R2 or 92.
Order dated 18/10/2010. Order number KPTCL,
Yes.
KPTCL bar B 66 bar 10029 bar 2009-10, Bangalore dated 18/10/2010. The answer scripts are maintained only till 2 months after the furnishing of the supplementary results. Full stop. It is stated in the affidavit that the examination was held on
Results were announced on 3/2/2022 originally, and revaluation results on
results of the departmental examination were announced on 3/2/2022. And the results of the revaluation or supplementary results were announced on 9/5/2022. Full stop. In terms of the extant order, the answer scripts and all other material pertaining to the departmental examination were destroyed immediately after expiry of 2 months from the said date. Full stop. On the other hand, the first respondent herein made a requisition only on 22/8/2022 seeking copy of the key answers. Full stop. In that view of the matter, it is stated in the affidavit that since all material, including the key answers, were destroyed in terms of the extant rules guiding the maintenance and destruction of the examination material, and the requisition came from the first respondent herein only after all the material were destroyed, it is impossible for the appellants to furnish the requisite information. Full stop. Next para. Moreover, it is also pointed out that in terms of section 19 of the Right to Information Act, 2005, an endorsement was issued to the petitioner herein, clearly
page 87.
stating that
Page 87.
Page
87.
If the first respondent was aggrieved of the information provided or not satisfied with the information given, he may approach the appellate authority, namely the managing director, bracketally administration, who was the appellate authority, to consider such appeals under section 19. Bracket 1, of the Act, 2005. Full stop. Learned counsel for the appellant would therefore submit that the writ petition could not have been entertained, since there was an alternative efficacious remedy available for the petitioner. Full stop. Next para. For contra, learned counsel for the first respondent contends that along with this application seeking answer scripts, the first respondent herein had sought for the key answers also, but they were not furnished. Full stop. Thereafter, once the first respondent received copy of the answer script, he once again made a request on 22/8/2022 seeking copy of the key answers. Full stop. It was also pointed out that in their initial reply,
Annexure N, page number 87.
87. ಇದಲ್ಲ ಇದೇನಾ?
ಹೌದು, ಇದೇ ಒಂದೇ
ಅಲ್ಲ, it is
ಇದೇನಾ?
annexure N, it is after the representation, 15/10/2022.
ಇದು
ಇಷ್ಟೇನಾ? ಇದೆ ಇಷ್ಟೇ.
ಇದು ಒಂದೇ ಕೊಟ್ಟಿರೋದು
ಇದು ಒಂದೇ.
ಹೌದು.
In the reply dated 15/10/2022 at annexure N, the appellants herein did not state that the key answers were destroyed. Full stop. What was stated was that in terms of the judgment of the Honorable Supreme Court, it would not be permissible to provide the information sought by the first respondent here. Full stop. Next para. Having heard the learned counsel for the appellants, the learned counsel for the first respondent, and on perusing the petition papers, we find that the appellants have put forth all their grievance as to why it is not possible to furnish the key answers to the first respondent. Full stop. It is pleaded that in terms of the rules governing the maintenance and destruction of all material pertaining to the departmental examination, the answer scripts, question papers, and all material including the key answers have been destroyed immediately after expiry of 2 months from the date when the supplementary results were announced. Full stop. The supplementary results were announced on
9/5/2022.
9/5/2022. Full stop.
They are not supplementary, they are revaluation results.
Adene supplementary andre ಇಲ್ಲಿ supplementary exam ಅನ್ಕೊಂಡೆ ನಾನು. I never knew this was departmental inquiry. Examination. We thought it was some regular examination. The second application, second bada, the first respondent gave a representation on 22/8/2022 seeking key answers, which was beyond the period of 2 months from 9/5/2022. Full stop. In that view of the matter, we are constrained to accept the contentions of the appellants that they do not have the key answers which could be provided now to the first respondent here. Full stop. Next para. Consequently, the writ appeal is partly allowed. Stop. Starting early, 3 days in filing the appeal stands condoned. Partly allowed.
And at least one observation may be made. In future, whenever exams are held, my lord, key answers and OMR should be made available to the candidates. Because they do not disclose it.
Allah, see, our understanding is that key answers have to be published.
How? Madlebek.
See, it will be published in the website and all of you will be able to download them.
ಇಲ್ಲ ಇವ್ರು ಮಾಡೋದಿಲ್ಲ, ಜಿಸ್ಕಾಮ್ದವ್ರು ಮಾಡೋದಿಲ್ಲ.
ನೀವು ಅಲ್ಲಿ ಏನ್ ಅಲಿಗೇಷನ್ಸ್ ಮಾಡಿಲ್ವಲ್ಲ ನೀವು. You are only asking for a copy of the answer, key answers. Where have you made all this allegation? ಏನ್ ಮಾಡೋದು ಮತ್ತೆ? See, immediately after the results were announced, if you had filed a writ petition directly challenging the process of the examination conducted by them, then all these things could have been gone into. Even key answers prepare. ಅವ್ರು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಅದನ್ನ ಹೇಳಿದಾರೆ ಅವರು.
ನಾನು ರಿವಲ್ಯೂಷನ್ ಮಾಡ್ಕೊಂಡು
ಅದನ್ನ ಕಂಪೇರ್ ಮಾಡಿದ್ರೆ ನನಗೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಮಾರ್ಕ್ಸ್ ಬರ್ಬೇಕು ಅಂತ ಅವರು. He has stated, yes, I have prepared. ಅದ್ರ ಪ್ರಕಾರ ನನಗೆ ಇಷ್ಟು ಮಾರ್ಕ್ಸ್ ಬರ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. Having regard to the findings herein above, we accept the contention of the appellants that they do not have the key answers to the paper 3, departmental examination conducted by them during March
2022.
21 now.
Please.
21. And therefore, they are not, the appellants are not in a position to furnish the key answers to the said exam question paper at this point of time. Full stop. Next para. Ordered accordingly. Idrally contempt petition in view of this court allowing the writ appeal filed at the hands of the respondents in WA number 20048 of 2024. The contempt petition is dismissed.
Okay, great.
Aita.
Habeas corpus.
Writ of habeas corpus petition.
Yes.
Choice of family members ಅಂತ ಸೇರಿಸ್ಬಿಟ್ಟಿಲ್ಲ.
ಪ್ಯಾರಾ 3 ಅದರಲ್ಲಿ ಒಂದು ಇಡ್ತಾರೆ ಮತ್ತೆ. ಪ್ಯಾರಾ 3 ಆರ್ ಅಂತ ಯಾಕೆ ಹೇಳ್ತಿದ್ರಿ?
ಆರ್ ಚಾಯ್ಸ್ ಆಫ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅಂದ್ರೆ
ಅಕಿನ್ ಚಾಯ್ಸ್ ಅಥವಾ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಚಾಯ್ಸ್?
ಅದೇಂಗಾಗುತ್ತೆ? ಅದೇಂಗಾಗುತ್ತೆ?
As my lord pleases. If she says any liberty gives to us, we'll give the bail. If she says he is marrying someone,
Burkle.
One submission here.
Hmm.
Now, my lord, we have to proceed with the, my lord, according to the, my lord, 154 and medical test and, my lord, Panchanama, everything we have to do it. But that is the reason, my lord, for 1 week, my lord, lords will direct the keep in Bala Mandira, my lord, for 1 week. Because medical test, my lord, we have to do. If she goes home, my lord, we don't know what will happen. But that is the reason, my lord, for limited period, my lord, Bala Mandira letter. We will do all completion of proceedings, direct the Bala Mandira to send her, my lord, to the parents' house.
She was taken before the magistrate?
Not yet, my lord, not yet, because we have to produce before lordship only. Now, my lord, we have to go the, my lord, medical test, then only, my lord, folks are that will arise. What else?
This habeas corpus petition was filed by Srimati Kalpana, wife of Sri Buddhesh. ಅಲ್ಲ ಇವಾಗ ಏನ್ ಆಕ್ಷನ್ ತಗೋತಾರ ತಗೊಳ್ಳಿ That is not so nice. Alleging that her minor daughter has been kidnapped by respondents number 3 to 5 here. Stop. It was alleged that although a complaint was given to the station house officer of the second respondent, Mahila Police Station, Raichur, never
Also, may I permit you to pass on this report of the advisory committee?
Next
Court
matter.
of- ಅದೇ 41 ಗುಂಡಾ ಆಕ್ಟ್ದಲ್ಲಿ ಡಿಟೆನ್ಷನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಲಾಡ್ ದಟ್ ಇಸ್ ದಿ ಅಡ್ವೈಸರಿ ರಿಪೋರ್ಟ್ ಮಲಾಡ್
ಮೊನ್ನೆ ನೀವು
ಮೊನ್ನೆ
ಹಾ
ಆಲ್ರೆಡಿ ಟೋಟಲ್ 8 ಕೇಸಸ್ ಇದೆ ಸರ್. ಅದ್ರಲ್ಲಿ 8 ಕೇಸ್ನಲ್ಲಿ 6 ಕೇಸ್ ಅಕ್ವಿಟ್ ಆಗಿದ್ದಾನೆ. ಇನ್ನು 1 ಕೇಸ್ ಇದೆ, ಅದನ್ನು ಆಲ್ಮೋಸ್ಟ್ ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ. ಸೊ ರಿಮೈನಿಂಗ್ ಓನ್ಲಿ 1 ಕೇಸ್ ಮೈ ಲಾರ್ಡ್. ಇನ್ ದಟ್ 1 ಕೇಸ್ ಓನ್ಲಿ
serial number
ಬ್ಯಾಕ್
41.
ಸೈಡ್
yes my lord.
ಕೈಂಡ್ಲಿ ಸಿ ದ ಬ್ಯಾಕ್ ಸೈಡ್ ಮಲಾಡ್.
ಆಯ್ತು.
ಅಲ್ಲ ಬ್ಯಾಕ್ ಸೈಡ್
We will
Because he is
consider.
only having a
for that is the reason only I
father is having paralysis patient my lord.
ನಾನೇ ಇದ್ನಾ?
ಹೌದು ಹೌದು ಅದಕ್ಕೆ ತಾವು ತೋರಿಸಿ.
Father of the petitioner is a paralysis person and he is having 4 sisters my lord. The question of public peace doesn't arise by the petitioner when he is under custody my lord since from 2017
We
onwards.
will do one thing. I am also a party to this. The advisory board order, I am also a party. And we will constitute some other bench. Huh?
Yes.
ಬರ್ಕೊಳ್ಳಿ. Since one of us, RDJ, was a part of the advisory board under the Gunda Act. While considering the order of detention, comma, a bench may be constituted a different bench may be constituted to consider the writ petition. Appropriate orders in that regard may be secured at the hands of the hands of Honorable the Chief Justice.
ಕೊಡ್ಬೇಡ್ರಿ ಅದು
ಇಲ್ಲ
So, ಇದು ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್ ರಿಪೋರ್ಟ್ ಅದು.